Yes, order will be there if they are taken adjournment.
Hmm?
Yesterday,
Daily orders will be there.
where
Might be there.
because last order it is not there. Last date when they are taken, that is not there.
Not there. Huh? He had taken. Do you check with him?
Yeah, he told me they are taken 2 weeks time.
Check it out. If not, then ask him what to. Why we want? We just inform the client already, no?
Answer is asking.
Daily orders. I'll check in sometime. So website.
Because as of now, no update is there.
No update.
I checked.
ಸರ್ಗೆ ಇರ್ಬೋದು ಅದ್ರಲ್ಲಿ ಇದು ಕ್ಯಾರೆಕ್ಟರ್
One 84th page, 212, 213, 242, 241. Okay. 40. Idiot.
someone put us. Just like if we are working together, you just mention wherever you are going for how much time.
Today he said, sent, no?
No,
No, no, Bharat asking for it. He asked us, actually. Gaurav. He asked, but
I think because he is not the way like he takes messages and all now. He's not liking it.
yeah, till he gets another job, I guess.
And his post and all, so that he's looking for somewhere.
He's putting poster.
No, I see his like and all post and all. Directly you comment no, interested and all.
Long back.
This and all, they don't even post because they don't even pass order and all. Madras High Court.
Today it's there. Monday is there. Wednesday is there. Tuesday, I don't know.
Therefore, it held that issuance of a 15 days clear notice is mandatory. Full stop. The question whether Rule 3(2) of the Rules 1994 warranting a meeting to be held within 30 days from the date of receipt of a representation from the members of the Panchayat is directory or mandatory is no longer res integra in view of the judgment of the division bench of this court in Writ Appeal 5159-5160 of 1990, where it was held, double inverted comma, where it was held, double inverted comma. In this case, there is no dispute that the meeting was not held within 30 days from the date of receipt of the notice of no confidence by the Assistant Commissioner, and it was held after the expiry of 30 days. Full stop. Therefore, the meeting is in violation of the mandatory requirement of Sub-Rule 2 of Rule 3 of the rules, and the same is not valid in terms of Section 49 and 50 of the Act and Rule 3(2) of the rules, inverted comma, close. The division bench also held that, after referring to the judgment of the coordinate bench of this court in Muniappa versus State of Karnataka and others, and set aside the said judgment and held that the proviso and held that Rule 3(2) of the rules employs the word shall, and therefore the legislative intent is to ensure that the Assistant Commissioner convenes a meeting without loss of much time, and therefore was mandatory. And therefore compliance of the said provision is mandatory. Full stop. In the instant case, the notice was issued by the respondent number 3 on 30th of December 2024. Full stop. Even if the date of notice is excluded, the meeting that is scheduled on 21/1/2025 is beyond the 30 days and hence violated Rule 3(2) of the Rules 1994. In that view of the matter, full stop. The contention of the learned counsel for the private respondents that the date of the meeting has to be excluded, cannot be accepted in view of the language employed in Rule 3(2), which mandate that the meeting has to be held within 30 days from the date of receipt of the representation in form number 1, meaning thereby that the date of the meeting cannot be excluded, but The 30th day from the date of receipt of the representation should be the day within which the meeting is held. Full stop. The other contention of the learned counsel for the respondents that the private respondents cannot be put on the guillotine, GUILLOTINE, for a mistake committed by the respondent number 3 can also not be considered, as it is the post of Adhyaksha which is at stake, and the petitioner is entitled to challenge the notice issued to her on the ground that the same violates a statutory rule. Full stop. It is now well settled in law that if a thing has to be done in a particular manner, it has to be done in that manner alone or not at all. Full stop. Since the notice violated Rule 3.2 of the Rules 1994, the same is liable to be quashed. Consequently, this writ petition is allowed. The impugned notice issued by the respondent number 3 is set aside. However, it is open for the private respondents to take fresh steps in accordance with law.
My liberty may be reserved to submit the representation today, my lord. Today
itself.
That should be clarified, because they should not. The assistant commissioner will say, we'll wait for the order.
Liberty is, I'll release it by evening. Release ಮಾಡ್ತೀನಿ.
ಅವ್ರು ಮತ್ತೆ ಇಲ್ಲ judgment certified copy ಬರೋವರೆಗೂ ನಾವು ಏನು ಮಾಡಲ್ಲ.
ಸಾಯಂಕಾಲದೊಳಗೆ release ಮಾಡ್ತೀನಿ. Today evening I'll release it.
And if your lordship could add a word that the assistant commissioner shall now, my lord, take care that procedure within 30 days has to be.
If a fresh representation in form number 1 is.
Because she will be, my lord, the assistant commissioner office
Form
is getting
number 1
spot free every time.
Submitted by the members in the manner provided under Rule 3.1 of the Rules 1994. The respondent number 3 shall proceed strictly in accordance with the Rule 3.2 of the Rules 1994. Henceforth, please avoid. I'm telling you seriously. Henceforth, please avoid. Now, if you have a point, you please argue. If you have a point, please argue.
Yes.
You also are entitled to lose your temper when the court is committing a mistake. You are entitled to do that. But don't ridicule a court. Don't ridicule a court when you are in the wrong, when you do not know the law. Don't ridicule the court.
Yesterday I submitted 3 rulings and I said it, and I needed time because when the time is given,
You did not.
I have get with all the preparations today.
Did not understand what was running in the mind of the court.
I understood it, but I could not find it yesterday within 1 hour.
So therefore, don't lose your cool in the
If
court.
that was not done, this court would have passed the wrong. Today, the order is passed
Please
as per
check-
the division bench.
Please check the earlier judgment.
Yes, my lord. That even with that, I could not submit that because that was not released.
Please check the earlier judgment.
2001
is already
wherein
quoted.
I am.
This judgment, division bench judgment is already quoted in that judgment. ನೀವು ಹೇಳಿಲ್ಲ, ನಾನು ಬರ್ದಿದ್ದೀನಿ.
ಸರ್ ಅದು ರಿಲೀಸ್ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ.
So
ನಾನು
therefore,
ಅದನ್ನೇ ನಿನ್ನೆ ಹಿಡಿದು ನೋಡ್ತಾ ಇದ್ದೆ.
ಗೊತ್ತಿತ್ತು, ಅದಕ್ಕೆ ನಿಮ್ಗೆ ಹೇಳಿದ್ದು ಸ್ವಲ್ಪ
Yes.
ನೋಡ್ರಿ ಅಂತ ಹೇಳಿದ್ದು. And you lost your cool. Don't lose this.
Yes.
Don't lose your cool in the court and don't ridicule the judge.
Since I was correct, that was my submission in answer to it. That's it, my lord.
Be correct,
Again and
sir.
again, I have submitted the same thing.
Might be correct, but when there are 2 judgments on the same point, what should be done?
Yes,
When there are 2 judgments on the same point, what should be done?
that's clear to do.
So therefore, I asked you to find out a judgment because I knew that there's a judgment. Therefore, I asked you to find out a judgment where
Whether it is
1998 judgment is
mandatory
different.
or.
ಅದಕ್ಕೆ ಹೇಳಿದ್ ನಿಮ್ಗೆ. And you did not take it. ಇರ್ಬೋದೇನೋ ಅಂತ.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಅದು ನಿನ್ನೆ ಸಿಗ್ಲಿಲ್ಲ ಇವತ್ತು.
I knew it, therefore I told you. And you lost, I don't know. Yes, next. And mistake. Yes, what is the mistake?
We have.
we not
Now.
ನಾವು ಫೈಲ್ ಇದ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ ಅದು
ಯಾರು ಇದು?
ಆಫೀಸ್ನವ್ರು ಹಾಕಿರ್ಬೋದು ಸ್ವಾಮಿ.
ಏನಕ್ಕೆ ಹಾಕಿರೋದು? Being spoken to ಏನು? ಕರ್ಸಿದೇನು ಕೇಳಿ.
ಆಯ್ತು ಆಫೀಸ್ನವ್ರೆ.
ನೋಡಿ ಫೈಲ್ ಮೇಡಮ್. Anil Rathod. 1 week time is granted to do the needful. Password. Niva Chimkor. Madam, please amend the cost statement.
During the course of the day.
Ma?
Course of the day.
Madi. You have not done it for the last so many years. Please do it.
File
Memo is
memo for
filed.
withdrawal of the deposit,
Petition.
writ petition,
You
not
have-
the,
Oh, the petition is dismissed as.
Yes, and also the petitioner is signed in the memo notes, that is,
Aye.
yes.
My lord, in this case, my lord, there was a
Affidavit is
direction
not
of
filed by
this.
the medical board.
My lord, it
Yes,
may
ma'am.
be taken Monday, I'll secure report, my lord,
Why medical board?
medical report. my
Now
lord.
kindly see the order sheet. Since 22/5/2023, the court is repeatedly giving direction to the respondent to be present before the medical board. In spite of the specific direction, respondent number 6 has failed to appear before the medical board.
Appeared, my lord.
Even on the last time also,
Yeah. Therefore, respond six.
even
What is
on
my
the
lord?
last time also, my lord.
Have you appeared or not?
My lord.
You appeared. When? ಯಾವಾಗ appear ಆದ್ರಿ? board ಮುಂದೆ?
23/2/2024.
ಯಾವಾಗ appear ಆದ್ರಿ?
23/2/2024.
23 to 2000?
24.
ಒಂದ್ ವರ್ಷ ಆದ್ರೆ ಯಾಕೆ ಇದ್ ಮಾಡಿಲ್ಲ?
My lord, medical report given to CDPO, my lord. I will collect, it may be taken Monday or meanwhile, I'll collect my.
The learned AGA seeks time to secure instructions regarding the report of the medical board. This list on?
Monday, ma'am.
Yes. ಯಾವ್ದು ಇದೆ? PDO ದ ಇದು?
My lord, Anganwadi.
Yes, Anganwadi.
ಹಾ.
ಇದು 7,53,000 ಇದ್ದಿದ್ದು 5 is missing, ಅದು ಒಂದು ಕರೆಕ್ಟ್. 73,600 ಆಗಿದೆ, 753,600 ಆಗ್ಬೇಕು. ಫ್ಲಾಗ್ ಹಾಕಿ.
Flag ಹಾಕಿ.
ಕೊಡಿ.
ಪ್ಯಾರಾಗ್ರಾಫ್.
Number ಇದು ನೋಡಿ, 2 ನಲ್ಲಿ in paragraph number 15 of the judgment,
Monday.
comma, instead of mentioning at line 5, instead of mentioning the compensation is 7,53,000, it is mentioned as 7,03,600.
ಅದು 73,600, zero ಇಲ್ಲ.
73,600. Therefore, the same shall be read as 7,53,600.
Please.
Yes. This order shall be read in conjunction with the order dated soon.
Please.
Yes, Mr. Chak Shetty.
I was waiting for the petition. My response 1 to 4 are the government authority. Your artist may kindly direct the government advocate to take notice, man.
1 to 4, please.
ARP, 1 to 3, man. 1 to 3 government.
Or KDB, special land acquisition of KDB, man. Yes.
Yes. Yes, ma'am. I ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ ಅದನ್ನು ಒಮ್ಮೆ. Yes. Yes. ma'am. ಇಲ್ಲೇ
On behalf of Shivaputra, I am. Put this, that will rectify, yes, please do.
Your Lordship. Lordship, yes, I am appearing for Nitesh Padial. We have issued a NOC, Your Lordship, but our name has not been reflected. A. Gunnapur has filed wakalat now. Yes, but our name has to be deleted in. Yes. No, we have issued a NOC, Your Lordship. Now A. Gunnapur has filed a fresh wakalat in that. Yes. Lordship, Nitesh Padial, delete the name of Nitesh Padial. Yes. Bless.
Lords, in this case, my lords, I am filed application seeking to conduct the practical examination by appointing the constituting the coordinate committee, my lords. What happened, my lord, in this case? My colleges are recognized by state as well as the central, my lord. I produce A and B series.
A and B.
Yes, my lords. It is recognized. The colleges are recognized. When they issued the notification for collecting the examination fees, my lord, by issuing the notification on 24/4/2023, you have filed the application and they have collected all the fees, my lord, for practical as well as theory examination. Then they have not generated the hall tickets, my lord. They requested why they not generated the hall ticket. Then it is found that in verification, in this website verification, the institutions are not, the shortage of attendance, they have not generated the hall tickets. And therefore, approach this honorable court, my lord. This honorable court, my lord, granted an interim order produced along with the IA, my lords,
But the
dated
attendance shortage is what can be done?
at the time of,
Whether there is attendance shortage or not.
that is attendance is not shortage. They have not conducted any inspection. They have not visited our institution. Simply they are, in the website, we found that there is shortage of attendance.
Yes.
Therefore, approach this court,
Lord.
my lord.
I have already statement of objection filed. Kindly see para 5, my lord.
Let me come.
Yes.
My lord, I approach this court, my lord. This honorable court, after verifying the original register, attendance register from the institution at the time of granting the interim order, my lord, in page 34, my lord, that is, sorry, first interim order, that is in page sorry, in page Annexure V is the first interim order, my lord.
Annexure?
V, additional document act. The in page 19 and 20, my lord, that is operative portion of the interim order. In my eye.
Yes.
The renew of the submission made by the learned counsel for so and so. Exams internal practical and theory of first year DED course in respect of students of petitioner colleges is scheduled to be commenced from 11/12/2023 as per Annexure N and P. Proceed past the following order. Students of the petition number 5 to 294 shall permitted to take up the upper side examination upon payment of examination fees and late fees, if any, to the college. Respondent 4 shall issue admit card and shall ticket so and so before 9/12/2023. However, results of the exam shall not be declared and announced without leave of the permission of this court. Accordingly, they have appeared, my lord. Results were not announced. Again, I filed one more application when they issue one more exam notification for the next examinations. scheduled on 27/5/2024, that this honorable court granted an interim order again in phase 34, my lord, that is operative portion, 34 and 35 in the said IA. Again, my lord, this honorable court directed on the respondent to announce the result and permitting the students who are unsuccessful students, they are appeared. Then, my lord, the theory exams were conducted and they have appeared, and the results were, first year results were announced and they appeared for second year examination also. Now they are not conducting the practical examinations.
But you said that this court had summoned the attendance register.
At the end, it is not in record, but I produced the appeared and produced the original records. After verifying that original register only, attendance register only, they have given the permission to attend, appear for their examinations.
Nothing mentioned in the order.
Yes, it is not mentioned, but I have produced that. After verifying those records only, the honorable court granted an interim order.
Yeah.
Permanent. Now, my lord, first time they have conducted the practical exams, that was not considered. Therefore, now I filed this application. Direct the respondent the diet to conduct the practical examination and by constituting the committee. Unless that practical examinations are conducted, my lord, my entire efforts will not, the students will suffer. They will not declare when they declare results, they will fail.
Correct, but then let us dispose of the writ petition, this or the other.
I am requesting, my lord, otherwise
Take an order on merits.
Yes.
Our examination ತಗೊಂಡು ಮುಂದೆ pass ಆಗ್ತಾರೋ ಇಲ್ವೋ, should they wait?
Theory exams, first year is already declared as per this direction of this honorable court, my lord. Again, they appear for second year examination.
Subject to the result of the writ petition, madam.
If they,
For your case ಗೆದ್ಬಿಡಿ, you succeed in the writ petition, you take all the benefits.
yes, my lord, we are on merit, my lord, if permits, my lord, I will bring all the attendance register, my lord, for verification,
when do you
personal
want it?
attendance. Next week, any date, my lord.
Current counsel for the petitioner seeks time. List on date to address arguments on the main matter. List on
29 ಹಾಕಿದೆ. Sorry. Yes, sir.
list on date. Yes.
If my lord's permits, I'll bring all the attendance registers.
Do whatever you want, but take an order on merits.
Yes, ma'am.
Because the students cannot be kept undecided whether to pursue it or not to pursue it. ಆಮೇಲೆ 4 ವರ್ಷ ಆದ್ಮೇಲೆ writ petition dismiss ಆದ್ರೆ then what should happen to them?
In identical circumstances, the honorable court earlier
You argue on merits and take an order.
directed the diet to conduct a practical examination there.
You argue on merits. 30th or 29th? 30th.
Please.
Ravi B. Patil. Yes, R6 and
These are
R7.
respondent 6 and 7 is now.
6 and 7.
House.
Babu and Lalu.
House.
Ah,
I taken,
Take out notice. 1 week
I'll
time is
take a
granted
fresh
to-
notice. Interim order may be
time
granted.
is granted to do the needful.
Interim order.
Interim order granted at least extend till the next date. A memo is filed to withdraw the writ petition. In view of the memo, the petition is dismissed as withdrawn. Number 13, Ravi Patil. Pass over.
Amended cost title is ready. I'll file in the.
Amend the cost title first.
Please, serial number 13.
Pass over. ನೀವ್ಯಾರಿಗೆ?
I'm respondent 7, my lord.
Mohammed Sharif.
Yes, sir.
Please wait. There's some amendment that he has to make. Let him make the amendment.
Okay. Thanks.
My lord. Needful is done, my lord. Hands up.
Learned counsel for the petitioner submits that he has taken the hand summons in respect of the proposed respondent number 5.
I have furnished acknowledgement and my lord
ಮಾಡಿದ್ದೀರಾ?
process. ಮಾಡಿದ್ದೀನಿ ಇವಾಗ.
Of having served.
No, no, not, hand summons is not yet taken.
ಮತ್ತೆ ಯಾವಾಗ ತಗೋತೀರಿ?
I'll take my lord, it may be reissued.
Learned counsel for the petitioner seeks time to accept the hand summons for service on the proposed respondent number 5. 1 week time is granted to do so. In the meanwhile, office is directed to reissue the hand summons. Yes.
Great.
One week time is granted to do the needful. Interim order idya? Geeta Anna Rao. R7, 9 to 12.
My lords, in this matter, I would like to submit that the remaining respondents are not formally objecting for the petitioner's mutation. I am seeking dispensation
Want
of notice.
dispensation, file a memo.
Yes, my lords.
Carefully. Learned counsel for the petitioners filed a memo seeking dispensation of notice
For 7, 9 and 12, my
7,
lords.
9 to 12.
Yes, my lord.
So in view of the memo, notice to the said respondents is dispensed at the request and risk of the petitioner. What about objection 19 and 24?
My lords, in that actually certified copy, they had asked for those certified copies. I have filed the documents before the other appellate authorities. Therefore, petitioner does not have them.
Objection serial number 19 is overruled.
And this 24, my lords, Zaira B, she has expired during the trial proceedings and her legal heirs are already on record. Respondent number
Also
4 to 12.
contends that the legal heirs of Jaira B are already on record in this writ petition. What about Mehtab?
Four to 12, all are legal heirs, my lords.
Whether Mehtab legal heirs are already on record?
Yes, my lords.
Jaira B and Mehtab are already on record. Huh? He contends that the legal heirs of Jaira B and Mehtab are already on record and therefore there is no need record full stop. The office objection serial number 19 and 24 is overruled by accepting the submission of the learned counsel
My
for the
lords,
petition.
respondent number contesting respondent numbers have been served notice. They are not represented by an
Why
ID.
do you worry? Please argue the matter on.
Yes, my lords, in this matter, the petitioners had purchased the
We'll fix a date, madam. What date you want? On date,
third,
list on so and so. The Shivanan
28,
Patil.
my lords, 30th, my lords, 30th. Next date after 28th, I'm not there. Obliged.
Shivanan Patil.
In this case, your lordship, on the last date of hearing, your lordships have directed
The office objection at serial number 27 is overruled by accepting the submission of the learned counsel for the petitioner. Yes.
Yes, my lord. In this matter, last time,
Ah.
your lordship had heard this matter.
Ah.
25 inquiry that was already once completed.
Ah.
Another 25 inquiry has been ordered.
Ah.
So your lordship had asked the state to decide upon what is the
status
result
report.
of that report.
Yes. First report.
Yes.
Result of the
First,
first report.
First inquiry.
We have sent letter, we have not received any.
In this case, your lordships, the enquiry.
ಯಾಕೆ ಮತ್ತೆ ಡೇಟ್ ತಗೋತಾರೆ ಶಾರ್ಟ್ ಡೇಟ್ if you can't get the information?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ, enquiry report which has been submitted by the enquiry officer, your lordships, the issues which are concerned, your lordships, he has taken note that your lordships, he was not benefited with the documents. For that reason, your lordships, he has submitted the report. In fact, under section 25, he has a power to examine all the records of the society.
That is right. So, but then what happened to the prior inquiry report? Has it taken a decision on the?
Nothing, no decision has been taken, your lordships. It is because of
That is not
conduct of the enquiry officer, noticing that your lordships, the joint registrar has issued another enquiry, your lordships.
How can they do it? First inquiry has to culminate in something.
That has to be
Either
set aside
dropping-
first.
one ನಿಮಿಷ ತಡ್ರಿ. Either dropping the inquiry or proceeding with the inquiry and pass appropriate orders. Before the inquiry, earlier inquiry is accepted or rejected. How can you institute one more inquiry?
In the enquiry report, if your lordships peruse, your lordships, there is nothing in that. He has stated that the allegations which are made by the complainant, that is the present contesting respondent, are not, your lordships, considered because of lack of documents submitted by both the parties. In
Yeah,
fact,
get the instructions. Learn AGS seeks time to comply the order dated
8/1/2025.
8/1/2025. List on
2 weeks time. Interim order may be extended.
interim order granted is extended till the next day. Yes. Harshavardhan.
Senior counsel is appearing through VC lot.
Yes.
Please, ma'am. Good.
An execution.
Who are the decree holders in this case?
Decree holders are, my lord, respondent number 2 to 9, my lord.
Your lordships, I undertake to file wakalat on behalf of them.
Respondents 2 to 9 are the decree holders. Correct?
Please, my lord. Respondent number 1 is the assignee of the decree holder.
Who are the JDRs?
JDRs 10 to 31.
Yes.
Or 2 to 9, your lordships, I'll undertake to file wakalat.
2 to 9.
Yes.
You are for R1.
R1 lordship.
Mr. Ganesh S. Kalaburagi undertakes to file undertakes to appear for respondents 2 to 9. Yes.
I will be assisting your lordships for the advocate, Mr. Harshavardhan, for respondent number 1.
Yes, please.
So,
Yes, Mr. Correct.
please, my lord. My lord, this execution petition, I will come to the point thereafter. If required, I will give the other details. This execution petition was filed, and my lord, when it was going on, my lord, the decree holders files an application, impleading application to implead the first petitioner herein.
So,
As
please come to paragraph number 2 of your petition.
2, my lord.
Para 2 of your petition.
That a compromise decree set had passed on 25/2/15 between respondent number 2 to 8 and 1 late Mahbub Saab in RSA number so and so by this honorable court as per joint memo.
As per the decree, the response 2 to 9 were to execute a registered sale deed in favor of Mr. Mahbub Saab.
Please, ma'am.
But you said response 2 to 9 are the decree holders.
May I, my lords, explain?
To execute a registered sale deed to an extent of
Now, who are the decree holders in this, in the,
decree holders are 2 to 9 only, ma'am. 2 to 9.
they are the decree holders?
Yes.
And they are supposed to execute the sale deed in favor of this Mahbub Saab.
Allala. Judgment debtors 10 to 31, they were supposed to execute the ಅದ್ರಾಗ ಒಬ್ರು ಡೆತ್ ಆಗಿದ್ದಾರೆ, ಹಿಂಗಾಗಿ ಇವ್ರು 31 ಮೆಂಬರ್ಸ್ ಆಗಿದ್ದಾರೆ.
ಎಲ್ಲ ಕನ್ಫ್ಯೂಸ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ರಿ ನೀವು. ನರೇಶನ್ ಅಲ್ಲಿ ತುಂಬಾ ತಪ್ಪು ಮಾಡಿದಿರಿ. You say respondents 2 to 9 were supposed to execute a sale deed in favor of Mr. Mahbub Saab. ನೀವೇ ಹಿಂಗ್ ತಪ್ಪು ಮಾಡಿದ್ರೆ ಇನ್ನ ಬೇರೆಯವ್ರು ಹಿಂಗೆ?
ಇಲ್ಲ, ಅದು ಏನಾಯ್ತಂದ್ರೆ ನಾ ಹೇಳ್ತೀನಿ, ಸಂಡೇ ದಿವಸ ಬಂದ್ರು ಸಾಯಂಕಾಲ, ಅದು ಸೇಲ್ ಡೀಡ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ವಾರಂಟ್ ಇಶ್ಯೂ ಆಗ್ಯದ ಅಂತ ತಿಳಿದು ಡೈರೆಕ್ಟ್ ಡಿಕ್ಟೇಷನ್ ಕೊಟ್ಟು ಸ್ವಲ್ಪ ಚೆಕ್ ಮಾಡ್ಲಾರ್ದೆ ಹಾಕಿನಿ, ಅರ್ಜೆಂಟ್ ಇತ್ತು.
ಊಟ ಮಾಡಿದ್ಮೇಲೆ ಡಿಕ್ಟೇಷನ್ ಕೊಟ್ರ? ಊಟ ಮಾಡಾದ್ಮೇಲೆ ಡಿಕ್ಟೇಷನ್?
ಇಲ್ಲ, ನಾನು ಚೆಕ್ ಮಾಡಿಲ್ಲ ಅದು. ಯಾಕಂದ್ರೆ ವಿ ಆರ್ ಇನ್ ವೆರಿ ಹರಿ, ನನ್ಗೆ ಆಗಂಗಿಲ್ಲಪ್ಪ ಅಂತ ತಿಳಿದ ಅಂದ್ರೂ ಅವ್ರು ಬಿಡ್ಲಿಲ್ಲ. ಅದಕ್ಕೆ ಯಾಕಂದ್ರೆ ಶನಿವಾರ ಸಂಜೆ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದಾರೆ, ಕಾಪಿ ತಗೊಂಡು.
ನಿಮ್ಗೆ ಯಾರು ಬರ್ಕೊಟ್ಟಿದ್ ಸೇಲ್ ಡೀಡು?
ನಮಗೆ ಅವರೇ ಡಿಕ್ರಿ ಜಜ್ಮೆಂಟ್ ಡೇಟರ್ಸ್.
Judgment debtors, they sold it to you.
Please, on by way of a registered sale deed, my lord.
ಯಾವಾಗ?
My lord, that is 29/6/24.
When was the application filed to implead you?
Pardon, my lord?
When was the application filed to implead you?
To implead me, my lord. That was, my lord, on 24/9/2024.
24/9/24.
Yes, my lord.
And when was the date fixed for consideration of the application for impleading?
ಅದು ಏನಾಯ್ತು, that was fixed on 18th of January 25 only. ಅವತ್ತೇ ಅಪಿಯರೆನ್ಸ್, ಅವತ್ತೇ ಎಲ್ಲ ಆರ್ಡರ್ ಆಗಿದೆ.
Yes.
So, my lord, thereafter what happened, my lord? This first petitioner has sold the land to second petitioner and one Sangappa. That was sold on, my lord, December, my lord, in December 2024, my lord. Thereafter, my lord, the JDRs filed impleading application to implead the second petitioner and said Sangappa as JDRs 25 and 26.
JDS file ಮಾಡಿದ್ದ decree orders file ಮಾಡಿದ್ದ
Decree orders, madam.
decree orders filed the
Decree
application.
orders, yes, yes, yes. These two applications, my lord, notices were served on us to giving the date as 18th January 25 for our appearance.
Yes.
My lord, on that day, petitioner number 2 and that Sangappa filed wakalat through an advocate, my lord. A separate wakalat was given by the petitioner number 1 to the same advocate to file it separately. But my lord, unfortunately, what happened? The advocate concerned didn't come to the court. And my lord, he sent his junior and wakalat for petitioner number 2 and that Sangappa was filed. Then, my lord, the court, my lord, the stage was for my appearance and to consideration of my addition as JDR. On that, it was a stage. The court below, my lord, passes an order of issuing the commission warrant.
Your
Without
application to implead you was allowed.
no, no orders are passed. We have not brought on record. No opportunity was given to us to file our objections, and the impugned order is passed.
Yes.
So, well,
Yes, Mr. Senior Counsel.
My lords, may I make this submission? This is a case where the compromise has been effected before this honorable court. As per the compromise, my lords, the decree is passed in favor of the plaintiff, one Mahbub Saab, who assigns the decree by way of a registered assignment in favor of the respondent number 1. The respondents 2 to 9 are the LRs of that original decree holder who passed away after the assignment.
Yes.
Now, my lords, the judgment debtors who are required to execute the sale deed as per the compromise decree, they execute a power of attorney. The power of attorney holder, my lords, taking undue advantage of his agency, executes a sale deed during the pendency. It's a lis pendens execution of a sale deed in his own favor. That's the first mischief that he commits.
Who is the power
And
of
then
attorney?
Mohammad Salim, son of Babu Saab Janwekar.
Whether he is a respondent in the case.
no, he is the first petitioner. First petitioner.
Mohammad Salim.
The list of documents is filed, my lords, before the executing court, producing the power of attorney copy, the sale deeds, the RTCs and all subsequent documents also. Now, this Mohammad Salim is the one, my lords, who gets the power of attorney from the judgment debtor during pendency. He gets executed the sale deed in his favor stealthily without the knowledge of the judgment debtor themselves, and then gets his name mutated in the revenue record. At that point, they come to know that there is some mischief played by him.
Yes.
So before they could implead him, my lords, he executes a sale deed again stealthily using an earlier RTC, though we had brought before the revenue officers the pendency of the case. So he takes a RTC of an earlier period, and using that document, he executes a sale deed in favor of the petitioner number 2.
No, but did you file an application to bring these people on record?
Yes, no, I have made an application to bring these people on record, not for the purpose of execution of the sale deed in my favor. It was because the Bhumi website does not permit the execution of a sale deed by the judgment debtors in my favor, even if there is a decree of the court. So these persons, my lords, will have to be formally a part of the execution. Otherwise, my lords, they are not required at all.
Yes.
Now, my lords, the objections raised by these purchasers is that, see, there is a violation of Order 21, Rule 32. I should have first sought for civil imprisonment of the judgment debtor. This, my lords, is not the locus standi of these persons. My lords. They cannot say what is the procedural impropriety in the execution proceedings.
Yes.
Mainly, my lords, what is the other argument, substantive argument is that they want to say they are bona fide purchasers. In the sale deed, there is a mention of the pendency of the proceedings.
Yes.
And they want to say that they're bona fide purchasers. Secondly, my lords, bona fide purchaser is not a plea available at all to a person who is a purchaser.
He is on a different aspect. He says that you have filed an application to implead them.
Correct.
And the date was scheduled on 18/1/25.
Yes, my lord.
And on the same day, the court has issued a warrant to execute the sale deed.
My lord, kindly see the order sheet, which is starting from page 41. 18/1/2025 order sheet is at page 43. Before that, my lords, 14/2/2024 issue notice to JDR 1 to 23 PF paid. 8/1/25 case is advanced. Advocate for decree holder has filed application under order 7 rule 26. IA number 7 under 26 rule 10 of CPC. Then was on 18/1 VSS advocate filed wakalatnama for proposed JDRs 25 and 26.
Yes.
JDR
8/1/25, the suit was advanced.
Yes.
So when were the proposed JDRs 25 and 26 supposed to appear?
18/1/2025, I will read the entire order sheet. Advocate for DHR has filed a memo along with Kannada Daily Newspaper. Perused the memo, satisfied and accepted. Notice to propose JDR 24 served by way of paper publication. Proposed JDR number 24 called out absent. One JDR is absent. Objection to IA 7 is taken as not filed. Counsel for decree holder has filed IA 7 under 26 rule 10 of CPC, and this was filed already on the 8th of January. And prays to appointment of court commissioner as an advocate to execute sale deed in favor of decree holder. I have heard and perused IA 7 filed by decree holder. Reasons assigned in the affidavit are satisfactory to meet the ends of justice and equity. It is necessary to allow the application. Therefore, IA 7 filed by decree holder under 26 rule 10 is hereby allowed. Consequently, Sri so and so advocate is appointed as court commissioner to execute a sale deed in favor of decree holder as per the order passed by Honorable High Court of Karnataka in RSA number 7247 of 2012. It is perused that there is no appeal judgment and decree passed by Honorable High Court and produced the same before this court.
No, but what happened to JDR number 25 and 26? What happened to them?
First sentence.
ಅಲ್ಲಿ ಫಸ್ಟ್ ಗೆ ಅಪೇರ್ ಆಗಿದ್ದಾರೆ ಆನ್
ವಕಾಲತ್ ಹಾಕಿದ್ರು.
ಹೌದು.
ವಕಾಲತ್ ಹಾಕಿದ್ರು, whether that application was allowed or not.
Nothing, they are not, that is not forthcoming here. IA number 7 under 26 rule 10 is a separate application where they JDR number 25, 26 or the petitioners before your lordships are not required to join the execution of the sale deed at all.
No, but then why did you file the application?
The application is only filed to, my lords, bring to the notice of the execution court that for the purpose of subsequent recovery of possession and other things, and also especially because the RTC now shows the name of these persons, I have to my lords, show to the executive
Then
court.
they must have been impleaded in the proceedings before sale deed is issued. Warrant is issued to execute the sale deed.
Warrant is not against them, my lords. May kindly permit me to say this.
May not be against them, but in case if there's subsequent purchaser,
yes,
should be the.
But there are two judgments of the Honorable Supreme Court, my lords, which say that, my lords, if there is a subsequent purchaser, these are purchasers list pendants, my lords, section 52 of the TP Act will apply.
No doubt.
They cannot take the plea of bona fide purchase because they are aware about the proceedings.
Then why did you file an application to bring
That
them
is,
on
that is, my lord, that I may say, my lords, it might be an ill-conceived advice given to the litigant to file such an application. They were not required. They were not required, but then that will not stop the execution of the decree. They have no locus standi now to say that, see, my lord, for a moment, if the petitioners herein want to say that they have an independent right. If the petitioners want to say that they have an independent right in the property, it is for them to agitate their rights. The remedy is under maybe under 2197 or under any other. They can agitate their, my lords, rights if at all they have any. In my understanding, they have no rights because section 52 is applicable.
Yes,
there are two judgments of the Honorable Supreme Court recently passed.
They have filed an application to add us as JDRs 24 to 26.
Hmm.
For our appearance, it is there.
Yes.
My lord, as I was saying, a decree sought, the decree of 2050 was sought to be executed in 2040, in 2024 after a period of 9 years.
Hmm.
In the decree,
Hmm.
it was supposed to be executed within 30 days.
Hmm.
We don't know
Yes.
what all have happened, how whether that assignment was there or not, what all has happened, why he did not call upon the JDRs to execute the decree.
Hmm.
So all those things have to be explained.
Yes.
Ultimately, whether our objection, whether it will be accepted or not, that is a different aspect. And one more thing, my lord, one more thing on as per rule 34 of order 21 also, my lord, where there is a decree for execution of a document,
Yes.
in the instant case, as per that compromise decree, is registered sale deed has to execute. And the JDRs neglect to obey the decree holder may prepare a draft of a document in terms of the decree and has to deliver the same to the court. As per sub-rule 2, the court shall thereupon cause the draft to be served on the judgment debtor together with a notice requiring their objection, if any, to be made within such time as the court fixes. And thereafter, if the JDRs were to object to the draft, the court has to hear them and pass appropriate order about the draft of the sale deed.
Hmm.
Thereafter, the decree holder shall deliver the copy of the draft on a proper stamp paper, and thereafter the commissioner has to be appointed in this behalf to execute the document.
Hmm.
There are a lot of procedures are there, my lord. My lord, if I read the details of the order sheet, my lord, in so hasty manner, my lord, with due respect to the court below, a reasonable person's conscience bites the manner in which the court has proceeded. I will kindly look at the order sheets, my lord. I have produced the entire. Lord,
Yes.
my lord, on 24, my lords may kindly see.
Yes.
24/9/2024.
Hmm.
Advocate for DHRs filed IA number 2 under section 151 CPC for adding the JDR 24.
Yes.
IA 3, so issue notice to the proposed JDRs 24 on IA 2 and IA 3 by RPAD by hand by the court if process, if PF and sufficient copies furnished. So and so, so and so. And call on 27, within 3 days na date kodtar sahibre. On 27/9, matte issue notice to the JDR 24 ಅಂತ ಹೇಳಿದ್ರು. Then, my lord, again on 21/10/2024, my lord, nothing is stated.
ನಮಗೊಂದು ಕಾಪಿ ಕೊಟ್ರೆ ನಾವು ನೋಡ್ತೀವಿ, ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಲ್ಲ.
See, annexure C, order sheet.
Annexure C.
Huh.
Yes.
May I request,
Page
my lord,
35, my lord, page
take it up.
35.
Yes.
Page 35,
Hmm.
which I have just read.
Yes.
3 ದಿವಸದಾಗೆ ಕೇಸ್ ಇಡ್ತಾರೆ ಸಾಹೇಬ್ರೆ, ಮತ್ತೆ ನೋಟಿಸ್ ಇಶ್ಯೂ ಅಂತ ಮಾಡ್ತಾರೆ. ಇದ್ರಂಗ್ ಮಾಡಿ 3 ಸಲ ಅದು ಫಾರ್ಮ್ಯಾಲಿಟಿ ಕಂಪ್ಲೀಟ್ ಮಾಡಿ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ತಗೊಂಡ್ಬಿಡ್ತಾರೆ.
Yes.
As per that paper publication, my lords may kindly, the next 21/10 so and so. Then, my lord, 13/11/24, my lord. Await RPAD of the proposed JDR 24.
Yes.
Then, my lord, in the meanwhile, the case is advanced. On 18/12/24.
Yes.
The DHR filed an execution petition against so and so, so and so, so and so. The DHR has produced that certified copy. Iವ್ರಿಗೆ 25 and 26 ಅಂತ ತಿಳಿದು add ಮಾಡ್ಬೇಕಂತ ತಿಳಿದಂತ ಮಾಡಿದ್ರು. And the date given was 18/1/25 for appearance. Last line. 18/1/25 appearance. ಇದು ಯಾವಾಗ ಇದು ಅಡ್ವಾನ್ಸ್ ಮಾಡಿ ಹಾಕಿದ್ದು?
ಇದು JDR ನಂಬರ್ 24 ಆಯ್ತು.
ಇಲ್ಲ, ಇದು 25/26ಗೆ.
24 ಅಂತ ಇದೆಯಲ್ಲ. Consequently, issue notice to propose JDR number 24 on IA3 through paper publication on or before 18/12/2024, appearance of proposed JDR number 24 on 18/1/25.
ಆಮೇಲೆ ಮುಂದಾದ ಸಾಹೇಬ್ ಅದು ಹಿಂದೆ ಬರ್ದಿದ್ರು ಮುಂದೆ ಕಂಟಿನ್ಯೂ. JDRs number 24 has alienated the property to the proposed JDRs 25 and 26 during the pendency of the execution petition. At this stage, I am of the opinion that it is just and proper to restrain so-and-so from alienating the suit property to avoid the multiplicity of proceedings. Accordingly, so-and-so, so-and-so. ಅದು ಆರ್ಡರ್ ಮಾಡಿ ಅಲ್ಲೇ ಲಾಸ್ಟ್ ಆ ಆರ್ಡರ್ನಾಗೆ issue notice on IA number 5 and 6 to the proposed JDRs 25 and 26.
Yes.
Call on 18/1/25. Thus, for both, for 3 these additional JDRs to be added, were required to be appear on 18/1/25, my lord.
Yes.
ಇದನ್ನು ಅಡ್ವಾನ್ಸ್ಮೆಂಟ್ ಮಾಡಿ ಹಾಕೊಂಡ್ರೆ ಇಷ್ಟಿದ್ದಾಗ ಈ 18/1/25 ಇದ್ದಾಗೆ again once again DHR advances the case on 8/1/25.
Yes.
Files an application for appointment of a commissioner.
Yes.
ಅದಂತ್ರ ಯಾರಿಗೆ ಗೊತ್ತೇ ಇಲ್ಲ. Then on 18/5 that next order sheet, my lord. My lord's got page 43.
Yes.
8/1/25 case advance.
Yes.
ಅವತ್ತು ಫಸ್ಟ್ ಟೈಮ್ ಹಾಕಿದ್ರು ಇದನ್ನ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ಕಮಿಷನರ್ which is not known to anybody. Then my lord on 18/1/25 this order is passed. And my lord, even JDRs were also not given any opportunity.
Yes.
Rightly or wrongly, I have stepped into the shoes of JDRs. I may be given an opportunity to say what all I wish to say before the court, since you have asked me to come before the court.
Yes.
I have come. You are not ready to listen me.
Yes. Yes, Mr. Senior Counsel.
My lords, how would the purchaser lispendent step into the shoes of the JDR? My lord? That is not there is no provision in law.
That is right, but why did you invite them to the court?
That is an error, my lords. Let me assume for a moment, for the sake of argument,
Listen.
that my application to implead them was erroneous and was not required. It's an innocuous application.
Yes.
Just because, my lords, I make an application to implead someone doesn't mean that such person will get a right from nowhere.
No, at least you file an application to withdraw this application. Memo to withdraw the application. So long as the proposed respondents are JDRs are notified.
They are not
and
JDRs.
not to be-
That's my, yes, I will immediately take instructions. I will ask my friend to take instructions and come back to your lordships whether a memo can be filed right now here or not.
Don't execute the sale deed till then.
Well, it could be passed over, my lords, by around 4 o'clock in the evening. My lords will I will make a submission. But then, my lords,
Even that has to be done also before the court below. ಅಲ್ಲಿ opportunity ಕೊಟ್ಟಿ.
Stop them from withdrawing the application. Can you stop them from withdrawing the application filed by them to implead JDR number 25?
ಯಾಕಂತ ಹೇಳ್ತೀನಿ ಈಗ JDRs ಗಳಿಗೂ ಅಪರ್ಚುನಿಟಿ ಕೊಟ್ಟಿಲ್ಲ ಇಲ್ಕ ನಾಳೆಗೆ ಮತ್ತೆ ಅವ್ರ ಪರವಾಗಿ ನಾನೊಂದು
Can you stop anybody from withdrawing the application filed by them? Is there any force on earth which can stop? ಈ ಭೂಮಿ ಮೇಲೆ ಅವ್ರನ್ನ ನಿಲ್ಸೋದಕ್ಕೆ ಯಾವ್ದಾದ್ರು ಪವರ್ ಇದೆಯಾ? They have filed an application, they want to withdraw it.
ಅಲ್ಲ ಇಲ್ಲಿ ಯಾಕೆ ಮಾಡಿಕೊಂತಾರ ಇಲ್ಲಿ ಯಾಕೆ ಮಾಡಿಕೊಂತಾರ ಅದನ್ನ
ಇಲ್ಲಿ ಯಾಕೆ ಮಾಡ್ತೀರಿ ಅಂತ?
ಅದರಲ್ಲಿ ಅದ
World are you?
Pardon me?
We're in 2024. Law has changed. We are sitting in 227. How can you say, how can they file an application in this court? I will record the statement and I'll relegate them back to the executing court. If they want to withdraw the application, then nothing survives for consideration. You don't have a locus standard to come to this court. If they withdraw the application filed to implead the
ಅಲ್ಲಿ ಲೋವರ್ ಕೋರ್ಟ್ ನಾಗ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಅವ್ರು ಮಾಡ್ಲಿ ಅಂತ ನಾನು
ಅಲ್ಲೇ ಯಾಕೆ ಹಾಕಬಾರ್ದು ಅಂತ ನಾನು ಕೇಳ್ತಿರೋದು. Why they can't file an application in the High Court? Why they can't file? Why they can't file ಅಂತ ಹೇಳಿ. Yes, next.
ಅಲ್ಲ ಒಂದ್ ವೀಕ್ ಟೈಮ್ ಕೈಂಡ್ಲಿ ವಿ ಗ್ರಾಂಟ್.
Pass over.
ಅಲ್ಲ ಎ ವೀಕ್ಸ್ ಟೈಮ್.
ಮೆಮೊ ಹಾಕ್ತೀವಿ ಅಂತ ಹೇಳಿ ನೋಡಿ, let them pass over.
At 2:30.
2:30.
At exactly 2:30 it may not be possible, my lords, because the instructions have to be taken by my friends.
Ravi B. Patil.
ಏನಂತ ಅಮಿತ್
There are two office objections insofar as 22, my lord, there is some mistake in the order, my lord, passed with the deputy commissioner. I need to rectify it, my lord, by producing.
What do you want?
My lord, 22, I'll comply. 27, my lord, maybe kindly dispense with, because
The office objection serial number 27 is overruled by accepting the submission of the learned counsel for the petitioner that the annexure A and
Page
annexure
31.
D are legible.
Page 31 is
After complaints of office objection serial number 22.
page.
Yes. Government
Please.
advocate. What is this?
This
RP?
case, we have filed the RP, my lord, wherein the, in writ petition, my lord, there was a order only on the basis of the amount released order. So therefore, the honorable court was pleased to direct the authority to release the amount, my lord. So for us, the land was acquired, which is includes 2 gunta, which is also pertaining to the forest department, my lord. Later, we came to know about these things, my lord. So we have only released the amount to the only for the acquired land. So
Not on that. The court has passed an order
please,
directing you to release a sum of rupees 1.
yes, ma'am, yes,
67 lakhs 11,200,
yes.
which was the award passed.
Yeah, sale consideration. Yes, ma'am, sale consideration.
So if you want to now say the 2 guntas belong to the forest department.
Please.
How can you say that after the writ petition is disposed of?
No, but after filing contempt only, we have deposited the amount, only the 2 gunta, we have not credited to the
Deposit that also.
remaining amount we have paid.
Correct, but Nivene, how can you say 2 guntas belongs to forest department without hearing him?
So therefore, I requesting the restoration of writ petition, my lord.
Huh?
So restoration of writ petition, and also therefore we have filed.
Have you issued a notice?
Please, ma'am, please, ma'am. Already notice issued, my lord, it is come for delay, my lord.
Have you issued a
Please.
notice?
So, ma'am,
Please, hello, please listen to me.
please.
Have you issued a notice telling him or informing him that 2 guntas belongs to the state government or the forest department, and therefore compensation cannot be given to you and the another notice kottidira?
No, ma'am.
Then how can you unilaterally now say that 2 guntas belongs to the forest department? You should issue notice to him or her, whatever.
Please.
RP, in fact, order passed in writ petition is already complied. They have made payment also, my lord.
You already received the money.
Yes.
Enter.
You withdrawn the money.
Yes, alloko deposit ಮಾಡಿದ್ದಾರೆ withdraw ಮಾಡಿ.
Withdraw ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ?
Yes.
You withdrawn.
Yes.
As per instruction, my lord, as per our instruction.
Then take whatever steps that are available.
Please,
to you
ma'am,
in
let
law.
them record their submission and
Good.
close.
This review petition is filed by the state government to review the order dated 27/3/2019 in WP number 21680-81/2017. Next para. It is the claim of the petitioner that a sum of rupees 1,67 lakhs 11,200 was the compensation, ಏನದು?
No, my lord, sale consideration.
Was a sale consideration payable for
my lord, having purchased building.
How much?
23,142 square feet.
23,142 square feet
Square feet, yes.
of land belonging to the respondent.
Please.
Full stop. This court issued in WP number 21680-81 of 2017. This court issued a writ in the nature of mandamus to the petitioners herein to release They said sum of rupees 1,67,67,11,200. The petitioners contend that the respondent had initiated contempt proceedings for non-compliance of the order passed in the aforesaid writ petition, consequent to which they paid a sum of rupees 1,52,73,720. It is contended that the petitioners later came to know that 2 guntas belong to the forest department, and therefore the respondent was not entitled to a sum of rupees 14,37,480. The petitioners have therefore filed this review petition to review the order passed by this court in WP number 21680-81/2017. Next para. The learned counsel for the learned AGA reiterated the above contentions and contended that the respondent is not entitled to the sale consideration in respect of the entire extent, as 2 guntas of land belong to this forest department, for which the petition respondent is not entitled, full stop. He therefore contends that the order passed by this court in WP number so and so be recalled. Per contra, the learned counsel for the respondent submits that the petitioners have already deposited rupees 40, have already had deposited a sum of rupees 1,52,73,720, which was withdrawn by the respondent, and later a sum of rupees 14,37,480 was also deposited, and that the same is also withdrawn.
Yes.
Sure.
Yes.
Full stop. He therefore submits that if the petitioners are desirous of making any claim against the respondent, they may do so in accordance with law. Full stop. This fact is not disputed by the learned AGA. If that be so, the order passed in WP number 21680-81 of 2017, dated 27/3/2019, cannot be reviewed or recalled, as the same is complied. In that way of the matter, this review petition is disposed of, reserving liberty to the petitioners to take suitable action against the respondent in accordance with law, if the petitioners are of the opinion that they have paid sale consideration in respect of 2 guntas of land which belong to the forest department.
All contentions are
All
kept.
contentions are left open.
Obliged.
In view of the disposal of the review petition, IA 1 of 21 does not survive for consideration, and the same stands disposed of.
Let's say appear for the
Lords,
petition.
In
Senior
21, I
senior.
represent the petitioner's counsel. And in 21.1 R3, my lords, in 21.1, they have challenged the validity of amended section 28 and 30 of the KID Act. The government has to file its counter. Both can be taken up after both, my lords.
But was there some proceedings pending before the Supreme Court in this regard?
Idradilla, my lords, this was referred to full bench. This matter regarding, my lords, delay in passing an award.
Yes.
Thereafter, it has come back. That's all, my lords. So far as this matter is concerned, it's to my knowledge, it's not gone to Supreme Court. So far as 21 is concerned, it's the beneficiary for whom the land was acquired. After about 10 years, my lord, the government demands the payment of about 21 crores from me, which we have challenged. In 21.1, it's the landowner who has challenged the acquisition.
Yes. Yes, who appears?
Anytime after 5th of Feb, if your lordships have.
State has to file.
State,
I'll get the instruction and file to you.
2016-19 matter, right?
The AG matter, because
And AGA seeks time to file statement of objections. On the out with.
after 2 weeks.
My lord, in this case, we are appealing for the land loser. Since from my lord, the preliminary notification is of the 2006. The name of the KID is entered. Till today, my lord, no, not a 1 rupees paid to the land losers. The dispute is between the, my lord, the owner of the sugar factory and KIDB regarding the fixation of rate. In between them, my lord, these land losers have.
Bandeela.
ಇಲ್ಲ ಏನು ಕೊಟ್ಟಿಲ್ಲ
ಅಲ್ಲ ನಾವು ಡೆಪಾಸಿಟ್ ಮಾಡಿದೀವಿ. We have deposited, they have asked enhanced amount, but KDP has not passed an award, we do not.
Notice itself is challenged, madam. Notice for payment of
Yes,
Mulad
my lord,
Samad.
I challenge the validity of section
First
28 and
20,
30 and challenge the
21.1.
section
Let the
3 1.
compensation be paid. Where's the question?
Well, there is no award as such.
Not yet passed the award 2007.
Award ಮಾಡಿಲ್ಲ.
ಇಲ್ಲ ಸ್ವಾಮಿ.
Award ಆಗಿಲ್ಲ. Award.
For
ನಾವು
that,
deposit
Mulad,
ಮಾಡಿದೀವಿ.
is there any, Mulad, time limit to pass the award, Mulad? This court has referred the matter to the larger bench. Now larger bench has decided, Mulad, send it to the
Both are
present case.
different, it's not.
Larger bench, what does the larger bench say?
Two judgments.
My
are
lords, full
referred to
bench
the
only,
larger
the
bench.
issue was whether acquisition can be quashed, my lords. On the basis of, they said there is no conflict. The full bench said that there is no conflict between two division benches, because one division bench had held, my lords, that there is no time limit for passing an award under KID Act, whereas the other division bench had held otherwise. The full bench, my lords, said there is no conflict and left it open to be decided in individual matters.
Para 12. That's it. ಇಲ್ಲ ಮೂರ್ full bench.
Full bench. Mr. ಇಂದ್ರೇಶ್ ಅಂತ ಹೇಳಕ್ಕೆ ನಿಮ್ಗೇನ್ರಿ ಅಧಿಕಾರ ಇದು? How can you call a judge by his name? Who are you?
Thereafter, my lord, listing, my lords. After that, my lord, after, my lord, refer back to this court, my lord, some of the land losers have challenged the, my lord, 28 provision of, my lord, land, this 28(1) and 28 and 30 of, my lord, KID Act.
The award is not at first. Not even tell you first.
So many adjournment claimants land losers 20 provision challenge ಮಾಡಿದ್ರೆ ಕೊಡೋಬ್ರು ನಿಂದಿರ್ತಾರೆ ಅದೇನೋ ಉತ್ತರ ಮಾಡಿಲ್ಲ.
Depend upon which case, court can be either pass it or. What is it? Straight away now pass it or something or that.
Yeah.
For the award person, for any time award person, or award person, there is no limitation for passing the award.
Correct.
Yes.
Lordship, I have it after 5th of February, my
Serial
lords.
number 21, what is challenged?
Lords, the notices issued by the government, lords, enhancing and demanding about 21 crores from me, though I had paid the entire acquisition cost to the government in 2007.
Yes.
Lords, that is what is challenged.
And in the 21.1, what is challenged?
They have challenged the acquisition.
Validity of
21.1 acquisition is challenged.
validity of
Uh,
section 28 and
28 and
On
By
what? ground?
amendment,
there is discrimination among other acts, my lord, under National Highways Act and land acquisition as well as the.
That is already considered. Alva. That question is already considered. As Nagbhushan case, alva,
Yes.
is already considered.
Let them,
India,
government has
biggest-
filed a statement, my lord.
And
that,
AGA seeks time to file objection.
sir.
List on date.
After
Yavat mat
2 weeks, after 5th, 2 weeks.
kodi yavat.
Well, after 5th.
after 5th, please, my lords.
Actually,
Please.
Lord, this
Huh?
honorable court has last time suggested that if they want to establish industry, let them pay as on today as per the new act, payment act compensation. Or if they don't want to let it, my lord, notification will be. That is the two options which is.
ಈ
not-
21 ರಲ್ಲಿ ಮತ್ತೆ 21.1 same land is involved or
Yes,
different?
Same land, same.
Different
It's the
counts.
same thing.
Sanjeev Kumar, ನೀವು landowners.
Yes, I am also filed and implementing, my land is also acquired.
ಅಲ್ಲ, but ನೀವು ಯಾರು
Pleading baro.
You are also for landowner.
Total
Lords,
89.
impleading applicant cannot come as a land loser and stake claim, my lords. He has to file a writ petition.
Yes. ಆಯ್ತು, let him come.
After 5th, my lords.
Whichever day is government, ಯಾವಾಗ? 11th.
After 2 weeks.
11.
Yes.
Please.
Please.
This case, my lord, 2 weeks time, records are made. And go to records, my lord, and week after next month.
Lordship, date to be fixed, Lordship. Appearing for the
Counsel for the petition and the learned counsel for the respondent takes time, list on date.
much of
Arun Kumar.
Matter previous occasion heard for some time and I was directed to file RORs. Yesterday, my lord, I have filed it.
Again told.
ROR.
Yes.
Through this writ petition, orders of deputy commissioner and assistant commissioner passed under section.
Order sheet, Mr. Order sheet. Huh? What was the earlier order?
Here order, my lord, to produce RORs with respect to subject land of writ petition. And also there appears, my lord,
Anybody asked to produce the RTCs?
previous. Petitioners are calling in question, my lord, deputy commissioner orders, deputy commissioner and assistant commissioner order. It is at, my lord, next year. Next year. E, my lord, and my lord, C2. Deputy Commissioner referring to, my lord, by recording erroneous findings, stating that though of a revision preferred, appeal preferred before Assistant Commissioner was well within limitation. However, he holds, my lord, that it was beyond limitation and therefore application under Section 5 of Limitation Act was not there. And hence, my lord, RP is dismissed, holding.
Yes.
Lord, coming to, my lord, facts of the case, the petitioner's father by name Hanmanta and, my lord, the grandfather one Siddhappa.
What was challenged before the assistant commissioner?
Order of mutation.
Dated?
Lord, order of mutation dated.
2818.
Please.
18 to 18.
2/8/2018.
2018.
Yes.
Whereby the name of private respondent herein came to be mutated in respect of subject land. And my lord, it was contended that by these petitioners before Assistant Commissioner that she is not at all related to the person whose name found in the, my lord, column number 9, that is owner of the land. He was unheard of and he was not at all a resident of village. And therefore, virtually, my lord, they petitioners have disputed relationship with the original owner whose name found in column number 9. And my lord, Assistant Commissioner upholds contentions of petitioners. And strangely, my lord, he passes an order. May I request page 30?
Yes.
Page 30. ಪ್ರಕರಣದ ವಿಚಾರಣೆ ದಿನಾಂಕ ಸಂಬಂಧಿಸಿದಂತೆ ಮೇಲ್ಮನವಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಎದುರುದಾರರಿಗೆ ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಲಾಗಿ ಪ್ರತಿವಾದಿ ನಂಬರ್ 1ರವರ ಪರ ವಕೀಲರ ಮುಖಾಂತರ ಈ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಹಾಜರಾಗಿದ್ದು ಇರುತ್ತದೆ. ಮುಂದುವರೆದು ದಿನಾಂಕ 13/12/2019 ಸತತವಾಗಿ ಮೇಲ್ಮನವಿ ಪರ ವಕೀಲರಿಗೆ ಕಾಲಾವಕಾಶ ನೀಡಿದರೂ ಸಹ ಯಾವುದೇ ಆಕ್ಷೇಪಣೆಯನ್ನು ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಲಭ್ಯವಿದ್ದ ದಾಖಲೆಗಳ ಆಧಾರದ ಮೇಲೆ ಮತ್ತು ಮೇಲ್ಮನವಿದಾರರ ವಾದವನ್ನು ಆಲಿಸುತ್ತಾ ಮೇಲ್ಮನವಿಯಲ್ಲಿ ಸಲ್ಲಿಸಿರತಕ್ಕಂಥ ಅಂಶಗಳನ್ನು ವಿವರವಾಗಿ ಹೇಳಿದ್ದು ಹಾಗೂ ಈ ವಿವಾದಿತ ಜಮೀನಿಗೆ ಪ್ರತಿವಾದಿ ನಂಬರ್ 1ರವರು ಯಾವುದೇ ರೀತಿಯಾಗಿ ಸಂಬಂಧ ಇರುವುದಿಲ್ಲ ಹಾಗೂ ಅವರು ಸಲ್ಲಿಸಿರತಕ್ಕಂಥ ದಾಖಲೆಗಳು ಸೃಷ್ಟಿ ಮಾಡಿ ಕೊಟ್ಟಿ ದಾಖಲೆಗಳಾಗಿರುತ್ತವೆ ಮತ್ತು ಗ್ರಾಮ ಲೆಕ್ಕಿಗರು ಮಂತ್ರಾಲಯರವರು ರಂದು ಅವರು ನೀಡಿದ ವಂಶಾವಳಿಯನ್ನು ಹಿಂಪಡೆದಿರುತ್ತಾರೆ. ಸದರಿ ಹಿಂಪಡೆದ ಪತ್ರದಲ್ಲಿ ಬಹಳ ಸ್ಪಷ್ಟವಾಗಿ ಹೇಳಿದ್ದೇನೆಂದರೆ ಪ್ರತಿವಾದಿ ನಂಬರ್ 1ರವರ ಕುಟುಂಬದ ಬಗ್ಗೆ ಯಾವುದೇ ಬಗ್ಗೆ ಮಾಹಿತಿ ಇರದೇ ಕೂಡ ನಾನು ವಂಶಾವಳಿ ನೀಡಿದ್ದು ತಪ್ಪಾಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಗ್ರಾಮ ಲೆಕ್ಕಿಗರು ಮಂತ್ರಾಲಯ ಹಿಂಪಡೆದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸದರಿಯವರಿಗೆ ಪೋತಿ ವಿರಾಸತ್ ಮೂಲಕ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ ಮುಟೇಶನ್ ನಂಬರ್ ಮುಟೇಶನ್ ಆಧಾರಿತವಾಗಿ ತಕರಾರು ಪ್ರಕರಣ 2/8ರಂದು ಪ್ರತಿವಾದಿ ನಂಬರ್ 1ರವರ ಪರವಾಗಿ ಹೆಸರಿಗೆ ಪೋತಿ ವಿರಾಸತ್ ಮೂಲಕ ವರ್ಗಾವಣೆ ಮಾಡಿದ ಆದೇಶವನ್ನು ತಿರಸ್ಕರಿಸಲು ಮತ್ತು ಮೇಲ್ಮನವಿದಾರರು ಸಾಗುವಳಿ ಕಾಲಂ ನಂಬರ್ 12ರಲ್ಲಿ ಸತತವಾಗಿ 1954ರಿಂದ 2015ರವರೆಗೆ ನಮೂದು ಆಗುತ್ತಾ ಬಂದಿರುವುದಾಗಿ ತಿಳಿಸಿರುತ್ತಾರೆ. ನಂತರ ಸದರಿ ಜಮೀನು ಎಂದು ಮೂಲ ಪಟ್ಟೆದಾರರಿದ್ದು ಅವರ ವಾಸದ ಬಗ್ಗೆ ಮತ್ತು ಕುಟುಂಬಸ್ಥರ ಬಗ್ಗೆ ಯಾವುದೇ ರೀತಿಯ ಮಾಹಿತಿಯನ್ನು ಈ ನ್ಯಾಯಾಲಯದ ಗಮನಕ್ಕೆ ಬಂದಿರುವುದಿಲ್ಲ. ಮತ್ತು ಈಗಾಗಲೇ ಗ್ರಾಮ ಲೆಕ್ಕಾಧಿಕಾರಿಗಳು ಇವರು ನೀಡಿದಂತಹ ವಂಶಾವಳಿಯು ಸಹ ತಪ್ಪು ಮಾಹಿತಿ.
Land bearing survey number 42.
Yes.
Total extent is 10 acres.
10 acre 28 guntas.
Who was the khatedar of this land?
One, my lord, Raghavendracharya, son of Tattvagnanacharya.
Raghavendracharya.
Son of.
How are you related to him?
I am not related to him, my lord. However, my grandfather's name, may request lordship to peruse ROR in Kasrapani produced along with the memo. Page 3, my lord. Page 2. It is Kasrapani of the year 1954-55. There, my lord, in Pattadara athwa Inamdara Sarkari antide. Column number 9 ಅಲ್ಲಿ. There Raghavendra Tattvagnanachar ಅಂತಿದೆ. ವಿವರ ಈ ಅಂತಿದೆ, ಅದು ಇನಾಮ್ದಾರ್. And my lord, as against column number 16, ಅದರಲ್ಲಿ ಗೇಣಿದಾರ ಸಿದ್ದಪ್ಪ ತಂದೆ ನರಸಪ್ಪ. This is, my lord, Siddappa is none other than the grandfather
of
petitioners. His name all along, right from 1954 to, my lord, 2013-14, continued in column number 12-2.
Correct, but how can you have any objection against registration of the name in column number 9?
9, I have no objection. 9, I have no objection.
Yes.
12-2.
Hanumanta andre yaru?
Hanumanta is my father. Father of petitioners. Petitioner number 1. 4-5.
Till what year is your name continued? in column?
1314, my lord.
2000?
1314. Thereafter, without any
13.
orders,
2007, 8 ಅಲ್ಲಿ Hanumanta. Hanumanta.
Up to 1314, his name is there.
all I submit, my lord, whether she is related to Patadar, original Patadar is all, my lord, it is to be dealt with by the
Who are you to
competent.
say that? You are not related to him.
La.
So therefore, what about column number 12? Entries in column number 12.
My lord, sometime, my lord, their names after, my lord, 2000, their names are not appearing in column number.
Correct, but what was there in 2013 is deemed to continue. Where's the question of deleting it?
My lord, in 2000s, my lord, their name has been, our name is appearing in column number 12, my lord. 2000 ಹಿಡಿದು ನಮ್ದು 2001.
2013 ಅಲ್ಲಿ the name of Hanumanta is removed. Correct?
ಇಲ್ಲ, both names are appearing in column number 10.
It is appearing. Thereafter it was deleted.
Deleted, my lord.
How it was deleted? Was any proceeding held?
ಅದೇನು ಗೊತ್ತಿಲ್ಲ
So therefore that name should continue.
ಅದು ಅವ್ರು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ ಅವ್ರ ದೇರ್
Challenge ಮಾಡ್ಲಿಲ್ಲಲ್ಲ, their name should continue. What?
their contention is that, my lord, we are the, my lord, successor of the, my lord, my lord Raghavendra Charya. We was my husband, father, my lord. Subsequently, he had 3 sons, my lord. After that, we claiming that, my lord, entrance up.
That is okay. Column number 12, he says column number 9, I have no objection. Let this lady's name continue. But
And
column number 12.
we also prepared the revision petition before the, my lord, deputy commissioner.
ಯಾರು?
Now, ಹಾಕಿದೆ. It is also still pending for considerations.
What did you challenge?
The
Assistant
assistant commissioner.
Assistant Commissioner order forfeiting the land, my lord,
Forfeiting the
subject to land in
and,
favor of
my
state
lord,
government.
cancellation of my lord,
Registering it in the name of the state government.
house.
ಅದೇನಾಯ್ತು appeal?
ಅದನ್ನ pending ಇದೆ ಸ್ವಾಮಿ.
Lord, we have not received any notices.
Let that be decided. ಬರ್ಕೊಳ್ಳಿ.
ಅದು last occasion ಅದನ್ನೇ observe ಮಾಡಿದೆ.
Since it is stated by the learned counsel for the respondent number 4 that the respondent number 4 has challenged the order passed by the respondent number 2 before the respondent number 1 in a revision petition under section 136(3) of the Karnataka Land Revenue Act 1964, this petition cannot be disposed of until the revision petition pending before the respondent number 1 is considered. Hence, list this petition after consideration of the revision petition pending before the respondent number 1. Until then, the status quo in respect of the revenue entries of the land bearing survey number 42.
Yes.
Of
Marchetal village.
So and so.
Taluk and district Raichur.
As on date shall continue. Yes.
Great.
Raj Police Party.
Petitioner, my lord. The petitioners have filed the writ petition seeking the relief of mandamus against the respondents to acquire their land, which is being used for the formation of service road and also for national highway. The Honorable Court directed.
Okay, Santosh Kumar Maradi, you are not coming to the court. ಯಾಕೆ ಬರ್ತಾ ಇಲ್ಲ?
The last date hearing appeared.
Last time ಬಂದಿಲ್ಲಲ್ಲ ಇವರು.
Bandhan sir, present it, I have instructed the state government to produce the
CGP
order
is directed to furnish EDLR report, my lord.
It may be taken Monday, I will secure ADR.
Around AGS seeks time. This one also. Yes. Antesh Patil.
You already disposed of granted in status quo order.
Yeah,
I will pay the process, my lords, within 1
Learned
day.
counsel for the petitioner seeks time to pay the process. 1 week time is granted to do the needful, failing which the petition against R6 to R11 to the 25 only. Then R17 to R20 and R24, 25.1 shall stand dismissed. Even R17 deceased ಅಂತಿದೆ.
I will find out. So deceased R17 and
ಇದು R6 to R11, madam, is first petition only. 1 week, 2 weeks time is granted to take steps in respect of deceased R17 and R24.
R24.
Yes.
Interim order.
Interim order granted rejection to the next date. Naveen Jain.
So I appear for the petitioner. Lordship, on the last date of hearing, the fifth respondent took time to file an objections, my Lordship, to the IAS.
Gaurish Kashampur. There is no representation for the respondent number 5.
And for respondent number 4, Jaykumar S. Patil sir is on.
Gaurish Kashampur. Huh?
I paid for the corporation. Corporation has been taking time without doing anything.
ತಾವು ಯಾರಿಗೆ?
I am for respondent number 4.
My lord.
I am the applicant.
Yes.
Lordship sir granted an order of status
Objection
quo.
ನಿನ್ನೆ ರಾತ್ರಿ ರೆಡಿ ಮಾಡಿ ಕಳಿಸಿದೀವಿ for wetting, my lord. It will take 1 day time, my lord. Day after tomorrow.
Counsel for the respondent number 5 seeks time. List on.
It's been interim order to be continued.
Interim order is extended till the next date.
Yes.
Ratna Shivayogi.
Great. 23. Huh? 20. Grateful. Great.
Please, my lords, I have filed application for consideration of interim prayer because this honorable court directed the surveyor, assistant director of land records, to survey the land, my lord, during the pendency of writ petition on 22/10/2024. Accordingly, they surveyed and prepared the sketch also.
Yes.
That is sketch is available in the court, my lords. Therefore, the green, that the color marked by the green, my lord, that is vacant site. The entire,
Please wait, let me go through the. Where's the report?
report, my lord, report dated 6/11/24. Along with
24
sketch
is there
they have
not
filed.
really? Report ಅಲ್ಲಿ ಇದೆ ನೋಡ್ರಿ ಇಲ್ಲಿ.
Read it.
Yes.
Only single, that is not report, my lord, that I have. One more report that is filed by the surveyor.
24.
That the government has filed. with-
The government, have you filed it?
One.
Yes, please.
The green mark, my lord, which are shown, those are the vacant site. Because the 26/4 and 26/5, my lord, that is my triangle mark, that is my land. That entirely, that is blocked by the KHB. The connectivity road, block ಮಾಡ್ಬಿಟ್ಟಿದೆ.
This red, there's a strip of land. That's red strip of land is your land.
No, 26/4 and 26 triangle side, ಕೆಳಗಡೆ ಆ ಕಡೆ.
Red line is ಅದು.
Yes, sir.
Correct, madam, this is red mark. ಈ red mark is thin line ಇದೆಯಲ್ಲ ಅದು.
4 and 5.
ನಾವೇ ಮಾಡ್ಯಾರ.
4 ಗುಂಟೆ ಜಮೀನು ಒತ್ತುವರಿ ಮಾಡಿದ್ದು ಕಂಡು ಬರುತ್ತೆ.
They have encroached my land as well as blocked the entire area, which is my layout is approved. There is no connectivity. And they have filed this application, my lord, now they are putting the tin sets, therefore I filed this application to consider the interim prayer not to put up any construction in those plots, my lords. If them, let them provide any alternate site to others and.
Yes, Mr.
Sorry, my lord, but 27, English has requested me to seek password, my lord. 27 serial number ಅಲ್ಲಿ ಕೂಡ ಎಂಗ್ಲಿ ಅವರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ. ಈಸ್ ಇನ್ ಡಿವಿಷನ್ ಬೆಂಚ್, ಮೈ ಲಾರ್ಡ್.
ಯಾರು?
ಎಂಗ್ಲಿ ಅವರು, ಶಿವಕುಮಾರ್ ರೆಡ್ಡಿ.
Urban Development Authority.
Town Council for the respondent number 8 seeks time.
ಅಲ್ಲ ಪಾಸ್ವರ್ಡ್ ಕೇಳಿದ್ರೆ.
Password.
ಪಾಸ್ವರ್ಡ್. ಪಾಸ್ವರ್ಡ್ ಅವ್ರ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್
ಏನ್ ಬೇಕು ಹೇಳಿ?
ಪಾಸ್ವರ್ಡ್
Password.
that's all.
Yes, Praveen. Venkatesh C. Mallabadi. HCGP is directed to produce the
Please,
original
in this
records.
case, madam,
ಬಂದಿದೆ.
what, 2 weeks, my lord, I'll get.
Government
No, madam.
ಎಲ್ಲಾ
I
ಕೇಸ್
wrote.
ಮಾಡಿದೆ. There's a limit to testing the patience, Mr.
Sorry, my lord.
ಎಲ್ಲಾ
next time.
ಕೇಸಲ್ಲೂ ಗವರ್ಮೆಂಟ್ ಅವರು ಈ ತರ ಹಿಂಗ್ ಮಾಡಿದ್ರಿ. ನೋಡಿ, HCGP AGS seeks time to comply the order dated 18/12/2024. Yes.
My lord, the order of Assistant Commissioner and Deputy Commissioner is challenged in the present writ petition.
Yes.
Whereas the petitioners have purchased the land in the year 1994 from one Sunkappa. And this respondent number 6 has filed application saying that he too has purchased the land from Sunkappa, whereas the father's name of Sunkappa and his surname is different. Thereby the mutation affected in the year 2006 is illegal. For that reason, he sought for cancellation of the mutation.
What is your sale deed? When was your sale deed?
Our statement before the assistant.
When was your sale deed? What is the date of your sale deed?
The date of sale deed is 7/4. Sale deed is 18/5 to 1994, my lord.
18/5/94.
Yes.
What is the date of sale deed of the respondent number 6?
Respondent number 6 says that he has purchased the land in the year 1993. my lord.
What is the date?
Or 7/4/1993.
7/4/93.
93.
Ah. Now, what is the respondents done?
Respondent number one, Deputy Commissioner, respondent number 2, Assistant Commissioner has held that the sale deed got executed by the petitioners are incorrect, illegal, and thereby mutation is to be set aside. This is the only observation.
ನಿಮ್ಗೆ ಯಾವ್ದು ಮ್ಯೂಟೇಶನ್ ಆಯ್ತು?
ನಮ್ಮ mutation 2006 ನಲ್ಲಿ ಆಗಿದೆ, 2008 ನಲ್ಲಿ ಆಗಿದೆ.
ನಿಮ್ದು 2008.
8 ನಲ್ಲಿ 38.
ಅವ್ರಿಗೆ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 6 ಯಾವಾಗ ಆಯ್ತು?
ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 6 ಆಗಿದ್ದು ಇದು ಇಲ್ಲ ಸರ್, ಮುಟೇಶನ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರ ಅಂತ ಹೇಳಿಲ್ಲ.
ಅನೆಕ್ಷರ್ ಬಿಗ್ ಬನ್ರಿ, ಅನೆಕ್ಷರ್ ಬಿಗ್ ಬನ್ನಿ. ನಂಬರ್ 3 ಅಂತ ಏನೋ ಇದೆ ನೋಡಿ. ಸುಂಕಪ್ಪ ಉರುಫ್ ಕುಂಚೆ ಕೋರವರ, ಭೀಮಪ್ಪ ಉರುಫ್ ಕುಂಚೆ ಕೋರ, ಭೀಮಪ್ಪ ನಾಗಪ್ಪ ಕುಂಚೆ ಕೋರವರ, ಸುಂಕಪ್ಪ ನಾಗಪ್ಪ ಕುಂಚೆ ಕೋರವರ.
Yes.
2 acres, 23 guntas. Yes.
Yes, ಆದೇಶದಲ್ಲಿ ಒಂದು ಸ್ವಲ್ಪ ಓದ್ತೀನಿ ಸರ್. ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿದ ಅಂಶಗಳನ್ನು ಮತ್ತು ಪ್ರಕರಣ ದಾಖಲೆಗಳನ್ನು ಕೂಲಂಕುಷವಾಗಿ ಪುನರಾವಲೋಕನೆಯಿಂದ ಪರಿಶೀಲಿಸಿ ಮೇಲ್ಮನವಿಯನ್ನು ಅಂಗೀಕರಿಸಿ ವಿಜಯಪುರ ತಾಲೂಕಿನ ಮಾಲ್ಬಾಗಾಯತ್ ರಿಜಿಸ್ಟರ್ ಸರ್ವೆ ನಂಬರ್ 1073 so and so dated 25/5/2009 ಅನ್ನು ರದ್ದುಪಡಿಸಿ ಆದೇಶಿಸಲಾಗಿದೆ. ಈಗ ಇದನ್ನ ರದ್ದುಪಡಿಸಿದ್ರಿಂದ ಅವು ಸಿಡಿಡ್ ಅಂತೂ ಕ್ಯಾನ್ಸಲ್ ಆಗಂಗಿಲ್ಲ ಸರ್. ಅವರು ಸಿವಿಲ್ ಕೋರ್ಟಿಗೆ ಹೋಗ್ಬೇಕು.
ಯಾರ ಹೆಸರು ಪಾಣಿ ಇತ್ತು ಹೇಳಿ ನಿಮಗೆ? 2008-9 ಮುಂಚೆ ಯಾರ ಹೆಸರು ಪಾಣಿ ಇತ್ತು?
ಅವರು ಸುಂಕಪ್ಪ ಅವ್ರ ಹೆಸರಿಗೇನೆ ಇತ್ತು.
ಸುಂಕಪ್ಪ ತೋರಿಸಿ, ಎಲ್ಲಿದೆ ಪಾಣಿ?
ಹೌದು ಸರ್, ಸಿಡಿಡ್ ಜೆ ಫಾರ್ಮ್ ಏನದ ಅಲ್ಲಿ ಇದಕ್ಕೆ ಹೋಗ್ಲಿಲ್ಲ ತಹಶೀಲ್ದಾರ್ ಆಫೀಸಿಗೆ ಇಮಿಡಿಯೇಟ್ ಆಗಿ 94 ನಲ್ಲಿ. ಅದು ಹೋಗ್ಲಾರ್ದಾಗ ಇವ್ರು ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಟು ಮುಟೇಶನ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
ದಯಮಾಡಿ 2008ನೇ ಇಸ್ವಿ ಹಿಂದೆ
Yes.
ಯಾರ ಹೆಸರಲ್ಲಿ ಪಾಣಿ ಇತ್ತು ಅಂತ ತೋರ್ಸಿ.
ಎಸ್ ಹಾಕ್ತೀವಿ ಸ್ವಲ್ಪ ರಿಕಾರ್ಡ್ಸ್ ಹಾಕ್ತೀವಿ ಇಲ್ಲ ಹಾಕಿದ್ದ ಸರ್ ಒಂದು ಶಾರ್ಟ್ ಹಾಕಿದ್ದಿದೆ ಸರ್ ಐ ನಂಬರ್ 1 ಅಲ್ಲಿ ರೀಸೆಂಟ್ಲಿ ರಿಕಾರ್ಡ್ಸ್ ಹಾಕಿದ್ದಿದೆ 24, 23 ಅಥವಾ 27
ನೀವೇನು ಹಾಕಿಲ್ಲ.
ಇಲ್ಲ ಹಾಕೇನ್ ಸರ್
ಹಾಕಿದ್ರೆ ನೋಡ್ಸ್ ಕೊಡ್ರಿ ತೋರ್ಸಿ.
ಒಳ್ಳೆ ಇಟ್ ಬಿ ಪಾಸ್. ಹಾಕಿಲ್ಲ ರಿಕಾರ್ಡ್ಸ್.
ಬರ್ಕೊಳ್ಳಿ. The learned counsel for the petitioner seeks time
Yes.
to furnish the revenue records of the property in question prior to the year 2008-9.
92, 93. Sunkappa name is there.
Prior to the year 2008-9. This list after the same is done. Yes. Ganesh Naik. Venkatesh Mallabadi.
Appearing for the petitioner, my lord.
Ah.
This case, my lord, as per the annexure F, my lord. Also, is the interim order, is the grant, my lord, is the order of the petitioner, is the page number 49, my lord.
My lord. That,
Please,
please.
complete your submission.
Please.
Even before I understand, you start opening. Yes.
Page number 49, my lord. The learned counsel for the government advocate, my lord, for third paragraph. The meanwhile, by way of the interim arrangement and without the prejudice to the rights and contention of the parties, it is directed that all the further proceeding result to the imposed notice dated 3/12/2024 at annexure K would be subject to the further order of this court and final outcome of this writ petition. As per the my lord, as per respondent number 3, without the my lord is the followed this my lord the interim order. My lord has the proceed was the initiate against the my lord the petitioners, and my lord the same reason the result was the pronounced, and my lord the subsequent my lord the respondent number 2 is the communicate to the new president as the election was the conducted by the third respondent. Is the clearly the violation of the law, my lord.
3/12/2024.
Please, my lord.
Where is the notice?
My lord is the annexure A, my lord.
Annexure
A, my lord. Is the page number, my lord, is 13, my lord. What is the typical mistake, my lord, the 312 1312
The annexure 312 ಅಂತ ಇದೆಯಲ್ಲ.
ಹೌದು 312 my lord is the key 312 sorry sir.
Annexure is 312 only.
Please, my lord, that is 312.
On what ground have you challenged this?
My lord is the key, as per the private respondent, my lord is the key, requestion is the key represent before the third respondent for the key some allegations, my lord. On that base, my lord, we are the key challenge before this on.
But if the allegation is there, it has to be construed as 49.
My lord is the key coordinate bench, my lord, as per the section 49(2), my lord has the key some allegations, my lord has the provisions of the my lord.
Lakshmamma judgment ಕೊಡ್ರಿ.
ಅದು ಆದ್ಮೇಲೆ my lord coordinate bench judgment ಆಗಿದೆ.
ಲಕ್ಷ್ಮಮ್ಮ ಜಡ್ಜ್ಮೆಂಟ್ ಏನಂತ ಹೇಳುತ್ತೆ? ಡಿವಿಷನ್ ಬೆಂಚ್.
ಆದ್ಮೇಲೆ 2018 ಅಲ್ಲಿ my lord there is the key.
ಲಕ್ಷ್ಮಮ್ಮ ಜಡ್ಜ್ಮೆಂಟ್ ನೋಡಿದೀರಾ?
ನೋಡಿಲ್ಲ. ಆದ್ಮೇಲೆ
ಜಡ್ಜ್ಮೆಂಟ್ ರೆಂಡರ್ಡ್ ಬೈ ಆನರಬಲ್ ಚೀಫ್ ಜಸ್ಟಿಸ್ ಅಂಡ್ ಜಸ್ಟಿಸ್ ಕೃಷ್ಣ ದೀಕ್ಷಿತ್. Have you read the judgment? ನೋಡಿದಿರಾ?
ಅದು ಮಾಡಿದ್ದಾರೆ.
ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ ಏನಂತ ಹೇಳಿ?
ಅದನ್ನೇ ಇದರಲ್ಲಿ my lord the 844 my lord is the writ appeal. ಅದನ್ನೇ ಇದರಲ್ಲಿ ತಗೊಂಡೇ ಮಾಡಿದ್ದಾರೆ ಸರ್. Is the some observation my lord.
ನೆನ್ನೆ ಲಕ್ಷ್ಮಮ್ಮ ಜಡ್ಜ್ಮೆಂಟ್ ತಂದಿದ್ರಲ್ರಿ ಇಲ್ಲಿ. ನೆನ್ನೆ ಚೇಂಬರ್ ತಂದಿಲ್ವ ಇಲ್ಲಿ? Yes,
The para 16 and the para number 17, 18, that is the same. It is the clearly that is the stated in the intention to where the two category of the mention of the no confidence motion the assistant commissioners would be only have to decide on the base of the where perusal of the complainant has to, which the category the motion of no confidence belongs to. It is where the section 49(1) of the act, the assistant commissioner has to proceed with the same as per the rule, frame and other orders hands. If it's where to be a motion of the no confidence motion, the follow the within the section 49(2) of this act, he shall be no discretion to who proceed with the such resolution till rules and frame providing for the procedure to be adopted has the regarding to the such matter of the no confidence motion is observed by the division bench in the Lakshma case. Malod is the para 18 malod is the same contention of the writ appeal malod is there. Once the division bench has the pronounced the authority interpretation till the rules have the frame providing for the procedure to the consider the motion of the no confidence under section 49(2) of the act, it is clear that no such motion of the no confidence motion can be moved. The judgment of the division bench in writ appeal number 844/2018 has the observed the follow. The para 747, here the single judge has the observed that the motion of the no confidence under the subsection 2 of the section 49 should remain the subject matter and the matter for the consideration as per the section 1. The such mode and the method would be only related to the requirement of the numbers of the number of members from moving the motion and for the adopting the resolutions on the basis. However, the procedures and method of the consideration of the motion under section 2 of section 49 shall be provided by the separately prolonging.
The representation,
please, my brother. Malord, as per the annexure C, Malord, there is the here annexure D, Malord. The page number 23, Malord. ಈ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಕಲಬುರಗಿ ಜಿಲ್ಲೆಯ ಹಂದ ತಾಲೂಕಿನ ನರೋಣ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಅಧ್ಯಕ್ಷರಾದ ಗಂಡಹ ಭೀಮಶಾರಾಗಿ ಇವರು ಆಗಸ್ಟ್ 2023ರಿಂದ ಇಲ್ಲಿಯವರೆಗೆ ಅಧಿಕಾರಾವಧಿಯಲ್ಲಿ ಯಾವುದೇ ಅಭಿವೃದ್ಧಿ ಕಾಣದೆ ಇರುವುದರಿಂದ ಪಂಚಾಯತಿಗೆ ಸಂಬಂಧಿಸಿದ ಸದಸ್ಯರನ್ನು ವಿಶ್ವಾಸಕ್ಕೆ ತೆಗೆದುಕೊಳ್ಳದೆ ಹಾಗೂ ಅಭಿವೃದ್ಧಿ ಕಾರ್ಯಗಳಲ್ಲಿ ಸ್ಥಗಿತಗೊಂಡಿದೆ. ಯಾವುದೇ ಅಭಿವೃದ್ಧಿ ಕೆಲಸ ಆಗುತ್ತಿಲ್ಲ. ಹೀಗಾಗಿ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಕಾರ್ಯಗಳ ಮರೀಚಿಕೆಯಾಗಿದೆ. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸದಸ್ಯರು ನಾವು ಸಾರ್ವಜನಿಕ ಕಗ್ಗಣಿಗೆ ಗುರಿಯಾಗಿರುತ್ತೇವೆ.
Why don't you have a look at the judgment of the division bench? So, put it para 48 was. Para 48 was the word.
But kindly the password they pertaining to that period is the senior counsel engagement in the service.
I'll file my objection. This is a covered matter, my lord. What the very recent judgment, my lord, of this very bench, my lord, the allegations to define this as an allegation cannot be construed, my lord, because it is only the reasons why they are moving. There is no allegation as such. What they are in the form number 1, the compliance of form number 1 is done. My lord, requisition and the reasons have been supplied.
Why don't you have a look at para 48 was the word.
42 minutes.
48.
48.
However, he has but the motion of the no confidence indicate decided the interpretation shall be deemed to be those the move under section 1 of section 49 cannot be considered invalid.
So,
please, Malord, there is the
rules frame agilla. 49(2) nalli motion of no confidence, how it has to be taken forward. There are no rules framed. Now, the division bench said, unless the rules are framed, no motion of no confidence based on allegations under 49(2) can be moved. Correct? But the court said, because there is a representation in form number 1, even if there is allegations, it shall be construed as a no confidence under section 49(1). Correct? 49(1) ಪ್ರಕಾರ ಟ್ರೀಟ್ ಮಾಡಬೇಕು ಅಂತ ಡಿವಿಷನ್ ಬೆಂಚ್ ನೋಡ್ ಹೇಳಿದ್ದಾರೆ. Correct? So therefore, how can you now say that no confidence motion cannot be taken out? It shall be construed as it shall be construed as a no confidence motion is for section 49(1). If that is so, then how can you challenge the notice is the question.
But my contention, my lord, has per the some allegations made against the petitioner.
I don't know why you people are not opening. Keep your minds open, mister. Division bench said 49(2) ಪ್ರಕಾರ ರೂಲ್ಸ್ ಫ್ರೇಮ್ ಆಗಿಲ್ಲ. ಸೊ ರೂಲ್ಸ್ ಫ್ರೇಮ್ ಆಗೋವರೆಗೂ 49(2) ನಲ್ಲಿ ನೀವು ಮೂವ್ ಮಾಡಂಗಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಕರೆಕ್ಟ್ ಅಲ್ವಾ? ಡಿವಿಷನ್ ಬೆಂಚ್ ಸೈಡ್ ಇನ್ನು ಮುಂದೆ ರೂಲ್ಸ್ ಫ್ರೇಮ್ ಆಗೋವರೆಗೂ whenever there is a no confidence motion moved, it shall be construed as under section 49(1). ಅದಾದ್ಮೇಲೆ ಒಪ್ಕೋತೀರಾ? At least will you accept this, please? If it is treated as 49(1), the Assistant Commissioner has issued a notice to you on 3/12, fixing a date of no confidence on
What is the 19/12/2020?
19/12.
Please.
So what is the mistake in that notice? ಅಷ್ಟು ಹೇಳಿ ಸಾಕು. What is the mistake in that? ಇದ್ರಲ್ಲಿ ತಪ್ಪೇನಿದೆ ಅಂತ ಹೇಳಿ.
But on view of that, my lord, points, my lord, is the interim orders, the grant the further order ತನಕ, my lord,
ಆಯ್ತು ಮಿಸ್ಟರ್.
at least, my lord,
ಅದೇನಪ್ಪ ನಾವು ಏನೋ ಮಾತಾಡಿದ್ರೆ ನೀವು ಬೇಜಾರು ಮಾಡ್ಕೋತೀರಿ. And you do, I don't know. Yes. The more I say, the yes.
Contention, my lord, as per the respond number 3, my lord, is the court order cannot be given, my lord.
But what prevents them? ಆಯ್ತು, ಇವಾಗ interim order ಆಯ್ತಲ್ವಾ?
Interim order alle subject to the further order of this court.
That is okay. 203733 of 2024 interim order ಆಯ್ತು. Fair enough. Does it prevent the members to give a fresh representation?
No, my lord, he has not given the fresh representation.
ಯಾವುದು?
ಇವ್ರು ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ, entry ಮಾಡ್ರ ಆದ್ಮೇಲೆ ಮಾಡಿಲ್ಲ. Proceed was the initiate against the no confidence meeting, my lord.
Annexure D, is it a fresh representation?
No, my lord, it's the previous representation.
212.
Oh, 212.
212 is a fresh representation.
Fresh representation, not earlier, my lord, a representation was given, and my lord, 203388 of 2014, my lord, annexure page 30. Page 25, annexure E.
Page 25.
Yes, Lord. On the earlier representation, this order came to be passed, reserving liberty to the petitioners. Thereafter, my lord, annexure D is the.
This is 2911.
Yes, madam.
What was challenged in this petition?
The earlier representation requisition dated 8/11/2024.
What happened to this petition?
This writ petition, my lord, came to be allowed, reserving liberty to the respondents. The last paragraph is 46. Representation submitted by 5 to 20. Assistant Commissioner Supra, Respondent Assistant Commissioner shall receive the same and further in accordance with law, including provision of the and so.
ಇದೇನಿದು 203733 ಏನು?
2037. Now they challenge, my lord, the notice issued, my lord, 3/12/2024, saying that this whole ground that was argued earlier was that, my lord, the attestation by the Assistant Commissioner saying that at least 2 members were present and has not been given is not complied with. To which, my lord, we made a submission that if that is the case, we produce the photographs. However, since we cannot dictate the terms to the Assistant Commissioner, she has endorsed. There is a signature of received. Thereafter, my lord, this court directed the government. The Assistant Commissioner filed an affidavit that all the persons who had signed in the requisition were present in my office. And she also attached, because it is her office photograph which was taken. Then she says they have personally present. Now, at that point of time, my lord, the interim order was rejected. And in fact, writ petition was being dictated for disposal. Then learned senior counsel, my lord, submitted that they want to argue on the point of 49(2) omission, the effect and consequence of which. Thereafter, what the court, my lord, it let to subject to result anta heli, a subject result and further consideration.
No confidence ಆಗಿದೆಯಾ?
No confidence agi, election agi, ಹೊಸ ಅಧ್ಯಕ್ಷ ಬಂದಾಗಿದೆ. Now, the newly elected majority Adyaksha is there.
Argument ಮಾಡ್ರಿ.
The only ground now they want to take is, my lord, with that these are allegations. On the very first day we have made.
Argument ಮಾಡ್ರಿ.
My lord, is the interim order is the granted, my lord, is the 18/12/2024, my lord.
ಹೌದು.
ಅದ್ಮೇಲೆ, my lord, is the further procedure was the initiated by the respondent number 3. Further proceeding initiate ಮಾಡಿದ್ದಾರೆ. Meeting was the held by the third respondent.
second writ petition is filed.
My lord, as per the annexure H, my lord, there is proceedings.
I think what is the, the coordinate bench of this court said,
Reasonable.
all proceedings pursuant to this notice shall be subject to the outcome of the writ petition.
No, but it is the further order ಅಂತಿದೆ sir.
ಓದಿ ಏನು?
ಅದು complete ಓದಿದ್ರೆ ಅದನ್ನೇ treat ಮಾಡ್ತಾರೆ.
Would be subject to further orders of this court and final outcome of this petition.
Please, my lord, that is.
So therefore, please argue.
My lord, as per the further order, my lord, has the has not passed any, my lord, has the to asking by the third respondent. If the proceed to the, my lord, is the meeting was the held, and my lord, the new president was the election was the conducted, my lord.
Seri, argue on merits, that is what I am asking you. The court said, any proceedings held pursuant to the impugned notice
Please.
would be subject to further orders of this court. ಅಂದ್ರೆ ಈ ಕೋರ್ಟ್ ಏನಾದ್ರು ಸೆಟಿಸ್ಫೈಡ್ ಮಾಡಿದ್ರೆ ಮಾಡಬಹುದು ಆ ಗ್ರೌಂಡ್ ಮೇಲೆ ಇದ್ರೆ argue
But
ಮಾಡಿ.
the previous, my lord, has the only the base of the allegations, my lord, the rules was the not applicable in this case, my lord, that is.
I don't know, either you are confused or you are trying to confuse me.
No, my lord, there is, as per the coordinate bench judgment, my lord, on base we are the
ಏನು coordinate bench ಕೊಡಿ ಏನು?
put it.
ಯಾವುದು? You mean this judgment? ಏನ್ ಹೇಳ್ತಿದ್ದು? What do you want to?
My lord, is the para 22 and my lord, there is the.
Para 22. ಓದಿ.
My lord, the 21 is the notice. The observation has the regarding to the consequence of the motion of no confidence motion has the refer to in the para number 48. The division bench judgment must be constructed to the applicable has the regarding the motion of no confidence motion moved under section 49(2) of this act will be where the pending consideration has on the date of the pass of the order in the division bench and cannot be extended to the applicable as regard the motion of no confidence that were to be moved with the allegations. Those the relevant to the section 49 of the act even after the judgment of the division bench. Hence, it is the clearly that it is the just not possible to the treat as a petition filed under section 49(2) after the disposal of the writ appeal on the under section 49(1) of this act. The given the prima facie, there has to be specific allegations made by the members. The motion must be deemed to be one moved under section 49(2) of this act in the absence of the matter specifying has to the whether it is the motion is the moved under section 49(1) or 49(2) of this act. Given the observation of the division bench in para number 43, related to the become necessary has to these allegations a task which is not possible given to the absence of rules. The respondent members have the offered to given allegations how to who only option to open to the member to to the fresh notice according the writ petition is allowed and by the set aside the order dated annexure Z with the liberty to the member to move the fresh notice under section 49 of one act.
ಈಗ paragraph number 48 of the division bench judgment, whether it was considered by the coordinate bench. Was it considered? ಹಿಂಗಂದ್ರೆ considered
But is the 22 ನಲ್ಲಿ consideration ಮಾಡಿ
ಅಲ್ರಿ ಇವಾಗ ಅದು ಲಕ್ಷ್ಮಮ್ಮ ಜಜ್ಮೆಂಟ್ ನೋಡಿದ್ರಲ್ವಾ 48 ಓದಿದ್ರಲ್ವಾ ಏನ್ ಅರ್ಥ ಆಯ್ತು ಹೇಳಿ
ಅದರಲ್ಲಿ 49(2) ನಲ್ಲಿ ಕೊಟ್ಟಿದ್ದನ್ನೇ 49(1) ನಲ್ಲಿ ಟ್ರೀಟ್ ಮಾಡಿ ಇದು ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳಿ
ಇನ್ನೊಂದ್ಸತಿ ಓದಿ ಫಾರ್ ಯುವರ್ ಸ್ಯಾಟಿಸ್ಫ್ಯಾಕ್ಷನ್.
Held by the mention of the no confidence motion is the decided petition shall be to those moved under section 1 of the section 49 cannot be considered invalid ಅಂತ ಮಾಡಿ.
ಇನ್ನೊಂದ್ಸತಿ ಓದಿ ಪ್ಲೀಸ್, ನಿಧಾನಕ್ಕೆ ಓದಿ ಗಣೇಶ್ ನಾಯಕ್
ಪ್ಲೀಸ್ ಮೇಡಮ್.
So now we please go to section, paragraph number 17 of this judgment.
Please.
Once the division bench has pronounced the authoritative interpretation that till rules are framed, providing for procedure to consider motion of no confidence under section 49(2), it is clear that no such motions of no confidence can be moved. Correct? The judgment of the division bench in writ appeal 844 of 2018 has observed as follows. Where the learned single judge has observed that the motion of no confidence under subsection 2 of section 49 would remain subject to mode and method for its consideration as per subsection 1. Such mode and method would only relate to the requirement of the number of members for moving the motion and for adopting the resolution on that basis. However, the procedure and method for consideration of motion under subsection 2 of section 49 shall have to be provided by separately promulgated rules, and any such motion under 49(2) cannot be proceeded under the rules of 1994, even as amended by notification dated 21/8/2018. Hence, it is clear that a motion of no confidence is, if sought to be moved with allegations, cannot be resorted to till rules are framed, providing for the procedure to be followed as regards motion of no confidence under section 49(2) of the Act. So therefore, where has the coordinate bench considered para 48 of the division bench judgment in Lakshmama? I was there when the matter was argued before the division bench. The issue was rules were not framed. So thereafter rules were framed, but a date of coming into force of the rules was not fixed. Then it was withdrawn. Then writ appeal 844 was filed. In writ appeal, this is the finding. But Lakshmama case, where is it? Whatever in paragraph number 48. Has the coordinate bench of this court referred to para 48? If that is so, then how is your writ petition maintainable? It shall be treated as 49(1) only. Then?
Only on that ground, my lord, we are the.
Stena, close ಮಾಡ್ಬೋದಾ?
But my lord, there further order ಅಂತಿತ್ತು ಅದಕ್ಕೆ ಬಿಟ್ಟಿರೋದು ಬೇರೆ. That is the only one ground, my lord.
Close ಮಾಡ್ಬೋದು ಅಂದ್ರೆ ಮಾಡ್ತೀನಪ್ಪ. ಮಾಡ್ಬೋದು ಅಂದ್ರೆ.
ಅವ್ರು ಹೇಳ್ತಾರದು ದಿ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್, ದಿ ಇಂಟ್ರಿಮ್ ಅರೇಂಜ್ಮೆಂಟ್ ಅಂತ ಹೇಳಿ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಟಿಲ್ ಸಬ್ಜೆಕ್ಟ್ ಟು ರಿಸಲ್ಟ್ ಆಫ್ ಸಬ್ಜೆಕ್ಟ್ ಟು ಫರ್ದರ್ ಆರ್ಡರ್ಸ್ ಅಂಡ್ ಫರ್ದರ್ ರಿಸಲ್ಟ್ ಆಫ್ ದಿಸ್ ರಿಟ್ ಪಿಟಿಷನ್ ಅಂತಂದು ಅದಕ್ಕೋಸ್ಕರ ವಿ ಆರ್
which is what is 30.1?
Apart from that,
the same number, the second one petition is the previous petition, 200733. They are subject to result of interim order was they granted.
203733 alone. In WP number 203733 of 2024, the petitioner has challenged the notice dated 3/12/2024 issued by the respondent number 3, convening a meeting of the members of the Panchayat on 19/12/2024 to consider a motion of no confidence against the petitioner. Full stop. In WP number 203970 of 2024, the petitioner has sought for quashing the proceedings held on 19/12/2024 by the respondent number 3 and the notice issued by the respondent number 4 for conducting the elections to the post of Adhyaksha of the Panchayat. Next para. The facts in brief are that the petitioner was elected as the president of Narona Gram Panchayat. Full stop. The Narona Gram Panchayat. Full stop. After the petitioner completed the minimum tenure as the president, about 14 members of the panchayat out of 20 submitted a representation on 2/12/2024 alleging that there were no development works during the tenure of the petitioner and that she was functioning as president without taking the members into confidence. It was also alleged that all development works in the panchayat limits was a mere mirage, which had resulted in the members facing the wrath, WRATH, of the general public. With these, they submitted, with these they requested the respondent number 3 to convene a meeting of the members of the panchayat to consider a motion of no confidence. Full stop. Accordingly, the respondent number 3 issued a notice dated 3/12/2024 proposing to hold a meeting of the members of the panchayat on 19th December 2024. Full stop. The petitioner challenged the said notice in WP number 203733/2024. Full stop. This court passed an interim order on 18/12/2024 stating that all further proceedings, pursuant to the notice dated 3/12/2024 would be subject to further orders of this court and final outcome of the writ petition. Full stop. Next para. Since there was no stay of the meeting dated 19/12/2024, the meeting was convened and a no confidence motion was successfully moved against the petitioner. Full stop. Following this, the office of the president fell vacant. President of the panchayat fell vacant. And therefore, the respondent number 3, respondent number 4 took steps to conduct the elections to the post of Adhyaksha of the panchayat. The petitioner therefore has challenged the meeting or the proceedings of the meeting held on 19/12/2024, as well as the notice issued by the respondent number 4 to conduct elections to the post of Adhyaksha of the respondent number 5 panchayat. Full stop. Next para. The learned counsel for the petitioner submitted that when this court in WP number 203733 of 2024 had directed that all proceedings pursuant to the notice dated 3/12/24 shall be subject to further orders of this court and final outcome of this petition, the respondent number 4 could not have taken any steps to conduct elections to the post of Adhyaksha. Full stop. He further contends that the notice dated 2/12/2024 contained allegations against the petitioner, and therefore, in the absence of any rules framed, and therefore, the request for no confidence should be treated as one filed under section 49(2) of the Act. And in view of the judgment of the division bench of this court in writ appeal 844 of 2018, which was followed by a coordinate bench of this court in writ petition 50210 of 2018, the no confidence could not have been held against the petitioner. Ashtena? Full stop. Per contra, the learned counsel for the private respondents, namely the members of the panchayat, submit that the representation merely contained the reasons for the petitioners moving a no confidence motion. He therefore contends that it cannot be construed as an allegation against the petitioner, and therefore the representation filed by the members of the panchayat cannot be treated as a request for no confidence under section 49(2) of the Act 1993. Anything else? He further submits.
The reasons anta held consider ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ
Huh?
No law laid down my lord. Very.
In support of this contention, comma, relied upon
reasons.
a judgment of a coordinate bench of this court in WP number 203258 of 2022. Full stop.
Para 7 last on perusal of form number 1, in addition to complying the basic requirement in form number 1 enumerated the rule, would also disclose the reason as to why response 6 to 17 are not having confidence in the response. That is the reason. That is.
That is nothing but an allegation. I don't know.
The allegation is where there is a misconduct or mismanagement.
Astera, anything else? He further
That is in
submits that no confidence motion was successfully held against the petitioner on 19/12/24 and a new president is elected. Agidya? New president is elected who was taken charge.
Yes, ma'am. On 3/1/2025.
On 3/1/2025. He therefore submits that this writ petition is not maintainable. Next, the learned AGA also supported the contentions of the learned counsel for the private respondents. Next para. The division bench of this court, while considering the right of the members to move a no confidence motion under section 49(1) and 49(2) of the Karnataka Gram Swaraj and Panchayat Raj Act 1993 held that no rules are framed by the state government to enable the authorized officer to hold proceedings to conduct a motion of to consider a motion of no confidence when members make allegations against the Adhyaksha and Upadhyaksha. Full stop. Therefore, it held that there can be no motion of no confidence by the members if it is based on an allegation against the Adhyaksha and Upadhyaksha. However, it held that the motions of no confidence shall be deemed to be those moved under subsection 1 of section 49 and cannot be considered invalid. Full stop. No doubt, as contended by learned counsel for the petitioner, comma, the division bench in writ appeal 844 of 2018 had held full stop. Therefore, comma, no doubt, therefore, comma, until rules are framed by the state government regarding the manner of considering a motion of no confidence by the members against the Adhyaksha and Upadhyaksha, comma, no member can move a motion of no confidence on the no confidence on the ground by making allegations against the Adhyaksha and Upadhyaksha. However, in view of para 48 of the judgment of the division bench of this court in Lakshmama versus State of Karnataka referred supra, such motions of no confidence shall be treated as one moved under section 49(1) of the Act 1993. Full stop. if the aforesaid exposition of law is considered, then the representation in the instant case filed by the members has to be construed as one filed under section 49(1) of the Act 1993. The respondent number 3 is therefore right in issuing a notice dated 3/12/2024, proposing to hold a meeting of the members on 19/12/2024. Full stop. Therefore, there is no error in the procedure adopted by the respondent number 3 in holding the no confidence motion meeting, or in holding the meeting, convening the meeting on 19/12/2024, warranting interference in WP number 203733 of 2024. In view of the above, the challenge to the notice dated 3/12/2024 has to fail. Consequently, writ petition 203733 of 2024 is dismissed. Since the respondent number 4 has already taken out proceedings to elect the Adhyaksha of the Panchayat, the challenge to the same in WP number 203970 of 2024 is also liable, should also fail. Consequently, WP number 203970 of 2024 is also dismissed.
Please. Similar, just for my note, similar view is taken by my lord on 7th January 2025. The Harvard bench my lord that on 49(2) eschewed ಮಾಡಬಿಡಬೇಕು ಅದು ಏನಾದ್ರು allegations ಅಂತ consider ಮಾಡಿದ್ರು it has to be eschewed.
That is what the division bench has said.
Yes.
Liaquat Fareed Ustad.
For petitioner, my lordship. Challenging the annexer B. B is the undated order.
Annexer?
B, my lordship, in page number 15. Without notice, without following the due process of law, in my land, government name was entered, my lordship. Only on the basis of Tahsildar report, my lordship. Is covered by judgment, my lordship.
Yes, ma'am. Workhold. The petitioner is challenged an order dated so and so, sorry, mailed notice ಆಗಿದ್ಯಾ?
ಇಲ್ಲ. I will take notice for
AG
respondent.
is directed to accept notice for the respondents. The order sheet will mind, no? Main order. The petitioner is challenged an order dated, order bearing number so and so dated nil-02-2020, passed by the respondent number 1. Number, insofar as it relates to the petitioner. The petitioner has also sought for a direction to the response 192, 193 to restore the names of the petitioner in the record of rights and other revenue records. Next para. The petitioner contends that he is the owner of land bearing survey number 99 of Yarandi village, Rajeshwar Hobli.
Yes.
Basu Kalyan Taluk and district. Full stop. He contends that the respondent number 1, without issuing any notice and without following the due process of law, directed the respondent number 3, 2 and 3 to cancel the khata that stood in the name of the petitioner and enter the name of the state government. Full stop. The petitioner contends that the impugned order was not communicated to him. However, after the COVID-19 lockdown was lifted, he came to know that his name was deleted from the revenue records and the name of the state government was entered. The petitioner is therefore before this court challenging the said order. The learned counsel for the petitioner submits that in similar circumstances, This court in WP number 200937 of 22 and 201500 of 2022 had quashed the orders and directed the respondents 1 and 3 to restore the revenue records. Full stop. He therefore submits that similar order be passed in the present writ petition 2. Full stop. The learned AGA does not dispute the fact that the impugned order is passed without hearing the petitioner and without providing an opportunity of being heard. In that view of the matter, this petition is allowed. The impugned order passed by the respondent number 1, bearing number so-and-so, dated so-and-so, is quashed. Full stop. The respondents 2 and 3 are directed to restore the name of the petitioner in the revenue records of the aforesaid land within a period of 3 months.
6 months.
6 months from the date of receipt of a copy of this order. It is, however, open for the respondent number 1 to take out proceedings against the petitioner in accordance with law, and after giving him an opportunity of being heard. Full stop. Yes. The learned AG is permitted to file a memo of appearance within 10 days. Yes. Yes.
The Annexure C is the order which is challenged and endorsement given by the sub-registrar refusing to register the document by quoting a reference of DRT order letter wide Annexure A, as per which there is an attachment of the property in question. And as such, it is entered in their computer system, so gift deed cannot be registered. That is the endorsement given by. Annexure A may kindly be seen.
Yes.
Annexure A is the letter written by the recovery officer to the sub-registrar, Raichur. In the Annexure A, my lord, enclosed is an attachment order dated 15/12/2020 issued by the recovery officer, Debt Recovery Tribunal, Coimbatore, in respect of the property situated in Siyatala, Raichur, in approved layout of survey number so-and-so of Raichur, which area is falling under your jurisdiction. So-and-so. This attachment has been made in execution of a recovery certificate number so-and-so, dated so-and-so, issued under section 19 so-and-so by the presiding officer, Debt Recovery Tribunal, Coimbatore, in terms of the orders in TA number so-and-so, so-and-so for non-payment of debts due to the applicant. It is requested that you may kindly make necessary entries in respect of scheduled property in the relevant registers maintained by you. The action taken by you may please be intimated to this tribunal in due course.
Yes.
So the order of attachment is Annexure A1.
Yes.
Lord, though it is titled as order of attachment, it is not an order of attachment. So that Annexure A letter is a misconstrued letter. Kindly see this letter. Parties' names are there. We are not parties to it, my lord.
You are not parties, Chandra?
No.
But what is the subject property?
Subject property is a site number 5 situated in Raichur, my lord.
Sulochanamma. How did Sulochanamma get this property?
That I have stated in my list of events in a synopsis, my lord. On 8/4/1985, this plot in question, plot number 5, my lord, was purchased by one Ramesh Rati, my lord. He sells the said property to one Srimati Sudha in 2001, my lord. Then, my lord, Sudha sells the said plot to one U. Venkatrama Reddy and Mallanna Gowda Devareddy in 2014, my lord. My lord, Venkatrama Reddy was the owner of site number 6, my lord. He gives his undivided half share in favor of Mallanna Gowda in 2015, my lord. The above, then my lord, both the properties were joined together and a construction permission was taken and a big hospital building is constructed there in 2005, my lord, 15. 8 crores loan was taken. Construction was completed in 2016. Then my lord, this, the order of attachment, so-called, which I have read. Then my lord, in 2021, mortgage loan was cleared. In 23, on 30th 1, 2023, Mallanagowda gifted his undivided share in the above constructed property to the petitioner herein, his son, my lord, Vijay Kumar. Then, my lord, when Vijay Kumar wished to gift it to Sulochana, when it was presented, this endorsement came to be issued. So, my lord, this, the sub-registrar has misread the annexure A letter and has
But plot number 5 is what is mortgaged.
Pardon, my lord?
Plot number 5 is what is mortgaged.
My lord,
You're also wanting to execute a gifted in respect of plot number 5 only.
ಅಲ್ಲ ಸಾಹೇಬ್ರೆ, ನಾನು ಅನ್ನೋದೇನು ಗೊತ್ತಾ, ಈಗ ವೆದರ್ ಇಟ್ ವಾಸ್ ಮಾರ್ಟ್ಗೇಜ್ಡ್ ಆರ್ ನಾಟ್, ವಾಟ್ ಹ್ಯಾಪನ್ಡ್ ದೇರ್, ಎಟ್ಸೆಟ್ರಾ, ಬಿ ದಟ್ ಆಸ್ ಇಟ್ ಮೇ, ದೇರ್ ಆಫ್ಟರ್ ಮಚ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್ಸ್ ಹ್ಯಾವ್ ಟೇಕನ್ ಪ್ಲೇಸ್. ಈಗ ಇದನ್ನ ಗಿಫ್ಟ್ ಮಾಡ್ತಾ ಇರೋದು, ಈವನ್ ಆಫ್ಟರ್ ದಿಸ್ ಸೋ ಕಾಲ್ಡ್ ಆರ್ಡರ್ ಆಫ್ ದ DRT, ರಿಕವರಿ ಆಫೀಸರ್ ಆರ್ಡರ್, Mallanagowda has gifted to Vijay Kumar, that is registered.
Yes.
ಈಗ ಅದು ಮದಾರಿಗೆ ಮಾಡಕೈತಿವಿ ಅಷ್ಟೇ.
Make this SPA as a party.
Pardon me?
Please include SPA as a party. Yaar is State Bank of India.
State Bank of India.
ಅವ್ರನ್ನ party ಮಾಡಿ. How can you take away an order without even noticing, without even notice to State Bank of India? ಅವ್ರನ್ನ party ಮಾಡ್ಬೇಕಲ್ವ? They should be heard. Barcode, learn counsel for the petitioner.
ಅಲ್ಲ, orally permit
is permitted to, sorry, on perusing the records, the document submitted by the petitioner for registration was refused on the ground that there is an order of attachment in proceedings initiated by State Bank of India, SARB Coimbatore, full stop. In that view of the matter, it is appropriate that State Bank of India is heard in this petition before any order is passed. Consequently, the learned counsel for the petitioner is permitted to implead State Bank of India, SARB Coimbatore as respondent number 2 in this petition. SPI Gyaro, Mr. Manvendra Reddy is directed to accept notice for the respondent number 2.
Please.
Yes.
Lordships, in this matter, I filed wakalat for respondent number 5 yesterday. The name may be shown in the first list.
The learned counsel for the respondent number 5 seeks time. List, sorry, what is your name?
R.S. Siddhapurkar.
Mr. R.S. Siddhapurkar has entered appearance for the respondent number 5. Full stop. The learned counsel for the respondent number 5 seeks time to file objections to the writ petition.
Your copy of the writ petition may be
You can
served.
ask him, he will
I've
give
informed.
list on. When do you want it?
Next week we need it.
Yes, next.
Obliged.
There is an interim order operating.
Interim order granted as extended till the next date.
Here for the petitioner is petitioner is seeking relief of mandamus, my lords. On last date of hearing, the government advocate were directed to get instructions in the matter, my lords.
My lord, it is payment of compensation amount, my lord. Already they have filed EP, my lord.
Earlier, execution petition was filed, my lords, and the amount was also 50% of the amount was directed to
The order
deposit.
filed in execution, how can you seek for
And now
mandamus?
it is-
One submission, my lords.
Ah.
Thereafter, my lords, kindly peruse annexure F, page number 61, my lords.
61.
Yes, my lords.
Ah.
As per the, after filing of the execution petition, my lords, they had issued 50% of the amount to be deposited in these 3 cases, my lords. Subsequently, my lords, annexure H came to be passed, my lords, and the amount was again reverted back stating that the annexure H, page number 69, my lords. The amount was sent back stating that the minor irrigation project, that particular project is not handed over by the PWD to the minor irrigation department.
So whatever it is, there's an award in your favor.
That is there, my lords, but
Execute it.
the minor irrigation department, my lords, who,
ಯಾರೋ ಅವ್ರು ತಂದು ಕೊಡ್ತಾರೆ, why are you worried?
no, here is the case, my lords, wherein in LACA, my lords, the minor irrigation project, minor irrigation was implemented, my lords, stating that, my lords, PW department has handed over the project to the minor irrigation department, my lords. Now, my lords, earlier they have deposited, they have agreed to deposit the amount, my lords, everything was done and they were about to deposit, my lords. And immediately annexure H came to be passed, my lords, they have dispersed the, reverted back the amount and adjusted in some other thing, my
ಇಲ್ಲಿ
lords.
award ಎಲ್ಲಿದೆ? Execution ಎಲ್ಲ ಹಾಕಿದ್ದಾರೆ.
Execution, my lords, annexure D is the judgment, my lords, of the appellate court, my lords.
Annexure
Annexure D, my lords, page number 41.
and you already filed execution.
Yes,
E,
my
my
lord.
lord, page 57.
Proceed in execution.
Now, the hurdle would be the annexure H, my lords, by virtue of which, my lords, they have reverted back the amount stating
Annexure
that the
H.
project is not at all handed over.
Correct. Annexure H, you are not concerned whether project is handed over or not.
Yes,
The land is taken over from you.
yes, my lord.
Therefore, you entitled for compensation.
Yes.
So why are you worried whether it is taken over, not taken over? Why are you worried?
Since the sanctioned amount was about to be deposited in the court, my lord, it was reverted back.
They will make steps, ನೀವು attachment ತಗೊಂಡೋಗಿ or office-ಗೆ. You take an attachment warrant against their office, they will deposit. ಅವ್ರು ಎಲ್ಲಿಂದ ತರಬೇಕೋ ಹೆಂಗ್ ತರಬೇಕೋ ಅದು ಅವ್ರು ಮಾಡ್ಕೋತಾರೆ. Why are you worried?
I have submitted subsequent to annexure H, my lords, I have submitted representation also, my lords. Because Assistant Commissioner now, my lords, he himself is seeking as to whom the letter is to be forwarded for the deposit of the amount, my lords. That is why I have submitted the
Steps
representation.
forward. The petitioner,
My lords, kindly peruse the representations of my, I have written representation to the Assistant Commissioner as well as the PW department as well, my lords.
yes.
Let that also be considered, my lords. I am only asking them as to from whom the measures are to be taken for the deposit of the amount, my lords. The representations I have submitted by annexure J, my lords, J, K, L. L2 and L3 also, my lords.
You please select one bunch of letters.
Yes, my lords. Annexure L1 to L3, my lords.
Yes, government. Consider pass appropriate orders. ಯಾರು ಕೊಡ್ಬೇಕು ಅಂತ ಡಿಸೈಡ್ ಮಾಡ್ಕೊಳ್ಳಿ ನೀವು.
Yes.
Hmm? And from 2020, you're simply keeping quiet after filing an execution petition.
No, my lords, I have taken several steps, my lords. After having issued the annexure H, my lords, now I am being made to run from pillar to post, my lords. That is why I have submitted.
You run, mister, why do you run? They have to run.
The Assistant Commissioner is directing me to submit as to whom the recovery is to be issued, my lords.
Your SLAO is the acquisition officer.
Yes, my lord.
Take an award against him. Take a warrant against him. Engineer, executive engineer, ಅವ್ರ ಮೇಲೆ ವಾರಂಟ್ ತಗೊಳ್ಳಿ. ಅದ್ ತಗೊಳದ್ಬಿಟ್ಟು ಸುಮ್ನೆ unnecessary wasting time. ತಿರ್ಗಾ ನೀವು ಅಲ್ಲೋಗಿ ಅವರು ಅಲ್ಲೋಗಿ ಗೌರ್ಮೆಂಟ್ ಹೋಗಿ ಮಿನಿಸ್ಟರ್ ಹತ್ರ ಹೇಳಿಸಿ. There will be no end to it. Take an attachment warrant against the executive engineer. ಅವ್ರು ಡಿಸೈಡ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಅವ್ರು ಯಾರು ಕೊಡ್ಬೇಕು, ಏನ್ ಮಾಡ್ಬೇಕು, they will decide.
Please.
Unnecessarily you're wasting time. 20ನೇ ಇಸ್ವಿ.
Yes, my lord. Since there was repeatedly problem, my lords, letters were issued, my lords, corresponding letters were issued between them, my lords.
And you have come 2/12/2024 ಗೆ ಅರ್ಜಿ ಕೊಟ್ಟಿದ್ದೀರಿ.
Yes, my lords.
ಇನ್ನ ಇಂಕೆ ಒಣಗಿಲ್ಲ.
Earlier to that, my lords, there is annexure K, my lords, 18/1/2024, my lords.
Yes.
Annexure H, my lords, 26, annexure J, my lords, 27/2/2024, my lords. I have repeatedly persuading the matter, my lords, for the deposit of the amount, my lords. Since
Take out notice, workout. We take out a warrant against the respondents. The petitioner is before this court seeking for writ in the nature of mandamus to consider the representations dated 27/2/2024, Exhibit J. Comma K and K1. And dated 2/12/2024, bracket, annexure L, L1 to L3. And annexure J is 27/2/24.
Yes.
Comma, annexure K and K1 dated 18/1/24. And annexure L, L1 to L3 dated 2/12/24. Next paragraph. The petitioner contends that the respondents, it contends that his land was acquired by the respondent number 1, following which an award was passed, which was referred to the additional civil judge Gulbarga in LAC 31/1985. Full stop. It is contended that the respondent number
3 minutes.
5 had deposited the award amount, which was withdrawn by the petitioner. Thereafter, the petitioner filed an appeal.
No minutes. The amount was deposited by the, yes, minutes.
And thereafter, the petitioner filed an appeal under section 54 bracket small 2 of the Karnataka Land Acquisition of the Land Acquisition Act 1894.
Please.
The appellate court passed an order, passed a judgment enhancing the compensation to a sum of rupees 1,19,650 per acre. The petitioner filed the execution petition
Notes annexure.
188 of 2050. Full stop. After receipt of the notice in the execution petition, the respondent number 2 sent a requisition to the state government to release the award as per the judgment of the appellate court. The state government took out proceedings for release of 50% of the amount as per the judgment of the appellate court. Full stop. The respondent number 6, in terms of his communication dated 26/2023, returned the amount so sanctioned by the state government on the ground that the acquisition did not belong to his division and sent it back to the respondent number 1. Full stop. After return of the sanctioned award amount, the petitioner submitted a representation to the PWD department to consider and take appropriate decision to deposit the award amount. The petitioner contends that since the same was not done, he submitted a representation to the respondent number 4 and 5 on 18/1/24, which too did not bear any fruit. The petitioner therefore submitted a further string of representations to the respondent number 4,
3, 4, 5, 7.
3, 4, 5, 7. Since the same, on 2/12/2024. Since none of these representations were not considered, the petitioner has approached this court for a direction to the respondents to consider the representations. Next paragraph. The learned counsel for the petitioner reiterated the above contentions and contended that the respondent number 3, the executive engineer of, respondent number 6 had returned the amount that was sanctioned by the state government And therefore, the respondents are in a fix as to whom the amount has to be forwarded to be deposited before the executing court. He therefore contends that suitable directions be issued to the respondents to consider the representations as stated above. For contra, the learned AG has submitted that the petitioner has already initiated execution proceedings, and therefore there is no need for execution proceedings to execute the award passed, enhancing the compensation payable to the petitioner. Therefore, he contends that there is no need to issue any writ, prerogative writ to the respondents to consider the representations submitted by the petitioner. Next paragraph. If the land of the petitioner is acquired and compensation is now enhanced by the appellate court, and if the petitioner has already filed the execution petition to execute the judgment and decree enhancing the compensation, the petitioner cannot compel the respondents to consider representations filed. Full stop. If at all the petitioner is interested to recover the compensation, he has to obtain an order of attachment of movables in the office of the respondent number 567, and proceed in accordance with law. Full stop. He cannot seek for a direction to the respondents to consider some representations filed and compel them to deposit the amount before the executing court. In that way of the matter, this writ petition is, no intervention is warranted in these writ petitions, and no direction can be issued to the respondents to consider the representations of the petitioner. Hence, the petition is disposed of, reserving liberty to the petitioner to take such steps as are available to him in law in the execution petition filed by him. Full stop. Yes.
That's one sentence, my lords.
Hmm.
One sentence could be added, my lords, regarding the project was handed over from the PWD department to the minor irrigation. That sentence to be added.
Why are you bothered? I don't understand.
The reference court is not, the executing court is not taking any steps, my lords, even after giving process also, my lords.
So you get a warrant, they will decide interstate. One warrant ತಗೊಂಡೋಗಿ movables warrant. Our decide ಮಾಡ್ತಾರೆ ನಿಮ್ಗೋ ಅವ್ರು ಕೊಡ್ಬೇಕು ಇವ್ರು ಕೊಡ್ಬೇಕು. The confusion should be there. You are creating confusion for yourself.
No, that's after in 2023, since the amount was reverted by us, all the confusion
The
started.
reason
in
why
this
I am
part.
telling you this.
Please,
Today, if I issue a direction,
please.
then the respondents will say that the petitioner has gone to the court and obtained some direction. So until that is decided, we cannot take any steps. The amount will get stopped. They will not deposit the money. At least on warrant ತಗೊಂಡೋಗಿ. Take a warrant. This next.
Next matter. also
Next matter, next and 70, serial number 70,
Serial number 35, huh?
35 and serial number 70, my lords, all
35 and 70, same order.
please,
So all of the matters at 2:30.
please.
61, it will be taken tomorrow.
Huh?
61, we are getting it to compromise. Tomorrow it may please be taken. Both father and children. 61, they are coming here.
ಯಾವತ್ತು ಬೇಕು?
Respond number 4 and 5 not, respond number 4 is bedridden, cannot come to the court.
What do you want?
No, one day adjustment. We will get it compromised. One day, tomorrow you can keep it,
ಯಾವತ್ತು ಬೇಕು ತಗೊಳ್ಳಿ.
please.
My lord, on submission,
61. ಇದು ಒಂದ್ ವೀಕ್ ಕೊಟ್ಟರು ಒಳ್ಳೆದು. ಇಲ್ಲಿ ಬನ್ನಿ. ಇಷ್ಟೇ ಇಲ್ಲ ಸರ್.
Serial number 41, Your Lordship.
41.
Please, ma'am.
Ah,
I have filed a memo for posting today, Your Lordship. Senior counsel is engaged. Your Lordship, Supreme Court matter has been reached today, so kindly it may be taken up tomorrow, Your Lordship, in view of urgency.
serial number 41.
Please, ma'am.
It's already adjourned.
No, it's not urgent.
Please wait then.
Your Lordship,
Take it up.
Supreme Court matter is reached in a Supreme Court. Senior counsel is held up in that matter, Your Lordship.
Yes, correct.
Still number 75, my lord, yesterday's matter.
Hmm.
My lord, the government was directed to get instructions. My lord, elections are tomorrow.
Yeah, the elections here.
Yes, my lord. It has
Yeah,
served
what
on
is, what is the
8
issue?
one.
Put it there, 75, put it.
My lord, on submission,
Ah,
serial number 66, my lord, petition for seeking parole, my lords. My lords may remember,
ah,
government has been directed, my lord, hence I am filing a memo for withdrawal.
please wait, mister.
Obliged, obliged.
But
Again, what is the issue?
I have challenged, my lord, the notice issued for, my lord, being no confidence.
Hmm.
On the ground that, my lord, 15 days clear notice is not provided.
What is the date of notice?
My lord, notice dated 4/1/2025 at annexure A, page number 11.
Hmm.
My lord, it is served on 8/11/2025 by, my lord, the development officer.
Yes.
My lord, it is served on 8/1/25, my lord.
Ah,
Within 15 days, my lord. Petition may be allowed.
these are the private respondents.
Yes, sir. Ganesh Naik is okay.
Ganesh Naik,
Please, minutes. But all their respondent, my lord, is served on, my lord, the 6th, my lord.
but in the 8th ಅಂತ ಹೇಳ್ತಾರೆ.
But
ಎಲ್ಲ
the
present
petitioner,
is-
president is the
ನಮಗೆ 8th ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದಕ್ಕಾಗಿ ನಾವು ಸರ್ಟಿಫೈಡ್ ಕಾಪಿನೂ ಅಪ್ಲೈ ಮಾಡಿದ್ವಿ.
ಬರ್ಕೊಳ್ಳಿ. The
My lord,
petitioner
submission.
being the president of Gram Panchayat Kale Belagunda has filed this petition challenging the notice dated 4/1/2025 issued by the respondent number 3, proposing to hold a meeting of the members of the Panchayat on 22/1/2025 to consider the motion of no confidence. Next para. The petitioner contends that she was elected as the president of the Panchayat. And later, Panchayat, after she completed the minimum tenure, after she completed the term of 16 months, a representation was filed by the members of the Panchayat expressing lack of confidence, following which the respondent number 3 issued a notice dated 4/1/2025, convening a meeting of the members on 22/1/2025 to consider the motion of no confidence. The petitioner being agreed with the said notice is before this court. The learned counsel for the petitioner submits the notice of the notice in form number 2 was served on the petitioner only on 8/1/2025, and therefore there was no clear 15 days notice as contemplated under Rule 3(2) of the rules 1994. Full stop. He contends that the notice was served on 8/1, I held the mail. He contends that the impugned notice is therefore liable to be quashed in view of the judgment of the full bench of this court in Puttaswamy versus State of Karnataka. Full stop. Full stop. The learned counsel for the private respondents. Puttaswamy versus Srimati Prema, 1992 SCC online Karnataka. The learned counsel for the private respondents, on the other hand, contended that notice of the meeting was served on the members on 4th,
6 month.
on 6th, 6/1/2025. And therefore, it is contended that the meeting scheduled on 22/1/25 is in compliance with Rule 3(2) of the rules 1994. Next, this court, in terms of the order dated so and so, directed the learned AGA to secure instructions as to when the notice was served upon the petitioner. Accordingly, the learned AGA today submits the notice was served on the petitioner on 8/1/2025. Full stop. If the above submission is taken into account, the notice is served, taken into account, there is no clear 15 days notice on the petitioner as provided under Rule 3(2) of the rules 1994. Full stop. As rightly contended by learned counsel for the petitioner, the full bench of this court in Puttaswamy's case referred supra had held that compliance of an analogous provision under section 47(3) of the so-and-so Act is mandatory. Full stop. In that view of the matter, the impugned notice issued by the respondent number 3 is liable to be quashed. Hence, the writ petition is allowed. The impugned notice dated 4/1/25 is quashed. It is, however, open for the private respondents to take out fresh proceedings in accordance with law.
Madam, the operating portion, madam, the tomorrow, madam, I think
ಸಾಯಂಕಾಲ ರಿಲೀಸ್ ಮಾಡ್ತೀನಿ.
please, madam. Madam, at least, madam, the respondent 3 and madam, the 4 is the negligence by the servicing of the notice to the respondent petitioner. Our negligence, madam, is the no confidence, madam. At least, madam, the imposing the key some madam. There is a second round litigation, madam. There is.
If intimation could be sent, given by the government advocate. If intimation could be sent by the government advocate.
This cost, Mr. I'll release a copy in the evening.
Yes.
Why
I'm
why are people wasting time? I don't understand.
My lord, on submission.
Yes.
Serial number 66, my lord, a petition for seeking parole, my lords. Lords may remember, my lord, I am filing a memo for withdrawal to file it before the High Court of Karnataka at Dharwad, my lord.
The learned counsel for the petitioner has filed a memo to withdraw the writ petition. Full stop. In view of the memo, the petition is dismissed as withdrawn. Office is directed to return back all the documents enclosed with the writ petition after retaining photocopies. Yes.
And liberty may given to file before the Dharwad High Court.
You can always come back. Parole, any number of times you can make an attempt.
Obliged, obliged. I love it.
Remember?
Annexure C is challenged in this. The respondent was a rider of the two-wheeler, himself fell down and got, he is not a third party.
What is challenged?
Annexure C, page number 18. On page 28, we'll actually paragraph 16.
So how are you challenging it in a writ petition? How are you challenging it in writ petition?
Because the award is only 76,000. And moreover, he is not a third party. He is the
76,000 ಇದೆಯಲ್ಲ, what is the limit?
1 lakh.
1 lakh.
It was 10,000 earlier. It is under the old act only, but courts are
But
not.
how can you file a writ petition when the law does not give you a right of an appeal?
This is your lordship, a case where he is not a third party. He is the rider, is a borrower of the two-wheeler. Apex court ruling is there. Ningamma's case. He is not entitled for compensation even under 163A. As provisions of 147 do not require this risk to be covered.
Without notice, issue emergent notice.
Stay may kindly,
Deposit.
50%.
50 interim stay of the impugned order subject to the petitioner depositing 50% of the award amount. ಏನ್ 75,000 the full deposit ಮಾಡಿ.
Before the High Court.
Subject to the petitioner depositing the entire amount before the
High Court.
before this court within 4 weeks
Right.
from today.
Much.
Yes.
For the petitioner, petition seeking mandamus for consideration of annexure G.
If the amount is deposited, office is directed to redeposit it in a interest earning fixed deposit for a period of 2 years, 1 year.
Seeking for a mandamus my lord for consideration of annexure E.
Annexure?
E. Page my lord 43. But a suit is filed for specific performance by the petitioner. Suit is decreed. In the execution petition, my lord, the court commissioner is appointed for execution of sale deed. My lord, the defendant therein, my lord, has the respondents, my lord, have inserted in the ROR column. Kindly see, my lord, page, the ROR copy at page 39, annexure B. It is, my lord, in the encumbrance, it is there only MRT number 2015-16, so and so. Now, my lord, after filing of the suit, behind the back, my lord, they have reproduced annexure D, page 42, prohibited for 15 years of alienation of land under Inam anta hakidare. This land was of 62, 60s early, it was an Inam land. Thereafter, my lord, it was released and became patta. Now, my lord, after filing of the suit, without, my lord, during pendency, when execution is there, they insert, my lord, this column. For that, I have.
You got a decree?
I have got a decree. I have produced the judgment. EP is also there, my lord. My decree is at page 36, my lord.
Yes.
The
MR T7 2015-16 ಎಲ್ಲಿದೆ ಅದು?
ಅದು ಕಾಪಿನೇ ಇಲ್ಲ ಅದು. It has nothing to do with Inam. They are now prohibited.
Let us see it. Let us see it to believe it. Where is this MR T7 bar 2015-16?
Other, I don't have the copy of that.
Apply ಮಾಡ್ಬೇಕಲ್ಲ.
But what I am considering, what I am seeking is, let them hold an inquiry with me and other thing on this, my representation, let them consider it.
Let us see what is that MR T7.
If the government is directed, my lord, let them produce it. What are the records of entire?
Apply.
ಅಲ್ಲ ಅವ್ರು ಮಾಡಿರೋದ ಎಂಟ್ರಿಗೆ ಐ ಆಮ್ ಟೇಕಿಂಗ್
available.
ವಿತೌಟ್
Application is also available.
ಡ್ಯೂರಿಂಗ್ ಪೆಂಡೆನ್ಸಿ ದೇರ್
MR T7 ನೀವೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ರಿ ಏನಾಗುತ್ತೆ?
ಗವರ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ಸ್
ಕರೆಕ್ಟ್ ಇದ್ದವರು ಲೇಟ್ ಆಗುತ್ತೆ ಅಂತ let them ಅವರಿಗೆ ಅನುಕೂಲ
ನಾವು ಅಪ್ಲೈ ಮಾಡಿ ತರಕ್ ಅವ್ರು ಕೊಡೋದೇ ಇಲ್ಲ, ಅದಕ್ಕೆ ಲೆಟ್ ದಿ ಗವರ್ಮೆಂಟ್ ಬಿ ಡೈರೆಕ್ಟ್.
ಆನ್ಲೈನ್
AG is directed to secure the extract of MR T7 bar 2015-16 in respect of the land bearing survey number 84 of Sirsi A, Bagadala, Hubli, Bidar Taluk by the next date of hearing. List on.
after 2 weeks.
ಮೇಲ್ಗಡೆ AG is directed to accept notice for respondents.
Please.
List on date ಕೊಡಿ.
I have challenged cancellation of land grant in this petition, your lordships.
Appeal ಇಲ್ವಾ? There no appeal.
You know, your lordships, there is no appeal, your lordships.
KT appeal ಇಲ್ವಾ?
No, your lordships, there is no appeal, your lordships. is also covered by judgment of this honorable court, section 25 of Karnataka land grant rules, your lordships.
Yes, government,
I will take notice.
here's that, accept notice for respondents. 1 to 4.
All responding.
Interim stay of the impugned order till the next date of hearing.
Obliged,
Based on date.
obliged.
Yes.
Your Lordship, respondent number 2 is not declaring the survey number land bearing. Respondent number 2 is not, in earlier occasion, your lordship, in the writ petition number 84950 of 2012, your lordship, the land bearing survey number 400/1 and 400/2, which is belonging to the petitioner, has been declared by the respondent number 2 in favor of the petitioner, your lordship. But later on, the land bearing number survey number 398 and 399, which is acquired by the then town municipal council, in these two survey numbers, it was not declared, your lordship. The prayer is as annexure H has been.
What is to be declared?
Survey number 398 and 399, your lordship. These two portion of the land in these survey numbers has been acquired by then town municipal council, which was not been declared in favor of the petitioner, your lordship. Whereas
I didn't understand. In favor, what has to be declared?
declaration, your lordship, because
No-
the land.
Notification is not issued.
No, notification is not, your lordship. Survey number 398, 399 and 400 in annexure A1, your lordship. It shows their heavy industrial area, serial number 1, that is 400, 399 and 398. They have been acquired.
Yes, government, AG is that to accept notice for respondent.
Yes.
Number 1 and 2.
Please.
Number 4. The amended counsel for the 2019 petition, Siddhapurkar. S.S. Siddhapurkar.
ಬೇರೆ advocate ಇದ್ದಾರೆ. Respondent number 1, 3 and 4, lordship.
The learned counsel for the petition has amended the cost title. This is that to check and verify. Yes, Siddhapurkar, yaar, S.S. Siddhapurkar. You appear ಆಗ್ತೀರಾ?
I am appearing for the R6 month.
You ready? Ready?
Date maybe.
2019 petition.
ನಾಳೆ
List down date. List down for. Yes.
I have amended the cause title.
Huh?
Cause title amended.
Pardon?
Cause title amended.
Cost.
Cause title amended.
Counsel for the petition has amended the cost title. Office is there to check and verify. What about this process ಕೊಟ್ಟಿದ್ದೀರಾ?
Process ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ. ಇವತ್ತು ಆರ್ಡರ್ ಆಗಿ ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಟು ಟೇಕ್ ನೋಟಿಸ್ ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ದೀವಿ ಸ್ವಾಮಿ. 1 to 3.
1 to 3.
Yes.
Yes, next. 1 to 3 are government education. Yes, next. Ravi B. Patil. Amendment ಮಾಡಿದಾರಾ? The learned counsel for the petition has amended the cost title. Office is there to check and verify. Yes, Ravi B. Patil. Yes, what is your case?
I am the respondent number 7, my lord,
Ah,
in this case.
yes.
My lord, I did not receive any notice, my lord, first of all.
You don't have a copy of the petition?
I have petition copy, my lord, I have taken from the HCGP.
Yes,
I did not got any, I did not receive any notice, my lord.
yes.
My notice received by the petitioner number 3.
Okay, now that you have received the copy, please argue the matter.
Okay, my lord.
Oh,
The plaintiff, one of Sadak B, daughter of Bade Saab, had filed a civil suit in OS number 398/89 in 1992, old OS number 180/86 before the principal junior civil judge at Bidar for partition of her 1/8 share in Matruka property out of 31 acre 14 guntas in both survey numbers 339 and 341. My lord, survey number 339 is equal to 12 acre 10 guntas, my lord. Survey number 341 is equal to 19 acre 4 guntas, my lord. Total land is 31 acre 14 guntas. The OS got decreed, my lord. The OS got decreed 1/8 share out of 31 acres. That means equal to 3 acre 37 guntas, my lord.
yes.
Again, she have filed a final decree petition before the Munsif Court at Bidar, my lord, for petition under Order 20, Rule 18, Section 54 CPC, execution of decree in OS number 398/89 to draw a final decree proceedings for partition and separate her position, etc. So, in this final decree, instead of getting her 1/8 share, she got double 1/8 shares, my lord.
Double 1/8 and
Instead of 3 acre 37 guntas, she got 8 acres land, my lord, decreed. In final decree, my lord. In final decree, she got 8 acres illegally. So after that, she got 8 acre mutation, my lord, and entered revenue records also on her name 8 acres. After some time, she realized that 1/8 share becomes only 3 acre 37 guntas, not 8 acres. Like that, she realized and sold it to the third parties hurriedly. My lord, the share of Sadak B is 1/8 only 3 acre 37 guntas out of 31 acre 14 guntas, my lord.
yes.
But she got mutated 8 acres illegally.
I understood you. Amele.
Point number 1, that, my lord. So, the respondent number 4 and 5.
So, but why did you not challenge the FDP final decree?
challenged, my lord.
Final decree, did you
Final
challenge?
decree mutation challenged in
Did you challenge the final decree the decree passed in final decree? Did you challenge the final decree?
Yes, my lord. Mutation in final decree challenged before the assistant commissioner be there, my lord.
Forget the mutation comes later. There was a decree earlier, 1/8 share,
Yes,
then there was final decree,
yes,
then there was execution.
yes.
Did you challenge the final decree is what I am asking you.
So my father and my uncle has appointed a council, my lord. He has challenged before assistant commissioner be there.
ಅದು mutation ಅಪ್ಪ ಅದಕ್ಕೆ ಹೇಳಿದ್ದು what do you do for a living? You're an engineer.
No, my lord.
What do you do?
I do some private office work and under advocate, I'll do assistant, my lord.
So therefore, you do not know what the law is. Law is when there's a final decree
Yes,
giving a larger share,
yes.
then you have to challenge that final decree, not before the mutation. You have to challenge it in the High Court or in the District Court. You have to challenge that.
So maybe my father and my uncle may not have awareness of this.
So therefore, you please challenge it. You can't challenge the mutation. Mutation ಅಂದ್ರೆ ಏನು? ತಹಸೀಲ್ದಾರ್ ಮಾಡೋದು. ಫೈನಲ್ ಡಿಗ್ರಿ ಏನು ಹೇಳುತ್ತೋ ಅದ್ರ ಪ್ರಕಾರ ಅವ್ರು ನೋಡ್ತಾರೆ. ಫೈನಲ್ ಡಿಗ್ರಿ ತಪ್ಪಿದ್ರೆ ತಹಸೀಲ್ದಾರ್ ಹತ್ರ ಹೋಗಿ ತಪ್ಪು ಅಂತ ನೀವು ಹೇಳಕ್ಕಾಗಲ್ಲ. ಫೈನಲ್ ಡಿಗ್ರಿ ತಪ್ಪಿದ್ರೆ ನೆಕ್ಸ್ಟ್ ಕೋರ್ಟ್ಗೆ ಹೋಗ್ಬೇಕು. ಶುಡ್ ಚಾಲೆಂಜ್ ದ ಫೈನಲ್ ಡಿಗ್ರಿ ದೇರ್.
Again, now the current petitioner brought this petition that 1/8 share becomes 4 acres. The FDP, in FDP, they got that 4 acres only. That too in our property only. Again, mutate the restore for the entries. They filed this writ petition, my lord, petition.
Who's advocate? You are working with whom?
In Hyderabad, my lord.
In Hyderabad.
Yes.
You should have got that lawyer here. You're working with an advocate. That doesn't mean to say that you will know what exactly is the position of law. Mutation is always based on the final decree.
Yes, my lord.
Mutation is based on the final decree.
Yes, my lord.
If you want to challenge the mutation, you should challenge the final decree first. Have you challenged the final decree?
No, my lord.
Then Tahsildar cannot do anything more. Tahsildar has to simply follow what is mentioned in the final decree.
Yes.
Correct? If
Yes,
the final decree passed by a court says 8 acres, Tahsildar cannot say 3 acres.
Yes, my
Or
lord.
the assistant commissioner cannot say 3 acres. Or the deputy commissioner cannot say 3 acres.
Yes, my lord.
You have to challenge the final decree itself.
Yes, my lord.
Then if you get it rectified, then you can go before the Tahsildar or the assistant commissioner or before the deputy commissioner asking him to change the mutation.
Yes, my lord.
Artha aita? You understood?
Yes, I understood, my lord.
So what do you want to do? Please consult your lawyer first.
They filed a revision petition before the deputy commissioner of Bidar, my lord. Revision petition was dismissed. Against this assistant commissioner order, they filed a revision petition.
What does the assistant commissioner say?
Assistant commissioner said that 1/8 in our property, only the Sadakbi has to get only 1/8 share, not entire property.
Where is the final decree? Do you have a copy of the final decree?
Yes, my lord.
Give the final decree.
Replies.
And 341.
Yes, my lord. In survey number 339, 4 acres she got, and in survey number 341, she got 4 acres, my lord. 8 acres cannot be considered as 1/8 share out of 31 acre 14 guntas, my lord. Already now, Sadak beside 4 acre 22 guntas of land as of now.
Then you must challenge this decree, mister. You shall, Telgar, Teluga?
My lord, I can understand Telugu, English, Hindi also, my lord. I am Muslim.
So I hope you understood.
Yes, my lord.
What did you understand?
The final decree should be challenged.
Final decree child cheyala.
అప్పుడు లాయర్ గారికి ఇచ్చాము. అయ్య గారు వాళ్ళు ఏం చేసి
మాట్లాడండి, లాయర్ దగ్గర మాట్లాడదు కరెక్ట్ గా.
అని చనిపోయారు కూడా. He passed away also now. My father also passed away.
Lawyer passed away, there will be one more lawyer.
Yes, yes.
అడగండి వాళ్ళ దగ్గర.
So she got all the ex parte decrees, sir.
ఓకే మిస్టర్. మ్యుటేషన్ తర్వాత వస్తుంది.
అవును.
అర్థమైనా?
అవును.
మ్యుటేషన్ తర్వాత వస్తుంది.
అవునవును. ఫస్ట్ డిగ్రీ
ఎఫ్డిపి మొదలు వస్తుంది, తర్వాత మ్యుటేషన్ వస్తుంది.
ఇప్పుడు వాళ్ళు ఏం తెచ్చారంటే కోర్టు ముందు మళ్ళీ 1/8 షేర్ అనేది 4 ఎకరాలు పాస్ చేసింది కోర్టు అని అనెక్జర్ ఏలో మెన్షన్ చేశారు.
ఇప్పుడు పిటిషనర్ లాయర్ అదే చెప్తా ఉండేది. ఫైనల్ డిగ్రీలో 8 acres ఉంది.
అవును.
అసిస్టెంట్ కమిషనర్ ఎట్లా 4 ఎకరా అంటే చెప్తారు అంతా అడుగుతా ఉన్నారు.
అవునవును.
If the court decree says 8 acres, how can the assistant commissioner say 4 acres? అదే చెప్తా ఉండేది వాళ్ళు.
అవునవును, అదే చెప్తున్నారు.
సో మీరు ఫైనల్ డిగ్రీ ఛాలెంజ్ చేయండి.
ఎక్కడ ఛాలెంజ్ చేయాలి?
ఎక్కడ మీరు వకీల్ దగ్గర మాట్లాడండి.
వకీల్కి ఇస్తేనే ఇలా చేసి పెట్టాడు సార్, ఏం చేయాలి? వకీల్కి ఇస్తేనే ఇలా చేశాడు, మాకు తెలియదు కదా సార్ దాని గురించి. వకీల్కి ఇస్తేనే అసిస్టెంట్ కమిషనర్ దగ్గర మ్యుటేషన్ ని ఛాలెంజ్ చేసి రెక్టిఫై చేయించాడు మ్యుటేషన్ ని. దాని తర్వాత వాళ్ళు రివిజన్కి వెళ్ళారు. రివిజన్ వాళ్ళు ఫైనల్ డిగ్రీలో క్యాలిక్యులేషన్స్ తప్పు.
డిస్ట్రిక్ట్ కోర్టులో ఫైల్ చేయాలి. డిస్ట్రిక్ట్ కోర్టులో.
వాట్ ఈస్ ద నెక్స్ట్ ప్రొసీడింగ్ హియర్ మై లార్డ్?
దిస్ ప్రొసీడింగ్ విల్ బి స్టేడ్ హియర్.
స్టేడ్ హియర్.
స్టే చేస్తాను.
ఓకే.
మళ్ళీ మీరు అక్కడ బీదర్ డిస్ట్రిక్ట్ పోయి అక్కడ అప్పీల్ వేయండి.
ఎఫ్డిపికి అగైనెస్ట్ గా. మై కాపీ నేను ఇచ్చాను కదా మీకు ఒక కాపీ.
వాపస్ కొట్టుకోకూడదు.
ఒకటి ఆబ్జెక్షన్స్ ఇచ్చాను, రిటర్న్ ఆబ్జెక్షన్స్. ఇంకోటి నేను ఇచ్చాను.
పర్వాలేదు, అబ్జెక్షన్స్ నేనే పెట్టుకోతాను.
ఇంకోటి జిరాక్స్ ఇచ్చాను. ఓకే. అబ్జెక్షన్ కూడా ఫైల్ చేశాము సార్.
లేకపోతే ఇక్కడ ఇంత వకీలు ఉండారు, ఎవరు మాట్లాడు.
మేము ఉండేది హైదరాబాద్ లో కదా సార్, కొంచెం దీని గురించి తెలియక. ఓకే, థ్యాంక్ యూ.
లిస్ట్ ఆన్ డేట్ కూడా ఇస్ట్. ఎస్, నెక్స్ట్. మిస్టర్ మొహమ్మద్ షరీఫ్, ఈ కేసు విల్ లిస్ట్ ఇట్ ఆన్ 4th February.
ఓకే.
దాంట్ లోపల మీరు అక్కడ ఛాలెంజ్ చేయండి
డిస్ట్రిక్ట్ కోర్టులో.
అవును,
4th February లోపు.
4th February పెడతాను. అక్కడ పోండి.
కొంచెం ఇంకా టైం ఇవ్వండి, మార్చ్ లో వేయండి. ఎందుకంటే
లాస్ట్ వీక్
ఈ సర్టిఫై కాపీస్ అవన్నీ తీయాలి కదా సార్. మార్చ్ February 20. ఓకే.
నెక్స్ట్.
Lordship, memo is ready, Lordship. Kindly pass, sir. The party is on the way, Lordship. I will sign it along with the affidavit. I will file, Lordship.
ಏನ್ ಮಾಡ್ತೀರಾ?
It may be, I may be given some time, I will just think over and submit ಮಾಡ್ತೀನಿ.
ಆಯ್ತು, ಮೆಮೊ ಫೈಲ್ ಮಾಡ್ಲಿ ಹೆಂಗಿದೆ.
ಮಾಡ್ಲಿ ನಾನು
ಮಾಡ್ಲಿ ನೋಡೋಣ.
one date may kindly.
ಫಸ್ಟ್ ಅವ್ರು ಫೈಲ್ ಮಾಡ್ಲಿ.
ಅವ್ರು ಇನ್ನ ಬರಕೈತಾರ ಆನ್ ದ ವೇ ಅಂತಾರೆ, ಯಾವಾಗ ಬರ್ತಾರೋ ಏನೋ. ಸುಮ್ಮನೆ ನಮ್ಮ
ಬರ್ತಾರೋ ಬಿಡ್ತಾರೋ 4:45 ಕೋರ್ಟ್ ಕ್ಲೋಸ್ ಆಗುತ್ತೆ.
ಹೌದು ಸರ್.
4:45 ಒಳಗೆ ಬರ್ತಿದ್ರೆ ಯು ವಿಲ್ ಗೆಟ್ ಅನ್ ಅಡ್ಜರ್ನ್ಮೆಂಟ್. You pray to God that it does not come before 4:45.
ನಾ ಪ್ರೇ ಮಾಡ್ಕೊಂತ ಕೂಡ್ಬೇಕಾಗತ್ತೆ ಈಗ ಅಷ್ಟೇ, ಬೇರೆ ಕೆಲ್ಸನೂ ಇಲ್ಲ. ಆಯ್ತು. ಅದಕ್ಕೆ ಒಂದು ಅಂಡ್ ನಾಳೆಗೆ ಇರ್ಲತ್ತ ಒನ್ ಡೇಕ್ ಏನಾಗುತ್ತೆ?
Please, as tomorrow. Meanwhile, I will file the memo, Lordship.
Tomorrow. Please, the order dated so and so is extended till tomorrow.
ಪ್ಲೀಸ್ ಮೇಡಮ್.
ಸೆಟಲ್ಮೆಂಟ್ ಏನೋ ಮಾಡ್ಕೊಳ್ಳಿ ಮಧ್ಯದಲ್ಲಿ ಏನೋ.
ಇನ್ ದ ಮೀನ್ ವೈಲ್ ಅದೇ ನಾನು ಅದೇ ಅನ್ಬೇಕಂತ ಮಾಡಿದ್ದೆ, ಮತ್ತೆ ಅದಕ್ಕೆ
ಸರ್, ನೀವು ಯು ಆರ್ ಫಿಶಿಂಗ್ ಇನ್ ಟ್ರಬಲ್ಡ್ ವಾಟರ್ಸ್.
ಅಫ್ ಕೋರ್ಸ್ ಐ ನೋ.
ಅದೇ ಲಿಟಿಗೇಷನ್ ಗೊತ್ತು, ಸೇಲ್ ಡೀಡ್ ಆಗಿದೆ ಗೊತ್ತು, ಎಲ್ಲ ಗೊತ್ತು. ನೀವು ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು ಯು ಆರ್ ಟ್ರೈಂಗ್ ಟು ಫಿಶ್ ಇನ್ ಟ್ರಬಲ್ಡ್ ವಾಟರ್ಸ್.
ಅಲ್ಲ, ನಾ ಫಿಶ್ ಇನ್ನಲ್ಲ, ಐ ಆಮ್ ಟ್ರಬಲ್ಡ್. ಲೇಟರ್ ಆನ್ ಐ ಆಮ್ ಸರ್ಚಿಂಗ್ ಫಾರ್ ಫಿಶ್. ಹಂಗಾಗ್ಯದ ಈಗ. ಯಾಕಂದ್ರೆ ಇಲ್ಲ ನನಗೆ ಗೊತ್ತಿರ್ಲಾರ ನಾ ಪರ್ಚೇಸ್ ಮಾಡೀನಿ.
ನೀವು ಹೋಗಿ ಅಲ್ಲಿ ಬೆಂಕಿ ಒಳಗೆ ಕೈ ಇಟ್ಟಿದ್ದೀರಿ. ಬೆಂಕಿ ಒಳಗೆ ಕೈ ಇಟ್ಟರೆ ಸುಟ್ಟೆ ಸುಡುತ್ತೆ.
ಇನ್ನು ವೇರಿಯಸ್ ಅದರ್ ಥಿಂಗ್ಸ್ ಹೇಳವಿರ್ತಾವ. ಮೆಲಡ್
ಸರ್ ಹೇಳೋದಿರುತ್ತೆ ಇಲ್ಲಿ, ಬಟ್ ದೇಸ್ ಎ ಡಿಕ್ರಿ, ದೇಸ್ ಎನ್ ಎಕ್ಸಿಕ್ಯೂಷನ್.
ಮೆಲಡ್ may put a question for myself, which will also be important for consideration. My lord, this court is having a supervisory jurisdiction. Let us assume that at first instance, I request this honorable court, if at all they wish to withdraw it, let them withdraw it before the executing court. ಇಲ್ಲೇ ಮಾಡ್ಕೋಬಹುದು ಅಂತ ತಮ್ಮ ಫರ್ಮ್ ಒಪಿನಿಯನ್ ಅದನ್ನು. ರೈಟ್ಲಿ ಆರ್ ರಾಂಗ್ಲಿ ನಾವು ನಿಮ್ಮ ಮುಂದೆ ಬಂದಿದ್ದೀವಿ. ಈಗ ಬಂದು ಏನು ನಡೆದದ ಅಂತ ತೋರಿಸಿದ್ದೀವಿ. ಈ ಕಮಿಷನ್ ವಾರಂಟ್ ಏನು ಇಶ್ಯೂ ಆಗ್ಯದ, whether that issuance of commission warrant is in consonance with the execution proceedings and rules. If I were to able to demonstrate before the court that the issuance of that commission warrant is patently against the rule 34 of order 21 adra, even if I were to be not party, you really illi withdraw ಮಾಡ್ಕೊಂತಾರಂತ ಅಂತೇಳಿ, thus they want that ಇದ್ರ ಇಲ್ಲಿಗೆ ಮುಗಿಸಿ ಸಡನ್ ಅದು ಇದು ಮಾಡ್ಬೇಕಂತಾರ. ನಿಮ್ ಗಮನಕ್ಕೆ ತಂದ್ಬಿಟ್ಟು ನಾನೀಗ ರೂಲ್ 34 ಏನ್ ಹೇಳ್ತದೆ ನೋಡ್ರಿ ಸಾಹೇಬ್ರೆ, ಅದ್ರ ಪ್ರಕಾರ ಇತ್ತಂದ್ರೆ ಪರವಾಗಿಲ್ಲ ಅಂತ ಹೇಳ್ದಂತ. ರೂಲ್ 34 ಪ್ರಕಾರ ಇಲ್ಲ ಅಂದ್ರೆ
ನಾಳೆ
marks of their withdrawal.
ನಾಳೆ ವಾದ ಮಾಡಿ. Yes, list tomorrow. Interim order granted on yesterday is extended till the next date. ರತ್ನ ಶಿವಯೋಗಿ ಮಠ್. Yes, Mr. Shivkumar Tengli.
Housing board has developed this layout, my lord, and aims and objects are similar. They are concerned, both the aims and my lord objects are similar, KHB and Kuda. Kuda is only concerned to Kalaburagi, my lord, they have developed this area. And they, without informing, without notice to the Kuda, they themselves are approved, we have written a letter to the urban development my lord, the secretary. In way back, I have filed that letter, copied letter, my lord, on 28/7.
Tell us who has formed this layout?
Housing board.
அநேகமா காலையில எல்லாம் இங்க கொடுத்துட்டு வேற பில்டிங் போய் கொடுத்துட்டு சாப்பிட்டு மறுபடியும் எடுத்துட்டு வந்துடுறானுங்க.
Housing board has encroached into this red color portion.
What they want some connectivity between their land and the housing board. We are already shown in the map where the connectivity is given, and survey has been done, and copy of survey is not given to me. I shall file objection to that survey. 2 days time.
ಅವ್ರಿಗೆ ದಾರಿ ಎಲ್ಲಿದೆ ಹೋಗೋದಕ್ಕೆ?
ನಾವು ದಾರಿ ದೊಡ್ಡ ಗೇಟ್ ಹಚ್ಚಾರ, ಇದೇ ರೋಡ್ ಮೇನ್ ರೋಡಿ. ಗೇಟ್ ಹಚ್ಚಾರ ಅವರು, ಗೇಟ್ ಇದೆ.
ಕರೆಕ್ಟ್, ಅವ್ರಿಗೆ ದಾರಿ ಎಲ್ಲಿದೆ ಅಂತ ಕೇಳಿದೆ.
Connectivity ಬೇಕು, there must be connectivity.
They want connectivity.
There must be connectivity, each colony ಗೆಲ್ಲ connectivity ಬೇಕು, as per 32 rule 32 Karnataka Urban Development Act 32(6) they have to approve the plan with the connectivity. They violated that rules.
We also filed a map showing the connectivity in two plans.
ಇದರಲ್ಲಿ
They want,
as per the direction of
our convenient ಪ್ರಕಾರ already we have left connected here plot ಇದ್ದೇವೆ. ತೋರಿಸಿ map filed.
26/4 and 26/5 ಗೆ is there any access? ದಾರಿ ಇದೆಯಾ?
ಎರಡು ಪ್ಲಾಟ್ ಲೇಔಟ್ ಅದ, ಎರಡು ಕನೆಕ್ಟಿವಿಟಿ ಬಿಟ್ಟೆ ಕಟ್ಟಾರ.
ಆಯ್ತು, 2 ಪ್ಲಾಟ್ ತೆಗೆದುಕೊಡಿ.
ಒಟ್ಟು ಬಿಟ್ಟಿದೆ ಸರ್, ಆಲ್ರೆಡಿ ಫೈಲ್ ಮ್ಯಾಪ್. ದೇ ವಾಂಟ್ ದಿ ಅಕಾರ್ಡಿಂಗ್ ಟು ದೆಮ್, ಈ ಸೈಡ್ ಬಿಡು ಆ ಸೈಡ್ ಬಿಡು ಅಂತ.
ಇಲ್ಲ,
ಎಲ್ಲಿದೆ ಕನೆಕ್ಟಿವಿಟಿ ತೋರಿಸಿ.
ನಂಬರ್
ಫೈಲ್ ಮ್ಯಾಪ್.
ಇವಾಗ ಅವ್ರದ್ದು 4 ಗುಂಟೆ ಏನೋ ನೀವು
ಈ ಸರ್ವೆ ನಂಬರಿಗೆ ಇಲ್ಲ ಸ್ವಾಮಿ.
The honorable court has directed for survey by the area law, and housing board has submitted their say before this commissioner and given them. The commissioner has given report. What report he has given? I want to file objection to that report and show.
The learned counsel for the respondent number.
short date maybe, otherwise they'll put up construction to parking all.
No construction, ಎಲ್ಲಿ construction ಸುಮ್ಮನೆ.
ಇಷ್ಟೊಂದು ಯಾವತ್ತು ಬೇಕು ಹೇಳಿ?
2-3 days, 27, 28. 28.
Please.
ಇಲ್ಲ ಡೈರೆಕ್ಟ್ ಆಗೋದು ಸುಮ್ಮನೆ.
Lord, respondent number one, my lord.
Yeah?
Respondent number one is the bank, Jana Small Finance Bank. And 2 to 5 borrower, my lord.
ಯಾವ್ದ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದೀರಾ? Respond number one.
One, Jana Small Finance Bank, my lord. And 2 to 5 are the borrowers, my lord. And they have taken 40 lakhs rupees loan in the year 2000, my lord, sanctioned. And now remaining 5 lakh something principal and including interest 11 lakh something is there according to the judgment, my lord. They have not replied to notice and they've respondent number one filed under section 14 before the PCJ, my lord. And now possession warrant is issued. I purchased this house property, my lord, in the year 2021, my lord. Since then, records are standing in my name, my lord.
Mister, you said something in the morning.
Yes, I'm the purchaser of the house, my lord.
Asked you in the morning whether you purchased from the, what you call defaulters. You said
Yes,
no.
I purchased from the defaulters, my lord. This property from respondent number 3 here in, my lord. I purchased from him, my lord, in the year 2021. Since then, I'm in possession of the property. And these 4 persons, my lord, taken loan, my lord, personal loan. And this property, they have made agreement, my lord, they have made mortgage. At the time of purchase, I verified, my lord, no such mortgage was there in the year 2021, my lord.
The number one, writ petition is not maintainable. Number two, if some amount can be, if you are willing to pay up this money and proceed against the respondents, will grant you that liberty.
No, they have other properties also, my lord. ಅಲ್ಲ,
ನೀವು ದುಡ್ಡು ಕಟ್ತೀನಿ ನಂಗಿದ್ರೆ ಸ್ಟೇ, ಇಲ್ಲ ಅಂದ್ರೆ ನೋ ಸ್ಟೇ.
ನಾನು I would need stay, my lord. Now, Bailey
No
came
stay.
to my house, my lord.
My dear friend, this is under the Surface Act. This is under Surface Act.
Yes, my lord.
Section 14 order,
Yes, my lord.
correct?
Yes, my lord.
Number one, there is an appeal remedy as per the judgment of this
14
court.
only, I did not see the appeal remedy, my lord.
Please have a judgment of rendered by Justice Alok Arade.
There is no appeal on the 14th. ಅಲ್ಲಿ.
Please have a look at the judgment of Justice Alok Arade. No,
Lord, subject to result of the writ petition, my lord, I deposit before this court, my lord.
Yes, to. How much is the due?
ಅದು 5 ಲಕ್ಷ ಮೇಲೆ ಪ್ರಿನ್ಸಿಪಲ್ ಅಂತ ಇದೆ, my lord. 11 lakh ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ.
ಎಷ್ಟು the total amount?
Total 11 lakh as on today, my lord. Out of 40, Lord, less than 20% principal amount ಇದೆ, my lord.
ಎಷ್ಟು ಕಟ್ತೀರಾ? 50% ಕಟ್ಟಿ.
ಅಲ್ಲ, ಅದು ಆಲ್ರೆಡಿ ಕಟ್ಟಿದ್ದಾರೆ ಸ್ವಲ್ಪ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಅಲ್ಲ, 11 ಲಕ್ಷದ
they will settle, my lord, themselves.
11,85,000 ಇದೆ.
ಅಲ್ಲ, ನಾನು 4 ವರ್ಷ 2 ಲಕ್ಷ ಡಿಪಾಸಿಟ್ ಮಾಡ್ತೀನಿ, my lord, ಕೋರ್ಟ್.
50% ಮಾಡಂಗಿದ್ರೆ ಸ್ಟೇ ಕೊಡ್ತೀನಿ, ಇಲ್ಲ ಅಂದ್ರೆ ನೋ ಸ್ಟೇ. There is a law, Mister. I can't. The Supreme Court says don't interfere in surfacing matters. Supreme Court has directed high courts not to interfere in surfacing matters.
It is a good case, my lord, for interest.
You might have a wonderful case, not here, Alli, DRT Nalli.
25% of the
50%. If you are willing to pay 50%, stay.
ಅಲ್ಲ,
ಇಲ್ಲ ಅಂದ್ರೆ no stay.
I will deposit before this honorable court 25%, my lord, subject to result
Issue emergent notice to the respondents. Interim stay of the impugned order subject to the petitioner depositing 50% of a sum of rupees 11 lakhs.
my lord, amount heavy ಆಗುತ್ತೆ, my lord. This female ಇದ್ದಾರೆ.
No, no. 11 lakhs 85,012
25% ಮಾಡಿ, my lord, ಕಟ್ತಾರೆ.
within
Deposit
4 weeks from today,
before this honorable court.
before this.
My lord, amount may not be released, my lord. That is
Yes.
subject to result of it.
Yes, obviously court
Please.
amount will not be released. Yes. Baswa Kiran.
Challenging the conditions of tender document.
Hmm?
Challenge the conditions of the tender notification dated 30/12/24 issued by the Social Welfare Department.
Hmm.
Primarily, I'm challenging 2 conditions, my lord. One is regarding the turnover and one is the time, my lord, that only 10 days time.
Similar orders were passed.
Yes, my lord. But in this particular matter, my lord, the time to submit the document was only 10 days, though the tender value was around 34 crores, my lord. It should have been more than, it should have been 30 days, my lord, but only 10
government
days time was
purpose.
granted. No approval of the higher
AG
authority.
is directed to accept notice for response 1, 2, and 3. Pending disposal of this writ petition, the petitioner is permitted to submit its bid against the notification issued by the respondent number 3
Please, ma'am.
at annexure.
Annexure D, my lord.
Annexure D.
Yes. The impugned condition is at page 28A, my lord.
This is however subject to the result of this petition. Yes.
Fine.
This is Sanjay M. Joshi.
Yes, sir.
Lords, the petition, the respondent was working as a driver, Lords, and appointed on 1/5/1982. He was dismissed, Lords, from service on 30/8/2004, Lords. Then he raised a dispute, Lords, under the Industrial Disputes Act in KAD number 11/2005, Lords. That was came to be allowed on 22/5/2009. Thereafter, that order was came to be challenged, Lords, before this court in WP number 84242 of 2010. Lords. In that writ petition, there was an interim order. Subsequently, the writ petition was came to be dismissed, Lords, on 25/4/2015, annexure B, Lords, page number 18. Then thereafter, Lords, this settlement, he was superannuated on, Lords, 34/2015, Lords. Then the service benefits calculated 10,90,954, Lords. And he was paid the entire amount. And thereafter, he filed a petition under section 32C of the Industrial Disputes Act.
33C.
33C2, Lords, of the Industrial Disputes Act, claiming, Lords, prospective wages for the period from the date of the industrial dispute order, Lords, till the disposal of the writ petition. Then that was came to be allowed. Against that order, Lords,
What is wrong with the order?
Lords, first is in the first order, Lords, while the dismissal order was set aside, the back wages were rejected, Lords, at annexure 15.
Annexure?
Page number 15, Lords, annexure A. Dismissal order dated 30/8/2004 is set aside. The
From
respondent is.
2009 ಇಂದ ಕೇಳ್ತಿರ್ತಾನೆ.
Huh, sir.
From 2009
Yes, sir.
till the date of
Yes.
retirement.
Yes.
Lords, on the principle, he did not join the work, man.
No, you did not allow him to join to work.
No, but he has to, at least, Lords, by virtue of this order, he has to seek
See,
for,
but-
if a person, Lords, after,
Mister, you challenged it before the High Court
yes, Lords.
and that was disposed of only in 25th of April 2015.
Yes, ma'am.
Yes.
So therefore, where is the question of he joining?
17B, Lords, he has, there are provisions, Lords, under the act.
17B wages ನೀವು ಕೊಡ್ಲಿಲ್ಲ.
No.
Kodlila, all 17B, Lords, they have to seek for 17B compliance, or they have to seek for, Lords, rejoining the work.
Joining report is there.
They have to avail.
Joining report
both either of them, they have to avail it. If a person, Lord, sits and does not work, comes with a plea after 3-4 years of settlement of the wages, Lord,
Yes.
for payment of the wages, taking it as a prospective wages. Lord.
Yes. ಅಷ್ಟೇನಾ?
But in regard to the calculation, Lord, there is some confusion. In fact, I have called upon even the department, Lord. They are under confusion.
ಅದ್ರ ಬಗ್ಗೆ ಒಂದು ಕ್ಲಾರಿಫಿಕೇಶನ್ ಮಾಡಿ ವಿಲ್ ಮೇಕ್
ಅಲ್ಲ ಸರ್, ಆಕ್ಚುಲಿ
Possible.
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ ಇಸ್ ಆಲ್ಸೋ ಫೈಲ್ಡ್.
ನನಗೂ ಕನ್ಫ್ಯೂಷನ್ ಇದೆ ಅದ್ರ ಬಗ್ಗೆ.
Yeah,
ಅವ್ರಿಗೂ
calculation,
ಕೇಳಿದೆ.
sir.
ತಡ್ರಿ, ಅವ್ರು ಮಾಡ್ಲಿ, ಮುಗಿಸ್ಲಿ ತಡ್ರಿ.
Even I have inquired, what I called upon. The office is at Bijapur, the concerned employee worked. They told that they are not aware about all these things. ಅದೊಂದು ಕ್ಲಾರಿಫಿಕೇಶನ್ ಮಾಡಿ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಐ ವಿಲ್ ಮೇಕ್ ಸಬ್ಮಿಷನ್. ಅದೊಂದು ಅವ್ರು ಕರೆಸ್ತೀನಿ. ಅದು ಹೆಂಗ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಅರೈವ್ ಆಗ್ಯಾರ, ದೇರ್ ಇಸ್ ಸಮ್ ಕನ್ಫ್ಯೂಷನ್.
What is, he has only asked for salary for that period ಅಷ್ಟೇ.
ಅಷ್ಟೇ ಸರ್. One respond also lead the evidence and he is put the calculation madam. Then only 2 lakhs is reduced before the labor court.
ಅದು ಇವ್ರು ನಮ್ಮ ಒನ್ ಆಫ್ ದಿ ಎಂಪ್ಲಾಯಿ ಮಿಲಾಟ್ಸ್ ಹ್ಯಾಸ್ ಕ್ಯಾಲ್ಕುಲೇಟೆಡ್. ಇವನ್ ಈ ಅಡ್ಮಿಟೆಡ್ ದಟ್. ಬಟ್ ಅದು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಗೆ ಕನ್ಕ್ಲೂಷನ್ ಗೆ ದೇರ್ ಇಸ್ ನೋ ಮೆಟೀರಿಯಲ್.
ಪೇಜ್ ನಂಬರ್ 27 ಅಲ್ಲಿ ಕ್ಲಿಯರ್ ಇದೆ.
ಅಲ್ಲ, ಅದು ಕ್ಲಾರಿಫಿಕೇಶನ್ ವಾಟ್ ಐ ಆಮ್ ನಾಟ್ ಸೀಕಿಂಗ್ ಫ್ರಮ್ ದಿ ಡಿಪಾರ್ಟ್ಮೆಂಟ್. ನಾಟ್ ದಟ್ ಬಿಕಾಸ್ ಐ ಆಮ್ ಅಂಡರ್ ಆಲ್ಸೋ.
Come to page 25. 25 ಬಂದು.
ಇಲ್ಲ, ಅದೇ ಇದ್ರ ಬಗ್ಗೆನೇ ಐ ಹ್ಯಾವ್ ಆಸ್ಕ್ಡ್ ದಿ ಕ್ಲಾರಿಫಿ.
ಅಲ್ಲ, 25 ನೀವೇ ಹೇಳಿದ್ರಲ್ಲ.
ಹೌದು, ಅದೇ ನಾವೇ ಹೇಳಿದ್ವಿ ಸ್ವಾಮಿ. ನಮ್ಮ ಎಂಪ್ಲಾಯಿನೇ ಆಸ್ ಕ್ಯಾಲ್ಕುಲೇಟೆಡ್ ಇಟ್. ಬಟ್
ಅಷ್ಟು ಕೊಡ್ಲೇಬೇಕಲ್ಲ, ಅಷ್ಟಾದ್ರು 19,56,000.
ಅಲ್ಲ, ಅದು ಕೂಡ ಅದು ಜಸ್ಟ್ ಐ ವಿಲ್ ಕ್ಲಾರಿಫೈ ಬಿಕಾಸ್ ಹೌ ಇಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಅರೈವ್ಡ್. ದೇ ಆರ್ ಆಲ್ಸೋ ಡಿಸ್ಪ್ಯೂಟಿಂಗ್ ದಿ ಹೈಯರ್ ದಿ ಅಥಾರಿಟೀಸ್. ಈ ಕನ್ಕ್ಲೂಷನ್ ಹೆಂಗೆ 17 lakhs ಅಂತ ಯಾವ ಬೇಸಿಸ್ ಮೇಲೆ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿದ್ರು ಅಂತ ಅನ್ನೋದಕ್ಕೂ
ಬೇಸಿಸ್ ನೀವು
ಐ ಆಸ್ಕ್ ದೇ ಆರ್ ನಾಟ್ ಎಕ್ಸ್ಪ್ರೆಸಿಂಗ್ ಎನಿಥಿಂಗ್.
ಬರ್ಕೊಳ್ಳಿ. ನಾನು the petitioner has challenged an order dated 24/4/2019 passed by the Labour Court, Vijaypura, in application number 7/2018 under section 33C2 of the Industrial Disputes Act 1947. Next para. The petitioner, the respondent was employed as a driver, was dismissed from service. Full stop. The respondent then initiated proceedings before the Labour Court in KID number 11/2005, 2005. The Labour Court, in terms of its order award dated 22/5/2009, set aside the order of dismissal and directed reinstatement into service. Directed reinstatement of the respondent into service with continuity of service and other consequential benefits. However, the prayer for back wages was rejected. Full stop. The petitioner then challenged the award passed by the Labour Court in WP number 84242/2010. Full stop. This court, in terms of the order dated 25/4/2015, dismissed the writ petition. Following this, the respondent filed a petition under section 33C2 of the Industrial Disputes Act for a direction to the petitioner to pay a sum of rupees 19,28,019 with interest at 18% per annum from the date of the order passed in the writ petition referred above till realization. Full stop. The petitioner contested the said application and claimed that the petitioner had wrongly claimed wages of rupees 19,28,019. It contended that the petitioner is the respondent is only entitled to rupees 19,56,067, from which statutory deductions of rupees 2,17,950 had to be effected. Consequently, it claimed that the respondent was entitled to a sum of rupees 17,38,117. Stop. The Labour Court, after considering the aforesaid objections, passed the impugned order directing the petitioner to pay a sum of rupees 17,38,117 within 3 months, failing which the petitioner was bound to pay interest at 9% per annum. Full stop. Being agreed with the said order, the petitioner is before this court. Next para. The learned counsel for the petitioner contends that the respondent was entitled to claim 17B wages under section 17B by making appropriate application in the writ petition referred above. He submits that the respondent did not make any such attempt as he was already employed, and hence he could not have filed an affidavit declaring that he is not employed elsewhere. He therefore contends that the respondent is not entitled to any wages, and the impugned order passed by the labor court is incorrect. Besides this, he contends that the respondent did not report to duty, and hence he is not entitled to the wages. Full stop. Next para. The learned counsel for the respondent, however, on the other hand, contended that the petitioner had obtained an order of stay of the order of reinstatement of the respondent. He submits that as a result, the respondent could not report to duty, and he retired from service on so-and-so date. Yavato?
35/2015.
34/2015.
34/2015.
Full stop. He therefore contends that after the dismissal of the writ petition, the respondent was entitled to the wages that he would have earned if the petitioner had reinstated him into service. Reinstated respondent into service. Full stop. Next para. I have considered submissions of the learned counsel for the petitioner and the learned counsel for the respondent. Next para. The award passed by the labor court shows that the respondent shows that the order of dismissal of the respondent from service was set aside, and the petitioner was directed to reinstate the services of the petitioner with all benefits and continuity of service. However, the claim for back wages was rejected. This award of the labor court was passed on 22/5/2009. Full stop. This award was challenged by the petitioner in WP number 84242 of 2010, and therefore the respondent was prevented from reporting back to duty. Full stop. The writ petition referred above was dismissed by this court on 25th of April 2015, but by 30th of April 2015, the respondent had retired from service. Therefore, the petitioner had successfully ensured that the respondent did not report to duty from the date of the order of reinstatement by the labor court till the dismissal of the writ petition filed by it before this court. Full stop. The respondent is therefore deprived of the wages during this period, and hence full stop. Hence the respondent was justified in initiating proceedings under section 33C2 of the Industrial Disputes Act 1947. Full stop. It is seen from the impugned order that the petitioner itself made a statement before the labor court that the respondent is entitled to a sum of rupees 17,38,117 after deducting a sum of rupees 2,17,950 towards statutory deductions. Therefore, the labor court was justified in directing the petitioner to pay a sum of rupees 17,38,117 within 3 months. Also, nothing is paid. Deposit ಮಾಡಿಲ್ಲ ಇಲ್ಲಿ?
ಇಲ್ಲ ಇಲ್ಲೇನು 50% ಇಂಟೀರಿಯರ್ ಮಾಡ್ರ
ಮಾಡಿದ್ದೀರಾ? Order sheet ಕೊಡಿ.
ಇಲ್ಲ ಮಾಡಿಲ್ಲ.
Who will pay this 9% interest? Who will pay? Public money. You are playing with public money.
I told them, my lord, sir. I instructed them.
Full stop. Hence the petition is dismissed. The respondent, petitioner is directed to comply with the order passed by the Labor Court in application number 7/2018 in letter and spirit within a period of
6 weeks. 4 weeks.
1 month from today, failing which the respondent is liberty to take such steps as are available in law. Execution ಹಾಕೊಳ್ಳಿ ಅಷ್ಟೇ.
On the principles of my lords, no work, no pay. Because
Who did not allow him to work?
thereafter, my lords, the corporation
Is it
itself
your
has
case that he
modified
was
their
employed
policy.
elsewhere? That is not your case.
Lords,
Is it your case that he was employed elsewhere?
No, we are not saying that, my lord. The another aspect that if a person, my lords, who did not join or not sought for, my lords, any 17B nor filed modification of interim order, not taken any steps, my lord, then he come up with a plea without working for payment of the wages. That would, my lords,
Sorry, just next.
In this case, but give the joining report and also legal.
Dismiss ಆಯ್ತಲ್ಲ
ಅಲ್ಲ,
ಬಿಡ್ರಿ.
ಆಯ್ತು sir. ಅಲ್ಲ, ಅವ್ರು ಹೇಳ್ತಾ ಇದಾರೆ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ joining report.
ಆದ್ಮೇಲೆ ತಿರುಗಿ ಯಾಕೆ ರಾಧಿ?
Joining report already got.
at least 6%, my lords.
No.
Apologies, my lord. May I please submit regarding the previous matter, my lord? List
Huh?
to second matter. Apology.
Ah.
Submission, my lord. The clarification was with regard to the second point that I raised regarding extension of time, my lord. The stage for submission of the tender documents was closed in that matter.
You are permitted to submit.
That maybe if may clarify.
It's already mentioned. You're permitted to submit your bids.
Because the next
Response
stage is
to
for,
annexure D.
please,
My lord, once e-procurement is closed,
the online
it is
portal.
open not a problem, my lord, online process.
ಅದು ನೀವು ಯಾವ process ಮಾಡ್ಕೊಳ್ಳಿ, but do whatever that needs to be done. Whatever that needs to be done, you have to permit him. ಬೇರೆ ಕೇಸಸ್ ಎಲ್ಲ ಮಾಡಿದೀವಲ್ಲ.
ಇಲ್ಲ ಅದರಲ್ಲಿ ತಪ್ಪಾಗಿದೆ, ನಾ ಮೆಮೊ ಫೈಲ್ ಮಾಡ್ಬೇಕಾಗಿದೆ. ಆಲ್ರೆಡಿ ಫೈನಾನ್ಷಿಯಲ್ ಬಿಡ್ ಕ್ಲೋಸ್ ಆದ್ಮೇಲೆ ರಿಟ್ ಫೈಲ್ ಮಾಡಿ ಇದು ಮಾಡಿದ್ರು.
Financial bid is not yet opened, my lord.
ಇವ್ರ ಕೇಸ್ ಅಲ್ಲ, ಅವ್ರ ಬೇರೆ ಕೇಸ್.
ಬೇರೆ ಫೈನಾನ್ಷಿಯಲ್ ಬಿಡ್ಸ್ ಎಲ್ಲ ಓಪನ್ ಆಗಿದೆ.
ಎಲ್ಲ ಮುಗಿದು ಹೋಗ್ಬಿಟ್ಟಿತ್ತು, ಆಮೇಲೆ ರಿಟ್ ಹಾಕಿ.
Federal ಆಗಿಲ್ಲ, sir.
ಈ ಕೇಸ್ ಎಲ್ಲ ಮೈ ಲಾರ್ಡ್.
Then you get instructions, we'll list it tomorrow itself.
ಎಸ್
ಅದೇನು list tomorrow ಅಂತ ಮಾಡಿ.
Clarification in that. regard.
No, but he says financial bids are opened.
ಇಲ್ಲ
Not in this matter.
ಇನ್ ದಿಸ್ ಕೇಸ್ ಅಲ್ಲ, ಅದರ್ ಕೇಸ್ನ
ಈ ಕೇಸಲ್ಲಿ ಏನ್ ಹೇಳಿ?
ವೆರಿಫೈ ಮಾಡಿ ನಾಳೆ ಹೇಳ್ತೀನಿ.
ನಾಳೆ, ಎಸ್.
Please.
ಅದೇನೋ ಆರ್ಡರ್ ಮಾಡಿ ತೆಗೆದುಬಿಡಿ ಅದನ್ನು, ಸೆಟ್ ಅಸೈಡ್ ಟೈಪ್ ಮಾಡಬೇಡ ಅಂತ ಹೇಳಿ. List tomorrow.
Please.
You please hand over a copy of the writ petition.
Already, sir. Please.
Yes. Yes. R.S. Siddhapurkar, Satyanarayana Acharya, Gaurish Kashampur, Ambekar.
Tomorrow, Your Lordship.
Tomorrow.
Next week, senior counsel will be out of state.
Madam, when do you want it?
Tomorrow, Your Lordship.
Tomorrow ಆಗಲ್ಲ. This is a KLR matter. ಯಾವತ್ರಿ? 28th. Learn counsel for the
This week, any date, but it may be fixed, Your Lordship.
learn counsel, your Gaurish Kashampur's colleague.
Please, ma'am.
Learn counsel for response 5, 7 and 8 seeks time. List on date put. Yes. Bhimaraya. Arun Kumar Amargundappa.
My lord, in this case, our records are misplaced. I have informed land tribunal, my lord. 2 weeks time may be granted, I will say.
Learned HCGP seeks time to comply the order dated so and so.
Kindly ಒಂದು ಡೇಟ್ ಗಿವನ್ ಮಾಡಿ.
List on date, yes. ಯಾವತ್ತು ಬೇಕು?
2 weeks ನಲ್ಲಿ ಯಾವ್ದಾದ್ರು.
Mr. DP Ambekar.
And
79 AB land reforms matter. The petitioner.
When was the order passed?
Order passed is forfeiture of lands for violation of this thing.
When was that?
That order was passed. I'll just narrate the brief. The writ is based on the premise that merely order passed will not become an order. It has to be communicated. There was no date fixed for passing the order as such by the authority. By the time I came to know it, there are Karnataka ordinance was already there. May I just briefly state the facts, my lord? The petitioner, my lord, she hails from a family of agriculturists. Her husband owns agricultural land. Her father-in-law owns agricultural lands.
She purchased survey number 19/3 measuring 4 acres. Thereafter, my lord, within 2 months, my lord, notice was issued by the assistant commissioner that the sale deed is violative of 79A and B and asked her to produce certain document. She submitted whatever document, she appeared on the date fixed and submitted whatever document she had. Thereafter, the matter was posted for orders without assigning any date. Thereafter, my lords, behind our back, an order was passed on 10/8/2018. No intimation was received by the post as enumerated on the rules. In fact, my lord, it is pertinent to note the authority itself did not know that order has been passed. It issues a second notice to me, again fixing a date. I was under impression that it is the earlier proceeding itself. I did not know that it is a second new fresh proceeding. I again appeared, I stated that whatever document I had, I already submitted. Thereafter, again the matter was posted for orders without fixing any date. Suddenly, my lords, the case worker, he puts up the earlier order which has been passed. Therefore, second proceeding is dropped on the ground that already order is passed. Now, my lords, I'd like to take your lordship. In the meanwhile, the Karnataka Land Reforms Ordinance, it came to be passed. May I take your lordship, please? Annexure G,
Yes, government get the file
Yes,
enter file.
to see whether this earlier notice was served on the petitioner or not.
Well, I have produced the entire order sheet of both the proceedings.
Yes.
I will secure records.
And AGA is directed to secure the entire file relating to the order relating to the proceedings bearing number LRF 79A/B:CR-11/2015-16. Yes, list on ಯಾವ
And also another file.
ಅದು
Annexure.
ಬೇಕಾಗಿಲ್ಲ, ಅದು we are not concerned because that was closed.
Pardon?
That was closed subsequently. First ಅದನ್ನ ನೋಡ್ಬೇಕಲ್ಲ. Second is closed without passing any orders.
Or only relying on the earlier this.
List on ಯಾವ
Alla, that is maybe relevant, my lords, because by the time the ordinance was passed, I have not yet communicated. Though the rules. Alla, let both of them be secured.
ಫಸ್ಟ್ ಬರ್ಲಿ ಅದು
Please.
Yes, Neva Chumkot.
Submission, my lord, in previous case, 41, serial number 41.
Huh?
Serial number 41, Sergeant, stay has to be extended.
Then extended, interim order is extended.
And
Neva Chimkot,
in 44, there was an order of stay. Earlier.
44 ಅಲ್ಲ, 44.
44.
44 interim order is extended. 45, Neva
If I appear
Chimkot.
for respondent, filed objections notes, this court on the earlier date sought to produce sale deeds notes. Earlier notes under 49A of Land Revenue Act.
She has filed the petition, let
Yes,
her
yes,
argue.
Yes.
Lordship, still I am sticking on the same point, my argument. Lordship, annexure E,
Annexure?
Lordship, annexure E. The notification issued on 31/5/2021. Serial number 5 in the table, Lordship. Section 56, the powers, the deputy commissioner powers have been delegated to the regional joint director of land records of concerned division, Lordship.
Yes.
The order has been passed on 15/7/2021, Lordship. So by the day, Lordship, the deputy commissioner has no power to pass the order.
Where is the impugned order?
Impugned order is annexure F, Lordship, which is passed on 15/7/2021.
Whether this notification was gazetted?
Yes, Lordship, they have collected the information.
Gazette ಆಗಿದೆಯಾ?
ಆಗಿದೆ 7/6/2021 ಆಗಿದೆ ಅಂತ.
From Commissioner Office, they have sent this intimation on 7/6/2021.
7/6.
7/6.
ಅದಾದ್ಮೇಲೆ ತಿರ್ಗಾ ಮಾಡಿ ಇಂಪ್ಯೂಗ್ಡ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು.
Yes, what are the facts?
Facts being this, Lordship, the respondent number 4 and 5 have filed the application under section 49 of the 4 and 5, Lordship, respondent. The filed application before the DDLR, respondent number 2, Lordship, under section 49 of Karnataka Land Revenue, for taking the fresh survey, Lordship. Lordship, I'll take the, it is annexure,
See,
annexure A, Lordship, annexure A, their application, Lordship, their application, their prayer, Lordship, in para 12, sorry, Lordship, in page 12, last 4 lines, Lordship, their prayer,
yes.
ಕಾರಣ ಅವರು ತಾಲೂಕಾ ಸರ್ವೇಯರ್ ಬಸವನ ಭಾಗೇವಾಡಿ ಹಾಗೂ ಭೂ ದಾಖಲೆಗಳ ಸಹಾಯಕ ನಿರ್ದೇಶಕರು ಬಸವನ ಭಾಗೇವಾಡಿ ಗ್ರಾಮದ ರೆವಿನ್ಯೂ ಸರ್ವೆ ನಂಬರ್ 129ರಲ್ಲಿ 1 ಮತ್ತು 3 ಹಿಸ್ಸೆಗಳನ್ನಾಗಿ ತಯಾರಿಸಿದ ಆಕಾರ ಬಂದ್ ಪಿಟಿ ಶೀಟ್ ಅನ್ನು ರದ್ದುಪಡಿಸಿ ಪುನಃ ಹಕ್ಕು ರಕ್ಷಣಾ ಪ್ರಕಾರ ಹಾಗೂ ವಾಸ್ತವಿಕವಾಗಿ ಜಮೀನುಗಳನ್ನು ಸಾಗುವಳಿಯಲ್ಲಿ ಹೇಗೆ ಇರುತ್ತವೆಯೋ ಹಾಗೆ ಪುನಃ ಪೋಡಿ ಪ್ರಕರಣವನ್ನು ಮಾಡಿ ಹೊಸ ಪಿಟಿ ಶೀಟ್ ಅನ್ನು ತಯಾರಿಸಲು ಆದೇಶ ಮಾಡಬೇಕೆಂದು ಪ್ರಾರ್ಥನೆ. The application was rejected by the third respondent, Lordship, DDL, which is at
Let's see.
But
annexure,
where are reading page number 12 alla?
page number 12, Lordship. Last
an-
4 lines, Lordship, their prayer. They are sought for the
This
fresh
page number 12 is the front portion, is it? This is the page
Annexure-
number 12.
Next page.
annexure A, next page, Lordship. Page.
Where are reading?
Last 4 lines, Lordship.
Karana,
ಕಾರಣ so and so
Taluk
ತಾಲೂಕು
surveyor, Bhagavadi.
ಭಾಗೇವಾಡಿ ಹಾಗೂ ಭೂ ದಾಖಲೆಗಳ ಸಹಾಯಕ ನಿರ್ದೇಶಕರು ಬಸವನ ಭಾಗೇವಾಡಿ ಗ್ರಾಮದ ರೆವಿನ್ಯೂ ಸರ್ವೆ ನಂಬರ್ 129ರಲ್ಲಿ 1 ಮತ್ತು 3 ಹಿಸ್ಸೆಗಳನ್ನಾಗಿ ತಯಾರಿಸಿದ ಆಕಾರ ಬಂದ್ ಪಿಟಿ ಶೀಟ್ ಅನ್ನು ರದ್ದುಪಡಿಸಿ ಪುನಃ ಹಕ್ಕು ರಕ್ಷಣಾ ಪ್ರಕಾರ ಹಾಗೂ ವಾಸ್ತವಿಕವಾಗಿ ಜಮೀನುಗಳನ್ನು ಸಾಗುವಳಿಯಲ್ಲಿ ಹೇಗೆ ಇರುತ್ತವೆಯೋ ಹಾಗೆ ಪುನಃ ಪೋಡಿ ಪ್ರಕರಣವನ್ನು ಮಾಡಿ ಪಿಟಿ ಶೀಟ್ ಅನ್ನು ತಯಾರಿಸಲು ಆದೇಶ ಮಾಡಬೇಕೆಂದು ಪ್ರಾರ್ಥನೆ.
Yes, this is rejected.
Yes, Lordship, that has been rejected, which is annexure C, Lordship,
Annexure?
C,
Page 35.
page 35, Lordship.
Yes.
The detailed order was passed, Lordship. In page 36, Lordship, they have given the table. ಬಸವನ ಭಾಗೇವಾಡಿ ತಾಲೂಕು ಗ್ರಾಮದ ರೆವಿನ್ಯೂ ಸರ್ವೆ ನಂಬರ್ 129/1 ಆಕಾರ ಬಂದು ಒಟ್ಟು ಕ್ಷೇತ್ರ 5 ಎಕರೆ 24 ಗುಂಟೆ ಇರುತ್ತದೆ. ಇದರಲ್ಲಿ ಹಿಸ್ಸಾ ದುಶವಾರು ಶೇತುವಾರ್ ನಂಬರ್ 2017-18 ಈ ಕೆಳಗಿನ ಹಿಸ್ಸಾಗಳಂತೆ ಇರುತ್ತದೆ. 35 ಗುಂಟೆ ಏನಿದೆ ಸರ್ವೆ ನಂಬರ್ 129 ಹಿಸ್ಸಾ 3ರಲ್ಲಿ ಮೋಹನ್ ಭೀಮರಾಯ್ ವಣರೊಟ್ಟಿ, that is present petitioner and respondent before the revenue authorities.
So you have purchased it from this Rajshekar. ಯಾರಿಂದ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ ನೀವು?
Vijalakshmi.
Lordship,
Vijalakshmi. Sale deed, my lords, as per
regarding purchase of the Vijayalakshmi, there is no sale deed, Lordship.
Para 41 ಓದಿ. The page 41. ಬಸವನ ಭಾಗೇವಾಡಿ ತಾಲೂಕು ಭಾಗೇವಾಡಿ ಗ್ರಾಮ ಸರ್ವೆ ಹಿಸ್ಸಾ ದಾಖಲೆಗಳು ಕಂದಾಯ ದಾಖಲೆಗಳು ಕಾಲೋಚಿತಗೊಂಡಿರುತ್ತವೆ. ಕಾಲೋಚಿತ ಅಂದ್ರೆ
Periodically they merged into the records, Lordship. Lordship, before that, the revenue authority, the respondent number 3 have mentioned the reasons. First
Madam,
ಅಲ್ಲಿ
please
table ಇದೆ.
read that. I should understand your case.
Yes, Lord.
ಬಸವನ ಭಾಗೇವಾಡಿ ತಾಲೂಕು ಭಾಗೇವಾಡಿ ಗ್ರಾಮದ ತಯಾರಿಸಿ ಹಿಸ್ಸಾ ದಾಖಲೆಗಳು ಕಂದಾಯದ ಕಾಲೋಚಿತಗೊಂಡಿರುತ್ತವೆ. ಮೇಲ್ಮನವಿದಾರ ನಂಬರ್ 1 ರವರು 121 ವಿಸ್ತೀರ್ಣ 5 ಎಕರೆ 35 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣ ಜಮೀನನ್ನು ಬಸನಗೌಡ ತಂದೆ ಸಂಕನಗೌಡ ಪಾಟೀಲ್ ಅವರಿಗೆ ನೋಂದಾಯಿತ ಖರೀದಿ 1088ರಲ್ಲಿ ಕ್ರಯಕ್ಕೆ ಕೊಟ್ಟಿರುವುದು
ಖರೀದಿ
ಖರೀದಿ
ಪತ್ರದಿಂದ ಖಚಿತಪಟ್ಟಿದೆ. ತದನಂತರ ಸದರಿ ವಿಜಯಲಕ್ಷ್ಮಿ ತಂದೆ ಶಿವನಗೌಡ ಪಾಟೀಲ್ ರವರಿಗೆ ಈ ಜಮೀನು ಹಸ್ತಾಂತರವಾದರೆ ಈ ಜಮೀನು ಹೇಗೆ ಹಸ್ತಾಂತರವಾದ ಬಗ್ಗೆ ದಾಖಲೆಗಳು ಹಾಜರುಪಡಿಸುವುದು. ವಿಜಯಲಕ್ಷ್ಮಿ ತತ್ಕಾಲ್ ಪೋಡಿ ಯೋಜನೆಯಡಿ ದಾಖಲೆ ತಯಾರಿಸಿಕೊಂಡು ಹಿಸ್ಸಾ ನಮ್ಮನ್ನು Yes, Mr.
Yes, Lords.
Lordship, one more submission. After this order, Lordship, They appeared before the deputy commissioner. They filed the
Yes.
revision appeal. In that, lordship, there, kindly see the prayer para, lordship. Page 40,
Page 40,
page 40. Prarthane ಅಂತ.
43,
Page 40, lord. 40,
0 is,
annexure D. Annexure D, page 40, lord. Next,
annexure D na,
D.
that is page 43. ಪ್ರಾರ್ಥನೆ.
ಪ್ರಾರ್ಥನೆ. ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ತಾಂತ್ರಿಕ ಸಹಾಯಕರು ಹಾಗೂ ಪದನಿಮಿತ್ತ ಭೂ ದಾಖಲೆಗಳ ಸಹಾಯಕ ನಿರ್ದೇಶಕರು ನ್ಯಾಯಾಲಯದಲ್ಲಿ ವಿಜಯಪುರ ಜಿಲ್ಲೆಯ ಬಸವನಬಾಗಿ ತಾಲೂಕು ಪೈಕಿ ಬಸವನ ಬಾಗೇವಾಡಿ ಗ್ರಾಮದ ರೆವಿನ್ಯೂ ಸರ್ವೆ ನಂಬರ್ 129/1ರಲ್ಲಿ ತಯಾರಿಸಿದ ಸೊ ಅಂಡ್ ಸೊ 2018 ಪಿಟಿ ಶೀಟ್ ಅನ್ನು ರದ್ದುಪಡಿಸಿ ರಿವಿಷನ್ದಾರರು ಹಾಗೂ ಎದುರುದಾರರು ನಂಬರ್ 14685 ದಿನಾಂಕ 30/10/1972 ಪ್ರಕಾರ ಹೊಸ ಪಿಟಿ ಶೀಟ್ ಅನ್ನು ತಯಾರಿಸಲು ಆದೇಶವನ್ನು ಪಾಲಿಸಲು ಭೂ ದಾಖಲೆಗಳ ಸಹಾಯಕ ನಿರ್ದೇಶಕರು ಬಸವನ ಬಾಗೇವಾಡಿಗೆ ಆದೇಶ ಮಾಡಬೇಕೆಂದು ಪ್ರಾರ್ಥನೆ. Lordship, now they are seeking that, Lordship, when the partition has been taken place, ವಾಟ್ನಿ ಯಾವಾಗ ಆಗಿದೆ ಅವಾಗಿಂದ
Yes.
ಸರ್ವೆ
Yes,
ಕೇಳ್ತಾ
Mr.
ಇದೆ.
Yes, Milord.
You have sold it, you have sold this.
I haven't sold it. Milord.
Inner-
If I may pursue your lordship on the factual aspects of the case. Objections, Milord. Para number 2, I have produced family pedigree.
Family,
Family pedigree. Objections only. Para 2.
the pedigree, gidigree ಎಲ್ಲ ಇಲ್ಲ.
Illa, I'll appraise your lordship on the factual aspects
They're
because
not-
the division as per Milord's their claim.
Not a civil dispute.
Yes, Milord, I fairly concede.
It's a revenue survey dispute.
Yes, Milord.
If some property is sold to her
Yes,
or him,
yes.
this property has to be separated from the main survey number.
Madly. Milords, I am not disputing their sale.
35
rate, Milords.
guntas has to be separated from the main survey number.
Yes, Milord.
How it has to be done? They already done the survey, they already fixed the boundaries.
Not that survey itself was challenged before the under 49A, Milords.
That is rejected.
Yeah, that is rejected, Milords.
Ah.
Because, Milords, the carbon which they have obtained, Milords, that was fraudulently obtained without, Milords, giving any notice to me.
Yes.
And that apart, Milords, insofar as, Milords, the division is concerned, the division, Milords, for that very purpose, I need to appreciate, Milords, in para 2 only. Para 2 of my objections. Kangan Gowda, Milords, he is the original propositor, Milords, to 5 acres, 24 guntas. Milords, by Watney, as per, Milords, annexure R2, R1, Sankan Gowda.
R1 is registered. Is it registered document?
Watney Patra ide.
ವಾಟ್ನಿ ಪತ್ರ ನೀವು ಇಟ್ಕೊಳ್ಳಿ ಜಾಬ್ ಅಲ್ಲಿ.
Yes, Milords, this is registered.
ಎಲ್ಲಿ
Registered
ರಿಜಿಸ್ಟರ್
number,
ಎಲ್ಲಿ ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ? ಸ್ಟಾಂಪ್ ಅಂಡ್ ಸೀಲ್ ಇದೆ ಅಷ್ಟೇ.
seal ಇದೆ. But the, only on basis of this, Milords, the revenue entries, Milords, were entered into. Even as per their claim, Milords, their sale deed is running to the, running contrary to my sale deeds, Milords, which I have obtained.
If that is the case, you file a civil suit.
Milords, but I have already been placed, Milords, in possession by virtue of those sale deeds. My sale deeds may be kindly taken into consideration, Milords. Further sale deeds ಇದೆ. ಅದರಲ್ಲಿ my boundaries.
ಈಗ ಸರಿನೋ ತಪ್ಪೋ ಅವರಿಗೆ ಪೋಡಿ ಆಗಿದೆ. 35 ಗುಂಟೆ ಪೋಡಿ ಆಗಿದೆ.
Yes, Milords.
Correct?
Yes.
Boundaries are fixed.
No, boundaries, Milords, boundaries itself I am disputing, Milords.
Why?
Because, Milords, if I may, if Lordship may appreciate, you know that in document R9 may kindly be perused for a moment. Those 3 strips, Milords,
R9.
R9, Milords, page 35. For your reference, Milords, that strip number 367. That strip belongs to the vendor of the petitioner. On the western side, Milords, western side of those 3 strips, there is a well. There is a well. Yes, Milords. And to west of that well is, Milords, a road. The Watney was made in such a purpose, Milords, because all the 3 strips should have access to the well as well as the road. Accordingly, Milords, revenue entries were entered as per annexure R2.
Yes.
ನಂದು R2 ಅಲ್ಲಿ ಇದೆ. Now, my lords, the Ackerman which they have obtained, my lords, what they state is, ಇವಾಗ each strip belongs to each of their family member. ಅಂದ್ರೆ 367 belongs to Vijayalakshmi, 364 belongs to Ningangowda, and 362 belongs to Basangowda. This Ningangowda and Basangowda, 364 and 362 are sold to me, which is respond number 4 and 5.
360?
364 strip and 362 strip. These two strips of land, they are sold to me.
Where is the OD in favor of the petitioner?
OD,
Where is the OD sketch in favor of the petitioner?
ಅದು I do not have lots access to that. So, ಅವ್ರ ಹತ್ರ ಇತ್ತು. So this is my lords as per my
ಹತ್ರ ಇದೆಯಪ್ಪ, ಬಟ್ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿದಿರಲ್ಲ, ನಿಮ್ಮ ಹತ್ರ ಇರ್ಬೇಕಲ್ವಾ? You challenge it before the deputy director.
Yes, my lords,
Then you must bound to have it.
I do not have that document. Only except for that documents, my lords, my sale deeds, my lords, for a moment, lordship may kindly appreciate. Sale deeds, they are 1998 ಅಲ್ಲಿ ನನ್ಗೆ sale deed ಆಗಿದೆ.
Okay.
Subsequently 2017 ಅಲ್ಲಿ ಅವ್ರ sale deed.
What is the OD sketch as per the petitioner's purchase?
Yes, my lords. ಇದೇ sketch ಅಲ್ಲಿ ಹೇಳ್ತೀನಿ. ಇದೇ sketch ಅಲ್ಲಿ.
Sketch ಅಲ್ಲಿ ನೀವು ಹೇಳೋದಲ್ಲ, ತೋರಿಸಿ ನನಗೆ.
Lords, I may, for a moment,
For the
lords.
petition, the learned counsel for the respondents are directed to place on record the POD and POD sketch prepared in respect of the property of the petitioner, which was the subject matter of appeal before the respondent number 3.
Two.
2.
DDLR. DDLR, two.
For the respondent number 2. List on, when do you want it?
Lords, Monday,
Yes, next.
like,
Worship, one request. Let the government file that notification, publication of notification.
Again, publish ಆಗಿದೆ, ತೋರಿಸಿ. Whether it is notified or not.
Notified, my lord, 7/6/2021.
Notify ಆಗಿದೆಯಾ?
Commissioner office in they have sent communication to all.
ಆಯ್ತು, produce ಮಾಡಿ.
on that ground, if lordship may appreciate, ಅದ್ರಲ್ಲಿ already lords on one date, lords, the proceedings were concluded. It was only reserved for orders, lords, subsequent to the
Should merely
notification that order has been passed. That arguments, everything were concluded, lords.
Yes,
That
you
was
can-
only reserved for orders ಅಷ್ಟೇ ಇತ್ತು.
Yes, yes, next. Avanish Mutt.
Colleague is on.
My lords, I am for the petitioner.
Impugned order is already.
Matter, my
superseding
lord,
the-
this,
Impugned
third
order.
respondent has challenged the impugned order that has been allowed and remanded the matter, my lord.
Matter has been remanded, but it's pending before the
So this
tribunal.
petition doesn't survive.
No, my lord.
Whether this petition survives or not.
Yes, my lord, it survives because we are
same
not
order
party
still
to the
Same order.
proceedings, my lord.
Same order, now it is pending before
We
the
are not
tribunal.
parties to the
We
earlier
are not party
petition.
to the
What
proceedings.
they say,
Then
they have got
ನೀವೇ
some.
ಹೇಳಕ್ಕಾಗಲ್ವಾ? Why do you bring your senior for this?
He is there, actually it's his case. He has been conducting the case. We are not parties to the writ petition.
The petitioner has challenged in all the bearing number so and so dated so and so passed with the respondent number 1. Conferring occupancy rights.
Occupancy, my lord, it's ceiling limit, my lord.
Ceiling limit.
Ceiling.
Ceiling
ಅದು. Passed with the respondent number 1, declaring accepting the declaration dated 27/1/1999 by Srimati Sharada Devi, na?
Yeah, Sharada.
By Srimati Sharada Devi, that 2.1 units was excess land. Next. The petitioners contend that they and the respondent number 3 are brothers and sisters of late Rajshekar, who succeeded to land bearing survey number 91 and 40/B, situated Jinnur village, Manvi Taluk, in terms of a partition deed dated 2/6/1972. The said Mr. Rajshekar filed a declaration in form number 11 before the respondent number 2 in respect of the aforesaid land. Full stop. Later, the respondent, land sealing proceedings were initiated against the respondent number, against the said Mr. Rajshekar before the respondent number 1. Full stop. During the pendency of the proceedings, Mr. Rajshekar died on 1/4/1982. Full stop. The respondent number 3 came on, was brought on record in the proceedings before the respondent number 1 as the sole legal heir of late Rajshekar. The respondent number 1, in terms of the order dated 27/1/1999, held that the lands in question are C-class lands and that the holding of Mr. Rajshekar was in excess and hence declared 2.1 units in the aforesaid survey numbers as excess land in terms of the impugned order dated 27/1/1999. Full stop. The respondent number 3 had challenged the aforesaid order before this court in WP number 6972 of 1999. This court, in terms of the order dated 1/2/2000, allowed the petition and quashed the order dated 27/1/1999 and remitted the case back to the respondent number 1 for fresh disposal. Full stop. After remand, the respondent number 1 once again passed an order dated 27/6/2007, holding that an extent, holding that 2.1 units was the excess land possessed by Mr. Rajshekar. The petitioners contend that they are also the legal heirs of the said Mr. Rajshekar, and that whether this 27/6/2007 was set aside.
Yes, sir.
Yes, sir. Yes, sir.
2000 iದೇನಾಗಿದೆ after this order was set aside ಏನಾಗಿದೆ?
It's still pending, matter.
Still pending, my lord.
It's only the civil rights that they are agitating. That can be.
No. ಏನಾಯ್ತು? They claim that the respondent number 3 had misrepresented that she was the only legal heir of Mr. Rajshekar, and she was conducting the proceedings before the respondent number 1. They contend that they came to know of the proceedings when the village accountant of Jinnur village came for inquiry to effect mutate the name of the respondent number 3 as the sole legal heir of Rajshekar. Immediately the petition number 6 filed objections against registering the name of respondent number 3 as the sole heir, consequent to which the Tahsildar conducted an inquiry in RRT number 138/2015-16 and rejected the request of the respondent number 3. Full stop. The petitioners are therefore before this court challenging the order dated 27/6/2007 passed by the respondent number 7. Full stop. Next, the learned counsel for the petitioners contends that in similar circumstances, the sister of Rajshekar, namely Srimati Sharada Devi, had filed WP number 19310 of 2007, challenging the orders dated 27/6/2007, and this court, in terms of the order dated 29/6/2012, had set aside the order dated 27/6/2007. Full stop. He therefore submitted that this petition may also be disposed of on the same lines. Next, the learned counsel for the respondent number 3 did not dispute the aforesaid fact. The learned AGA submitted that proceedings are underway before the respondent number 1. And in view of the order passed in WP number 19310 of 2007, this writ petition may also be disposed of, setting aside the order dated 27/6/2007. Next, in view of the aforesaid submission of the learned counsel for the petitioner and the learned AGA as well as the learned counsel for the respondent number 3, this writ petition stands disposed of on the same terms as in WP number 19310 of 2007. Consequently, the order dated 27/6/2007 passed with the respondent number 1, bearing number so and so, is quashed. And the case is remitted back to the respondent number 1, who shall consider the matter on merits and in accordance with law.
Please, ma'am, please.
Hema Kulkarni. Yes. C. Jagadish. C. Jagadish.
This matter has become infructuous minutes, and also it is covered matter, even
Well,
in
if it is
similar
infructuous, then we'll record your submission. Learned counsel for the petitioner, Srimati Hema L. Kulkarni, submits that the writ petition has become infructuous and is also covered by
judgment.
a judgment of this court in
I'll arrange.
WP number so and so.
Please.
In that view of the matter, this writ petition is dismissed as having become infructuous.
Please.
Non-amendment of cost rate.
This matter pertains to sealing matter, my lord.
Ah.
The records were called for by this honorable court
Hmm.
because other declaration was filed by the sister-in-law. That declaration was accepted by the land tribunal, holding that she doesn't have excess land.
Yeah,
Some of
record
the lands have
ತರ್ಸ್ಬೇಕಾ?
been included in those.
Record ತರಿಸ್ಬೇಕಾ?
How the records ಬೇಕಾಗ?
Is government
Yes.
learned AGA seeks time to comply the order dated so and so list on. Please amend the cost title.
Yes, my lord, we'll write to the.
This amendment part. Learned counsel for the petitioners amended the cost title office director to check and verify. List on so and so. Yes, Dheeraj Kumar.
Yes. My lord, let him
Hema.
get the records. my lord.
Hmm?
Yes, I will. Records ತರಿಸ್ಲಿಕ್ಕೆ.
ಹೌದು ಹೇಳಿದೆಯಲ್ಲ. Ready?
This is a case where land is utilized for the national highway, but no compensations are paid. because of the non-appearance of the land
My
council.
lord, particular this road is not come under National Highway Authority of India. This is come under State Highway, National Highway Division is separate. The respondent number 3 and 4 are the necessary party, my lord.
ಯಾರು?
Respondent number 3 and 4 are the necessary party.
Necessary party, ಇದಾರಲ್ಲ ಪಾರ್ಟಿ ಆಗಿದಾರಲ್ಲ.
But the respondent number 2 is not concerned with this road is.
So who
The state government is the respondent.
is government?
Yes, my lord. I have filed objections also.
If you're ready, you can argue.
I'm ready.
Yes.
I've also filed rejoined to that minutes.
Hmm.
In the statement of objection, what they have contended, it is. up
First
to-
in petition ಏನು ಅಂತ ಹೇಳಿ.
Please.
What is this land? When was it acquired? When was it used up? What is the land survey number?
150 minutes.
92/1.
192/1 million, measure 9 acres. And 2 acres have been utilized millions for State Highway 51 and also National Highway 150.
For state highway,
Exactly in between State Highway 51,
which was later upgraded to NH.
National Highway 150
When was it upgraded?
minutes. In the statement of objection, they have given the date minutes. 26/9/2012. The statement of objection, page number 1 minutes.
Page number?
Page number 1 of the statement of objection.
Para 2, my lord.
Para 2,
Yes.
it is submitted that the Union Ministry of the Road Transport of Highway New Delhi upgraded the earlier State Highway 51 and declared it as National Highway 150. Wide Gazette Notification 2312 dated 26/9/2012. Further, the Government of Karnataka, by Government Order dated so-and-so, 9/10/1998, has incorporated.
Judgment, Ravi Patil ಏನೋ ಇತ್ತಲ್ಲ.
Similar, similar. Similar.
What happened to his case?
The appeal is filed, it is still pending. No orders have been passed.
Then we'll consider it after the disposal of writ appeal. Barcode, since similar questions are pending consideration in writ appeal numbers also. Writ petition, this writ petition, office is directed to list this petition after disposal of writ appeal numbers also.
It could have been disposed of in the line of writ petition, they could have taken it.
ಬರ್ಲಿ ಅದೇನಾಗುತ್ತೆ ನೋಡೋಣ.
Late ಆಗುತ್ತೆ, ಮುಗ್ದಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ.
Then again they have to file one more writ appeal. Waste of time ಅಲ್ಲ. Time, money, resources. Yes, Ravi Patil. Gaurish Kashampur.
Writ appeal number 1.
State of hearing, your lordship, my lord, is to direct court commissioner to go and inspect the property.
बेंगलुरु से ईमेल्स आया था
हाँ?
बोर्ड से प्रस्थान के सिलसिले में
कन्नड़ा?
घर से आया हूँ। कल ईमेल बेंगलुरु से आया हूँ, मैं उसमें गेरेवाट का सदर प्रेसिडेंट हूँ।
आप
वकालतनामा डालना है।
आराम से बैठो पहले, आराम से बात करो.
फिर से ईमेल आया था
हाँ?
वक्फ बोर्ड
हाँ, वक्फ बोर्ड से ईमेल.
तो वो मैं खबरस्तान का गेरेवाट का प्रेसिडेंट हूँ, सदर हूँ, तो मैं उसमें वकालतनामा डालना चाहता हूँ।
वकालतनामा करना चाहते हैं. हाँ.
वो उसमें मैं गेरेवाट का सदर हूँ।
No,
हाँ.
they're concerned.
उसमें क्या भी कब्रिस्तान नहीं करके वो बोल रहे. कोर्ट से एक आदमी को भेजा था.
डाली
मैं सुनो जी पहले, सुनता नहीं. ठीक है, सुनता नहीं. ये जमीन में क्या भी खबर है, कब्रिस्तान है, तो देखने के वास्ते उसको भेजा था कोर्ट की तरफ से. उन्होंने रिपोर्ट किया कि क्या भी कब्रिस्तान उधर नहीं करके बोल रहे उन्हें. तो कब्रिस्तान नहीं तो सदर किधर से?
साथ से है वो कंटिन्यू है, उसका रिकॉर्ड है, फोटो है, मैं झूठ नहीं बोलते हम, आप रिकॉर्ड के मुताबिक हम देखिए।
अरे उन्हें गए थे उन्हें
इनपुट है, मैं खुद बोलूंगा सर।
उन्हें गए थे कल. कब को गए थे
11 बजे से 12 बजे तक नहीं थे लोग।
18th, madam.
हाँ?
On 18th.
हाँ.
I have mentioned that I was late for 1 hour and I have mentioned in the report also, madam.
क्या रिपोर्ट है?
वेरीफिकेशन से हम झूठ नहीं बोलते, करेक्ट है, कब्रिस्तान है। पूरा ओल्ड रिकॉर्ड है, फोटो है।
किधर है फोटो?
है मेरे पास।
My lord,
मैं वकालत में जाने दीजिए, मैं पूरा रिकॉर्ड दे दूंगा।
during the time of inspection, my lord, they
Board
have-
is already represented through the
Work-
council,
work-
my lord.
work-
He is nowhere concerned.
my lord, I have mentioned in
Work
the
is,
report that
Work is there to protect the right.
नेक्स्ट डेट दीजिए, मैं पूरा
This is what been created in this matter, my lord, since property is now, my lord, within the municipal limits. They want to create records in respect of a private property and they want to claim it as their property.
my lord, during the time of inspection, they have showed me some photographs also, and they contend that the graves existed.
Son
in-
was there?
No, my lord, he is not. I have mentioned the name of that person who has shown me the photos. And I have taken the witness signature in regard to that. But on the date of.
But what is this mound?
That is
ಎಲ್ಲ
a
municipality
garbage dump.
garbage.
Garbage is there, my lord.
पूरा
I have
correct है।
inspected that also, my lord.
तो सही है बिल्कुल। बिल्कुल सही है।
क्या सही?
वो कब्रिस्तान है, उसका एरिया जो बाउंड्री है ना, बाउंड्री बता रहा हूँ।
Boundary is constructed by the railway
कुछ
department.
नहीं समझा नहीं। तो पूरा एक मेरा मौका दीजिए सर, मैं पूरा रिकॉर्ड देके मैं जब रिजेक्ट करूँगा।
Let him
ये
go and
garbage
submit whatever records he want to submit before the work board.
क्या
Work
भी
board is
documents
represented.
है तो वकील को रख के वो डालो।
उसके पास ना-
आपके पास सुन, अबे सुनो भाई, सुनने रही नहीं वो। आपके पास क्या भी डॉक्यूमेंट्स है तो वकील रख के डालो केस में, देखेंगे, ठीक है? हाँ, कब को
अब जब टाइम लगे, कम से कम 1 महीना दीजिए।
1 महीना नहीं होता, 1 महीना नहीं होता, 10 दिन, 10 दिने, 10 दिने, 10 दिने
He is
होना है
more-
तो ले लो, नहीं तो 10 दिने दे दूं।
It is the property which is registered by the work.
Mr.
now,
Somebody has come, we'll let him hear.
Manoj, this is what Manoj is sought to be
Let us
created.
hear him.
I do not even know what is his name and who is he. At least I should,
What is,
I
क्या
can make
नाम है
him a party.
आपका, नाम क्या?
What is his name? I don't know.
पूरा भाई रजिस्टर है।
क्या नाम जी तुम्हारा? नाम तो नाम क्या है जी तुम्हारा?
ये देख साहब,
नाम क्या है पूछ रहे?
ये बताइए आप।
नाम क्या है पूछ रहे?
मेरा नाम हौस कुरैशी, मोहम्मद हौस। स्टेट गवर्नमेंट ऑफ स्टेट पूरा बैठा के देख लीजिए सब दोनों हुई।
ये कब्रिस्तान होगा,
तो तब
कब्रिस्तान होगा, लेकिन ये रेलवे लाइन है ना, ए, सुनो जी तो थोड़ा, ये रेलवे लाइन है ना, रेलवे लाइन, हाँ, रेलवे लाइन के ऊपर, रेलवे लाइन के ऊपर क्या भी कब्रिस्तान नहीं
100% कब्रिस्तान है सर।
है।
बल्कि 100 है तो 200 नंबर दे सकते हैं। 100% कब्रिस्तान है। अब बड़ खबर है,
अभी उन्हें गए थे, उन्हें
कुछ नहीं देखे, रंग है।
रंग है।
कसम खा के बोलता हूँ, मैं जो कुछ कहूँगा अल्लाह को हाथ से जानते हुए सच
ठीक है,
कहूँगा।
ठीक है, ठीक है,
सच
वो
के सिवा कुछ नहीं।
हाँ, ठीक है, वो ठीक है। अगर अगर कबर नहीं दोबारा मैं बेचता हूँ, कबर नहीं तो 1 लाख रुपए,
बिल्कुल माना।
1 लाख रुपए, हाँ, ठीक है।
पूरा रिकॉर्ड के साथ
Barkoli, the report of the commissioner, this commissioner appointed by this court in terms of the order dated so and so has submitted his report, which indicates that there are no graves on the north of the railway line.
Yes, my lord.
Full stop. At this stage, a person named, क्या नाम?
इधर नाम मोहम्मद गौस कुरैशी,
Muhammad Gauss Qureshi,
सन्ना हाजी शेख महबूब।
Muhammad Gauss Qureshi, son of Haji Sheikh Mehboob, submits, has appeared before the court and submits that he was the president of the managing committee constituted by the Waqf board for maintaining the graveyard, Muslim graveyard. He therefore submits that he is in. 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 He is in It's-
It is our
This
ancestral
person
property.
is in no way concerned with the property in question. Next para. Since the issue relates to the claim by the Waqf board,
And the work
That
board is
the-
already represented. My contention, work board, my lord, has requested the municipality to make an entry, based on which municipality has made an entry, which is the subject matter of challenge before this
Yes,
court.
but-
I have
but
made,
please
my
wait.
lord, the work board as a
Allow
party.
me to complete my dictation. Yes, Janata. That the property in question belongs to it, comma, Mr. So-and-so Muhammad Yena, so-and-so Qureshi. Deserves to be granted an opportunity to come on record. Full stop. Hence, list on one date put out. 3/2. 3 next, 3 तारीख next महीने. List on 3rd February. ಇದು commission fee ಬಂದಿದ್ಯಾ?
ಹಾ, ಕೊಟ್ಟಿದ್ವಿ.
ಅದನ್ನ ಮೇಲೆ ಸೇರಿಸ್ಕೊಂಡು he
May I request on
acknowledges the
4th, my
receipt.
lord. May I request on 4th.
He acknowledges the receipt of the commission fee. Full stop. Yes, list on 3rd. Next.
Please.
May I request on 4th, my lord.
4th
Something
ಆಗಲ್ಲ.
can-
ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿದ್ವಲ್ಲ ಯಾವ ಕೇಸು ಅಂತ.
In this matter, my lord, I require some time to get, my lord, the instructions, because the last date of
For the
hearing.
petitioner seeks time. List on so and so. Mahadev Patil. Mahadev Patil.
The petitioner land has been notified as revenue village, my lord, that is uninhabitable, my lord, by notification by the respondent, my lord. Where, my lord, petitioner family having their own land and they filed a suit and it was decreed in their favor and they are entitled share in that portion of the property, my lord. The petitioner land, my lord. The respondent number one here has declared as a revenue village, my lord.
Revenue village ಅಂದ್ರೆ?
My lord, this
Unrecorded habitation.
habitations, my lord, which has not unrecorded habitation, my lord, with like thandas, my lord. Now they are recognized, my lord, by taking those portion in government under, my lord. So earlier, my lord, English or thanda, it was not recognized, my lord. My deputy commissioner by notification, my lord, it is now notified as an habitual for revenue land and where, my lord, the land of the petitioner has been included in that portion, my lord. Survey number 1160, my lord, to the extent of 1 acre 32 gunta, my lord, as per annexure A, my lord. That has been challenged before this court, my lord.
What is he trying to say?
My lord,
You don't have file also.
Huh?
my lord, the petitioner land has been notified, my lord, as a revenue village, my lord, in the said notification, my lord.
Yes.
And said land has been acquired, my lord, by the government, stating.
Acquired.
ಅಂದ್ರೆ ನೋಟಿಫೈಡ್ ಅಂದ್ರೆ ಅದು ಇದು ಅನ್ನು ರೆವೆನ್ಯೂ ವಿಲೇಜ್ ಅಂತ ಬಂದ್ಬಿಟ್ಟು.
Land Reform Act.
These are required for private persons. It will be restored to him.
Yes. So this, there's a declaration to section 38A.
ಹೌದು ಸ್ವಾಮಿ.
ಏನಂತಾಗಿದೆ? ಬಸವನ ಬಾಗೇವಾಡಿ ಕೃಷ್ಣಾಪುರ.
ಕೃಷ್ಣಾಪುರ ಅಂತ ಮಾಡಿದ್ದಾರೆ ಮೇಡಮ್.
ಕೃಷ್ಣಾಪುರದಲ್ಲಿ
ಈ ಲ್ಯಾಂಡ್ ನನ್ನ ಪಟಿಷನರ್ ಲ್ಯಾಂಡ್ ಇಸ್ ಬಿನ್ ನೋಟಿಫೈಡ್ ಮೇಡಮ್.
ಯಾವುದು?
Survey number, both are the, my lord, petitioner land, but my survey number in, I claiming that in respect of survey number 1160. Bar 1, to the extent of 1 acre.
Would you say it is your land?
My lord, I filed the suit, it is, my lord, suit for partition, my lord, which has decreed in my favor, my lord. And the final decrees are pending for the court, my lord. And I have made the representation before the revenue authorities also, my lord.
ಏನಲ್ಲಿ ಹೆಂಗ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಮಾಡಿದ್ದಾರೆ? Who has laid a claim? You know what 38 is?
38 is any agricultural labor, agricultural labor ordinary residing in that house, dwelling house, my lord. It was not recognized or not exempted for the either.
Any agricultural laborer
Sir.
having a house on any area which is not inhabited belonging to a Thanda can be declared and vested in the state government for consideration of the claims of the agricultural laborer. This is the purpose of 38 ಏನಲ್ಲಿ. ಇದರಲ್ಲಿ ಯಾರು agricultural laborer ಯಾರು? Who is the agricultural laborer who has made this claim?
Yeah, declare state government now notified, my lord, ಅದು Thanda ಏನೋ recognize ಮಾಡಿದ್ದಾರೆ revenue collection ಸಲುವಾಗಿ ಸ್ವಾಮಿ. So now it is declared as a Krishna Nagar, Krishnapur Thanda ಅಂತ. Earlier it is English Thanda ಅಂತ ಬರುತ್ತೆ. ಈಗ ಅದು ಈ ಲ್ಯಾಂಡ್ಸ್ ಗಳನ್ನ ಗೌರ್ಮೆಂಟ್ ಅಂತ ತಗೊಂಡಿದ್ದಾರೆ. That is petitioner lands also. It is absolute land of the petitioner and their family members were residing in it.
You file a civil suit, where is the question of going into this in repetition?
Lord, it now notified the said land, my lord.
Correct appa, but
Civil suit ಹಾಕಿ ಡಿಗ್ರಿ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಗೌರ್ಮೆಂಟ್ ಮೇಲೆ ಹಾಕೋಬೇಕಲ್ಲ. ಗೌರ್ಮೆಂಟ್ ಮೇಲೆ ಫೈಲ್ ಮಾಡಬೇಕು. See, this is a village which is not assessed to revenue. This is a village which is not assessed to revenue because it was not habited. ಜನಗಳು ವಾಸ ಮಾಡ್ತಿರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿ it is not assessed to revenue. No, the government has taken it over. So if you say that this belongs to you, you have to file a civil suit against the government. How can we go into the question whether this is habited, inhabited, whether you are the owner of this property? How can we go into all those questions? How can we go into all those questions?
There is a civil suit, my lord, it was decreed in my favor and final decree proceeding also is pending and the revenue authorities also, we made a representation, my lord. And the revenue record also disclosed that, my lord, it is belong to land of the petitioner, my lord, petitioner family.
Read the annexure F.
Please, my lord. ಈ ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಉಲ್ಲೇಖಿತ ವಿನಂತಿ ತಕರಾರು ಅರ್ಜಿಯಲ್ಲಿ ನಮ್ಮ ತಂದೆಯವರು ವಿಷಯದಲ್ಲಿರುವ ಸರ್ವೆ ನಂಬರ್ಗಳಲ್ಲಿ ಕಟ್ಟಲ್ಪಟ್ಟಿರುವ ಇಂಗ್ಲೇಶ್ವರ ಗ್ರಾಮ ತಾಂಡ 1 ಕಂದಾಯ ಗ್ರಾಮ ಮಾಡಿರುವ ಕಾರಣ
ಕಂದಾಯ ಗ್ರಾಮ ಮಾಡದಿರಲು
ಕಾರಣ ಸಮೇತವಾಗಿ ವಿವರವಾಗಿ ಬರೆದು ತಮಗೆ ಸಲ್ಲಿಸುತ್ತಾರೆ. ಸರ್ವೆ ನಂಬರ್ 160 ಕ್ಷೇತ್ರ 3 ಎಕರೆ 28 ಗುಂಟೆ ಹಾಗೂ ಸರ್ವೆ ನಂಬರ್ 161 1 ಎಕರೆ 22 ಒಟ್ಟು 5 ಎಕರೆ 1 ಗುಂಟೆ ಜಮೀನನ್ನು ನಮ್ಮ ಅಜ್ಜ ಖೇಮು ಉಮಲು ಲಮಾಣಿ ಹಾಗೂ ಅವರ ಮೂರು ಜನಗಳಾದ ಲಿಂಬು ಬುದ್ದು ಲಮಾಣಿ, ಲಾಲು ಠೇಕು ಲಮಾಣಿ, ಲಚುಮು ಢೇಂಗ್ರು ಲಮಾಣಿ
Why to conduct a spot inspection to find out?
Yes, my lord. Already houses are constructed in that place.
But if that is the case, then
They have sold, my lord. It has not sold by us in Inter-alia.
it is not sold by you. Somebody else is in possession is what they are claiming.
Yes.
Verify ಮಾಡಿ. ಯಾರು ತಹಸೀಲ್ದಾರ್ ಮಾಡದ ಹಿಂಗೆ?
On the recommendation of the Assistant Commissioner, my lord.
The learned AG is directed to, the respondent number 2 is directed to visit survey number 1160 and 1161 of Krishnapura, Paswana Bagewadi Taluka, to verify whether the petitioner herein has constructed any houses on the aforesaid survey numbers and submit a report to this court, where the inspection shall be done on
4/5, my lord, any day.
on
First-
5th of February, 2025 at 11 AM. It is open for the petitioner to be present on the said day. Yes.
Signed submission. In 49th matter, my lord, it is claimant who has appealed, not the state. State has not preferred appeal. Claimant agreed by non-payment of compensation in respect to some strip of 8 feet, my lord. It has challenged in appeal, but state has not preferred appeal.
No, ಬಂದ್ ಹೇಳಿ ಅವ್ರು. This is regarding that,
Acquisition,
Land
that is
acquisition.
National Highway. Ravi Patil judgment is squarely covered by that. I'll produce the judgment next. date, my lord.
ಬರ್ಲಿ ನೋಡೋಣ. ಯಾರು, who has filed the appeal?
The claimants, Ravi Patil's clients, in whose favor compensation is granted, in respect of non-payment of compensation in respect of some
Who
cartway.
has filed the appeal? Writ appeal.
Claimant has filed, the petitioner has filed the appeal.
Petitioner succeeded in the writ
Who
petition. Yes, next.
Please, next.
CS Patil. Jagashetty.
Adjournments, they have taken adjournment.
Yes.
Petitioner taken adjournment in the morning.
ಯಾವುದು?
53.
ಆಯ್ತು, 54.
54. In this matter, man, senior counsel Ashok Harnadi is appearing, man. He is on the line.
ಯಾರು?
Ashok Harnadi
ಹಾ,
appearing on behalf of the petitioner.
yes.
Your architect kindly pass over my, I will contact.
4:32 ಆಯ್ತು, ಪಾಸ್ವರ್ಡ್ ಇಲ್ಲ. The learned counsel for the petitioner seeks time list on it.
May I request that in the meanwhile, my lords, the papers of disposed writ petition will be put up along with this.
ಯಾವುದು? Office is directed to put up the records in WP number
201-801,
201-801 of
80 of 2017.
2017. Yes, list on date.
28, next, first week of February.
ಯಾವತ್ ಬೇಕಾದ್ರೆ ತಗೋ.
February, first week.
Any date.
4. Please.
Mahantesh Patil. This is already. Yes.
Lords, there was a direction to the government to place it, lords, the records from the concerned departments regarding the twenty-four, 7/20. 24, 7/20.
Crematorium.
These are the lords, petitioners or owners of surrounded lands. When this particular land was selected, lords, they have specifically
yeah,
objected.
How a park, this was identified as a park.
How? This town planning authority, master plan. Because the entire area was lords, reserved for park. The reason is that lords, there is a stream flowing in the village, in the city. The lands attached to the lords, this stream has been lords reserved for parks.
ಎಲ್ಲಿದೆ ಪ್ಲಾನ್ ಇದು CDP ನೋ RMP ನೋ ಎಲ್ಲಿದೆ?
Annexure B 25.
Annexure
B 25. May I give lords bigger version?
How, which is this lake?
Mark. Stream lords, Sindhanur Nala ante.
Sindhanur Nala ಅಂತಿದೆ.
ಅದರ ಮೇಲೆ ಇರೋ ಸರ್ವೆ ನಂಬರ್ 32, 31, 33, 34.
ಕಾಣದೇ ಇಲ್ಲ ಇದು.
ಇದು ಆ ಪೋರ್ಷನ್
Thirty?
32, 33 above the Nala.
32, 33. ಆಮೇಲೆ
ಅದಷ್ಟೇ 33/2/1 lords was selected. 33 /1/3.
Anyway, it's part of 33 only.
33. The other, the owners of lots 33 and surrounding 32 and other owners, they have objected because that is the only survey number which they have chosen and went for a survey for Panchanama. Then these surrounding landowners who are also residing in their in the huts, they have objected for that. In the report of the
Whether this RMP is approved by the state government? Approve ಆಗಿದೆಯಾ?
Not sure, but my instructions are that lords, it is approved. I will verify that. But because my instructions are that it is approved.
And government has
Verify
filed the
also.
objection to that, my lord. The report has been there.
Filed objections.
ಅಲ್ಲ, whether objections consider ಮಾಡಿ approve ಆಗಿದೆಯಾ ಅಂತ ಕೇಳಿದ್ದು.
Okay, the deputy commissioner is the authority to identify it and it has been done.
Sir, RMP ಮುಂದೆ it has to be approved by the state government. Section 4 ಅಲ್ಲಿ it has to be approved by the state government. This is only a proposed map.
Proposed map, my lords, thereafter it
map
has been
approve ಆಗಿದೆಯಲ್ಲ.
approved and-
ಈ map approve ಆಗಿದೆಯಲ್ಲ ಅಂತ that.
And objections also not served to me.
ಅಲ್ಲ, but was,
Where it is
it
filed
was
on-
in the last occasion when argued, the issue was raised, my lord, what is his locus standi to challenge it, that was.
ಅಲ್ಲ, but if it's a park, reserved as a park in the RMP, it can't be used for any other purpose. Can't be used for even crematorium, even if it's a civic community. It can't be used for civic community.
ಅಲ್ಲ, it is whether this plan is approved or not.
Then ಅದನ್ನ ನೀವ್ ಹೇಳ್ಬೇಕು. We should obtain information whether it is approved or not.
And my land has been taken, I am appearing for the owner of the land which has been sold to the government, sale deed has been executed in 23.
For the purpose of crematorium.
ಅಲ್ಲ, ಅದಕ್ಕಂತೂ ಅಲ್ಲಿ ಹೇಳಿ, yes, for that
Crematorium.
only.
ಹೌದು, crematorium.
I have brought the, it is sold on,
Anyway, then you don't. have
Allah,
to pay.
Allah, 13/3/2023.
No, if the government has purchased it, that's okay. So you don't have anything to say in this matter.
ಇಲ್ಲ ನನ್ಗೇನಿಲ್ಲ, ನಂದು ಉಳಿದ ದುಡ್ಡು ಅರ್ಧ ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದಾರೆ, ರಿಮೈನಿಂಗ್ ಅಮೌಂಟ್ ಇಸ್ ಪೇಡ್ ಟು ಮೀ.
ಅದು ನೀವು-
Whether they use it for
ಅದು-
garden or any other purpose, it is
Your petition you cannot,
not.
ಇವರ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ನಿಮ್ಮ ಬೇಳೆಕಾಳನ್ನ ಬೇಯಿಸ್ಕೊಳಕ್ಕಾಗಲ್ಲ.
ಇಲ್ಲ, because my land has already been, my lord, I have executed the sale deed, they have taken it. So my issue is only, my lord, whether they use it for the.
You file a
future
separate
for-
petition that if you want.
Lord,
You file a separate petition against the government if you
ಅಲ್ಲ
want.
ಈಗ ನಂದು ಅದನ್ನೇ ಚಾಲೆಂಜ್ ಮಾಡ್ಯಾರ, which has been in my favor. They have challenged that only.
Sale deed.
ಹೌದು.
Sale deed
ಅಲ್ಲ,
is-
all
Sale deed ಅಲ್ಲ, usage of the land.
ಅಲ್ಲ,
Usage
usage
of
of
the
land, if it is.
Usage of the land, I have.
They're not challenging the sale deed.
Sale deed, I can't challenge.
He cannot challenge. What is his right to challenge the sale deed? Yes, government. Who is the
ಅಲ್ಲ,
answer?
this is in, this sale deed is in pursuant to the proceedings of the deputy commissioner. They have challenged the deputy commissioner's decision and the rate fixed for that land also.
They cannot challenge it, Mr. Annexure G.
Yes, my lord. Annexure G, the rate, my lord, G is page 41. Next page is that is the rate fixed. This is my land. Usage they can do it, my lord. It's.
How can you challenge the proceedings relating to sale and?
What has happened is, the reason is that what, the land itself is particularly, this land has been selected directly, and when they went for surveying the land, for this land, by the revenue inspectors, we came to know, then we filed the objections for then itself. We raised the specific objections in the report itself that has been challenged.
What is to challenge the sale?
Well, sale, my lords, what my submission is, if there is a, my lords, for selecting the land for burial ground, there are some guidelines by the government.
Forget it. The government has purchased it for whatever reason. It might use it for a park, it might use it for some other purpose. You are only concerned with the usage. In the RMP.
Now they are using it for, my lords, this land is purchased particularly for using it as a crematorium.
So therefore you cannot challenge the sale.
Not sale I can't challenge, but the selection which they have made, the land which was selected, that is I am challenging.
That is okay, you can challenge that. But Annexure G, you know.
Annexure G, that is the further
Odi.
proceedings in pursuant of my objections and all other things, my lords.
ಓದಿ ಏನು Annexure G ಏನು?
Annexure G and H.
ರುದ್ರ ಭೂಮಿಗಾಗಿ ಖರೀದಿಸುವ ಬಗ್ಗೆ.
ಮೇಲೇನಿದೆ ಸ್ವಾಮಿ ವಿಷಯ. ರಾಯಚೂರು ಜಿಲ್ಲೆಯ ಸಿಂಧನೂರು ತಾಲೂಕಿನ ಸಿಂಧನೂರು ಪಟ್ಟಣದ ಸರ್ವೆ ನಂಬರ್ 32/1/3 ವಿಸ್ತೀರ್ಣ 1 ಎಕರೆ 10 ಗುಂಟೆ ಜಮೀನನ್ನು ಸಾರ್ವಜನಿಕ ರುದ್ರಭೂಮಿಗಾಗಿ ಖರೀದಿಸುವ ಬಗ್ಗೆ. Based on this, my lords, the land which they have selected, when they went for survey, my lords, whether it is suitable or not, then we made objections, my lords. Neither my objections were considered nor disposed of.
Yes.
Directly this land has been approved. And
You are not concerned about the purchase.
the usage itself is for
Concerned about the usage. To that extent will interfere.
usage, my lords, I am challenging it.
So proceedings leading up to the sale of the property by this man in favor of the government, that you cannot challenge. Usage of the property you can challenge.
Usage of the property, I am challenging it.
The
But the way proceedings were taken place and the land was selected,
ಅದು ಸಾವಿರ ಇರ್ಲಿ ಕಣ್ರಿ.
how?
Let there be anything.
What is usage, if they are changing, my lord, then we don't have any problem.
Only usage you
Allah, I agree, my lord. I understood the issue. But the issue is that, my lords, because these proceedings were initiated and started for selection of land for the crematorium.
My lord, I will verify 2021.
Barkoli, whether after hearing the learned counsel for the petitioner,
This is concerned.
after hearing the learned counsel for the petitioner and the learned AGA, it is necessary to ascertain whether the proposed RMP of Sindhanur
Planning Authority.
RMP of Sindhanur planning area is approved by the state government or not. ಯಾವ year ಅದು?
2021.
21. Planning RMP 2021 RMP 2021 for the planning area of Sindhanur is approved by the state government or not? Yes, list on yavat.
On 2 weeks. Oh,
List on date. Yes.
Interior model.
Interim order earlier granted is extended till the next date.
ಅಲ್ಲ, ಇದಕ್ಕೆ
However, this will
ಸಂಬಂಧಪಟ್ಟ-
not come in the way of the respondents 1, 2, 3, releasing the remaining consideration payable to the respondent number 4. Yes. Venkatesh Mallabadi.
Here for the petition.
Mohammed Usman Chondi.
Not, petitioner, my lord, is owner in possession of the 1 acre 3 guntas of land survey number 60/1.
Petitioner is the owner of
Land survey number 60/1, my lord.
60/1.
Originally 3 acre 2 guntas, out of which, my lord, 2 acres is sold. And what is remaining with the petitioner is 1 acre 3 guntas.
2 guntas.
Sorry, 2 guntas.
Ah.
Yes, no. Now, the present 1 acre is, my lord, converted into NA by the direction order of this honorable court, and thereafter the deputy commissioner, my lord, issued an NA order. A layout is formed and the petitioners are in possession. My lord, and at that point of time, my lord, the respondent number 6, my lord, gets a fabricated and created document in the Khasra. May I just take your lordship to that document? Would be visibly originally, which I have not just, that's a very. Certified copy, the last entry your lordship may see, or Himbararo, I will refer to it. Survey number 1 to 159 ಅಷ್ಟೇ ಇರೋದಲ್ಲಿ ಆ ಊರಲ್ಲಿ ಆ 54 ಅಲ್ಲಿ ಕಾಸರಪಾಣಿ ಮಾಡಿದಾಗ ಎಲ್ಲದರಲ್ಲಿ ಸ್ಪೇಸಿಂಗು ಎಲ್ಲದರಲ್ಲೂ ಹ್ಯಾಂಡ್ ರೈಟಿಂಗು ಇದು ಲಾಸ್ಟ್ ಒಂದು ಇಷ್ಟು ಗ್ಯಾಪ್ ಅಲ್ಲಿ ಈ ಮೆಲಾಡ್ ಗೆಟ್ಸ್ ಇಸ್ with the in the original Khasra, he makes an entry of his name. The last portion, the translated version, I have filed it along with my petition.
61 ಮಧ್ಯ ಬಂದಿದ್ಯಾ?
ಇಲ್ಲ ತೆಳಗಡೆ ಲಾಸ್ಟ್ 60 ಅಂತ ಇದೆ. ಲಾಸ್ಟ್ the last entry
61 ಅಂತ ಇದೆಯಲ್ಲ.
61 ಇಲ್ಲೇ ಇಲ್ಲ ಅಂತ ಅಲ್ಲ ಆಮೇಲೆ ಮುಂದೆ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಅದಕ್ಕೂ ಹಿಂಬರ ಕೊಡ್ತಾರ 61 ಅಂತ ಇಲ್ಲೇ ಇಲ್ಲ ಅಂತ. Now, based on this, my lord Khasra, he now, my lord, tries to interfere and also, my lord, gets ಆ ಪೀರಿಯಡ್ ಅಲ್ಲಿ 82, 83 ಅಲ್ಲಿ ಹ್ಯಾಂಡ್ ರಿಟರ್ನ್ ಟು ಇದು ಮಾಡಿದಾಗ 2 ಪಾಣಿಯಲ್ಲಿ he makes his hand written entry. That pani also, my lord, when verified its endorsement issued, it is not issued by the office of Tahsildar. My lord, I file an application to inquire into the correction illegality in the Khasra entry made and take action accordingly to the offices respondent concerned. The respondent does not consider my requisition. I make another reminder requisition. At that point of time, my lord, the annexure K, the office of deputy commissioner, my lord, considers it as an revision, and my lord passes an order that since it is of the year, page 46, the operative portion, ಮುಂಚೆ ಎಲ್ಲ ಬರೀ ಇದೆ ಹೇಳ್ತಾರೆ, the facts which I have narrated in my representation, last 2 paragraphs is.
What happened to the civil suit?
Civil suit is, my lord, still it is pending. My lord, this inquiry, which is visibly, apparently, my lord, visible with respect to that, my lord, the deputy commissioner, who is the authority, page 35 ali first Simbara, what the issue is, my lord, kindly annexure
Find
here.
out whether there's any tampering of this document, Khasra. Find out if there's any tampering, Mr.
Yes, fine.
Originally, if it is called for, it could be very visibly, my lord, spacing illa, idu illa.
Learned AG is directed to place on record the original Kasra of
My lord, of survey number 60,
survey number 60 of
uh, Gullar Haveli, Bidar.
Gullar Haveli, village, Bidar, Dakshina, Hubli, Bidar Taluk. List on yavat? Fourth.
Hello. Another connected matter. It is on another matter is, I will give
List this
number.
petition along with WP number so and so, list on date. Yes, Mali Patil.
My lord, this matter, my lord, kindly it may be taken next week, my lord.
Joint counsel for the petition seeks time list on
Matter is there, my interim order may be exchanged.
all other cases, some other.
The interim order is there, my lord, interim order exchange.
My lord.
Interim order is extended to the next state of you.
Serial number 73, my lord.
Matter
that the work is transferred to other villages. Kindly, the interim order is there, my lord. Not to work is transferred to other village, my lord.
Not to work,
To other village, my lord. Already estimated work is at Damla Naik Thanda of the petitioner village.
I
It
didn't
is now the
understand.
file the application for transfer to the other villages, my lord. May kindly be directed to other side. So interim.
ಏನ್ ಬೇಕು ಹೇಳಿ?
ಸರ್ ಅದು ವರ್ಕ್ ಇದ್ದಿದ್ದು ಬೇರೆ ಕಡೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಈಗ ಅದು ವರ್ಕ್ ಅಲ್ಲೇ ಕಂಟಿನ್ಯೂ ಆಗ್ಬೇಕಂತ ದಟ್ ಇಸ್ ದ ಪಿಟಿಷನರ್ಸ್ ಪ್ರೇಯರ್.
So what do you want me to do?
Not to transfer the work to other villages, my lord. Already which is
My lord, I will secure instruction. It may be taken on
Take
4.
whichever date you want.
27th, my lord, 27th.
Yes.
Education matter, may I move it tomorrow, minutes objection, sir. Yesterday I had moved it because of objections, it was not posted. Wait.
Not tomorrow, this, my lord. ಅಲ್ಲಿದೆ ನೋಡಿ. There's a display there.
Serial number 62, my lord.
No, all these matters will be listed as per the classification made. ಯಾವತ್ತು ಬರುತ್ತೋ ನೋಡ್ಕೊಳ್ಳಿ, ಯಾವತ್ತು ಬೇಕೋ ನೀವು ತಗೊಳ್ಳಿ. As per that list. 28 ಬರುತ್ತೆ. ನೋಡ್ರಿ ಯಾವತ್ತು ಕೊಡ್ರಿ.
That serial number 60 ಅಲ್ಲಿ interim order ಇದೆ, kindly.
Interim order will be extended, Mr.
Yes, sorry.
62 date may be given. 62, my lord, serial number 60.
The date will be given, Mr.
Yes.
68 again instruction on
68. ಇದರಕ್ಕಿಲ್ಲ
ನಿಮ್ಗೆ ಹೇಳಿದ್ರು KGA to secure instruction. Sir, one by one ಕರ್ಬಿಟ್ಟು.
ಅದನ್ನ 28 ಕೊಡ್ರಿ.
Court of sir 62 date ಕೊಡ್ರಿ. $62 date ಕೊಡ್ರಿ sir. Court of sir.
Sir, 62 next week on date ಕೊಟ್ರಿ sir. What up, sir? ಸಿಕ್ಸ್ಟಿ ಟು ಯಾವ ಡೇಟ್ ಕೊಟ್ರಿ ಸರ್?
ಹೇಳ್ರಿ ಮೇಡಮ್ 65 ಯಾವ ಡೇಟ್ ಕೊಟ್ರಿ? 28/1.
Sir, what happened to item 59, sir?
Huh?
59, what happened, sir? Item
27/1.
27. Okay.